All right, the next case is Roman Lesky. Is there an interpreter? No? Okay, we're
Your
waiting.
Honor, good morning. Good morning.
What do I have here? Oh, we do have an interpreter.
Of course, Your Honor. I've been here all along.
Are you a
Nobody
Ukrainian
noticed, but I'm here.
Are
Your
you
Honor,
or Russian?
this defendant needs a
Russian?
Ukrainian interpreter, I think.
A Russian interpreter.
A Ukrainian.
All right.
Yes.
Okay, do you?
Has that been requested?
Yes, it's been on the chart.
Okay, let me write a little note here to my supervisor and let them know, okay? But the
Okay.
Spanish interpreter is here when needed, Your Honor.
And that's why I asked if you spoke Ukrainian or Russian, because that's what we need for him. But please, let me know when it's ready on that one, because that's noted on the chart. Okay, so we'll pass on Mr. Levsky.
Judge, we have Ms. Farrell whenever you're ready. The one that we passed.
Here we go. Okay, let me go back. Shelby Farrell on page 1.
Ms. Farrell's present here at TGK.
Pardon me. Okay. Good morning, Ms. Farrell.
Good morning.
I have an out-of-state warrant from the Cartersville, Georgia, where it's alleged that you have pending a violation of probation regarding the possession of cocaine and possession of Schedule 1 drugs. And do you wish to waive extradition so you can go back to Georgia and address these matters, or you wish to contest the sufficiency of the warrant? What do you want to do? The quickest way to go back there is waiving extradition.
I'll do the quickest way.
Okay, so you're waiving extradition. Let me just put in here. And she has no local prior, so she should be on her way shortly. What's the reset date on this? April 11th is, we'll put it on the calendar, make sure that you're gone by that date, okay?
By April 11th?
April 11th, yes.
Okay, thank you.
Good luck, all right? Okay, I have Rodney Bruton on page 4.
Yes, good morning, Your Honor.
Morning, Mr. Bruton. Okay, let me see what I have.
April 10th, we'd like to reschedule for reset for April 11th.
Okay, there's been a waiver here. All right, so what I'm being told, sir, is that your current locals are set for the 10th of April, so they want to reset this for the following day to make sure that you've been moved on. Okay, so let's reset. We're just following the pending cases to make sure you don't sit here any longer than you need to for April 11th in the morning. Okay, good luck to you, sir.
Thank you.
Javier Marino Leyva.
This case is to the county court, county court this morning. You can accept it tomorrow.
Okay, is Mr. Marino Leyva present? I don't see him.
Your Honor, he had court this morning at 8:30, so we need to reset him.
No, Your Honor, you gotta let him in. He's here. We just gotta let him in.
Who's talking? I
It's
can't.
Officer Bloom at Metro West.
He's there?
Yeah, he's here. You gotta let him in so we can accept him. We can make him a panelist.
I'm trying to promote Unit 4. It's under a different name.
Hmm.
They're not accepting.
Okay, so let me move on to the next one. We'll pass this one momentarily. Okay, the next one on the calendar is Alvaro Rufa
Don,
Martinez.
he's present.
Who is present?
It's a different name. Label right here. Javier.
Is that the one?
The one we just passed.
Oh, the one-
Javier Label.
Okay.
Disregard the name. This is Javier Label.
Javier Leyva. Corrections, does Mr. Leyva need the interpreter?
Yes.
Okay, perfect.
Let me take a look at this. Okay, this was
Is misdemeanor set for today?
but this has been waived, right?
He did his misdemeanor today. He closed out his misdemeanor today.
All right. Okay, so what do you want to do on this? Because
Let's
it's,
reset it for tomorrow, Your Honor.
okay. All right, so they're gonna reset for tomorrow to see what occurs today.
Lo van a fijar para mañana.
Thank you. All right, so we'll reset for March 28th in the morning
Va a ser fijado entonces para el día 28 de marzo, en la mañana.
to make sure that that's been closed and we can then make sure that he's on.
Para estar seguro que eso haya sido cerrado, el caso a nivel de delito menor.
Then moving on to Mr. Alvaro Rufa Martinez.
Alvaro Rucha Martinez.
Okay, that's just the quash.
Okay.
Motion to quash warrant, which I am signing. And then Eugene Witherspoon,
NBC, Your Honor.
what's going on with this one?
April 7th, election be set for April 8th.
Okay, my understanding is these locals are scheduled for April 7th, so I'm gonna print this out, reset April 8th in the morning, okay? All right, which one did you?
I'm sorry, excuse me, for Witherspoon, I have on the card that Judge Alfield gave him an ROR on his local case as well as the case from Georgia, and that we haven't received a court order.
You're saying Judge Altfield gave him what on this out of state?
According to the card, they gave him an ROR on both his local case and the case from Georgia, but we haven't received the court order.
Judge Altfield cannot do that, Your Honor.
Okay, I don't know where it is. In other words, I don't know, no, the dots have to be connected and they haven't been, so unless there's confirmation by way of a court order, I'm resetting this for April 8th at in the morning, okay? You can always put it back on the calendar if there's something to the contrary. Okay, so we passed the only one that we are still missing.
We have counsel for Roman Leskiv needs to be promoted.
Okay,
His name is James Cusack.
see where Mr. Lefsky's at. Here we go, on bottom of page 3. His name is what?
James Cusack.
You see him?
I see him in the chat.
Pardon me? Yes.
I don't see him on the attendee list.
Okay. Let's see here. And do we have an intro?
He's a panelist. He just has to turn on his camera and unmute.
Mr. Cusack, you've been promoted. Please turn on your camera and unmute.
We still don't have an interpreter, so.
I'm not sure the other Ukrainian co-defendant, his counsel spoke Ukrainian. I'm not sure if James Cusack does.
Okay.
But
The interpreter present, please type in the chat that you're here to interpret.
Interpret Russian or Ukrainian. Okay, good morning. Mr. Cusack, who do you represent, sir?
Roman Leskiv.
Okay, do you speak either Russian or Ukrainian?
No, but I just wanted to advise the court that he closed his local case and he signed a waiver back on December 6th before I represented him. I took over in the substantive case and was just received notice yesterday that this was on for an extradition hearing.
Okay, well, we're waiting for an interpreter so that he understands what's going on and clearly.
Well, he does. I mean, I spoke with him yesterday in court. I can assure the court that he understands because he filed the waiver back in December.
Right, I know, it's been rolled over to accommodate and make sure that his locals are closed, and are they now? He was
They are
okay.
closed.
Okay, so
Your Honor, I'm seeing on the calendar that he was sentenced to 120 days, so we need to know from corrections his sentence expiration date in order to advise that the Texas.
Yes.
It expired already and he has a hold for immigration also.
Also, he has an ICE hold?
That's
Okay.
correct.
So let's verify by corrections, he's ready to go.
So just, they're seeking confirmation from corrections that he is ready to go, correct?
The sentence expired already, Your Honor.
Sentence expired, okay?
You can reset for April 11th beyond.
The request is being made to reset this for April 11th to make sure that he has been moved on. And I have a note here that there's a nice hold, okay?
Very well. Thanks so much, Your Honor.
Thank you so much, sir.
Take care. Have a nice day.
Likewise. Okay, let me just sign here. All right, now we're gonna move on to the in-state.
Thank you, Your Honor.
Yeah. And somebody needs to let Mr. Letsky know, I don't know how.
I think he speaks enough English. You want to ask him if he understands?
Mr. Letsky?
He left already.
Do you understand what happened? Your case is taken care of?
Yes. I wait to extradition to Texas, yes?
And we're gonna monitor it and put you on the calendar on April 11th to make sure that you're gone, okay?
Okay, thank you.
All right, good luck, sir.
Thank
Okay.
you.
In state, the first person that we have is Julio Jimenez.
He's on Zoom, Metro West 5.
Good morning. Good morning.
Good morning, Julio Jimenez.
English?
Yes, I do.
Okay, all right, sir, you have a warrant out of, it looks like Broward County. And it looks like it's for the offenses of grand theft, retail.
Mhm.
There is no bond on that. Okay, what are we doing on these?
Reset 15 days to see if they post the bond or get picked up.
Listen, I finished my case here in Lake County. And January 23, they dropped my charges. I've been sitting here waiting for extradition and they have not do nothing.
Okay, but you're gonna be going to Broward County to arrest the one over there unless it resolves. What's the reset date on the in-state? April 11th.
Corrections, when did he close his local case or be released on his local?
According to the card, January 23rd, it was no action.
So, January 23rd? Do we know
Yes.
why it's been 2 months then? Then
Why is
he's
it
been
this-
placed on calendar?
Never placed on calendar. I don't know why.
Judge, we'd ask that Mr. Jimenez be released. He's been sitting around for 2 months, held illegally by the Department of Corrections.
I have
He
no,
hasn't been transferred to Broward County.
not have confirmation of that. All I have is,
Corrections just indicated, Judge, that his local case was closed January 23rd. I believe that's a confirmation, Judge.
okay, who was he represented by in the other case? I have no idea. I don't have any of this information in front of me. The only thing I'm being told is he has nothing pending and he needs to be moved on and there's 15 days to do it. And I'm gonna pass this if you can give me information. Who represented him on the underlying case? And what was that underlying case?
I'm looking now, Judge, one moment.
Judge, and I'm okay with shortening the time till Thursday. So hopefully he got picked up by then and corrections try and get him on the list for next week.
Yes.
I mean, he must have been represented by counsel. So this just, something.
Judge, he was represented by counsel. The case was no action. That case was resolved. And then he was released on that matter. Then he was continuing to be held by the Department of Corrections without ever being placed on calendar, Your Honor. And this is a function of the Department of Corrections.
Who was his attorney on
His
the other?
attorney was Miss Boucher.
Private lawyer?
No, Judge, with the Public Defender's Office.
So the public defender. Okay.
Yes, Judge, it's not the Public Defender's Office responsibility to place someone on the calendar. It's the Department of Corrections responsibility. The Department of Corrections has held Mr. Jimenez for over 2 months without ever placing them on the in-state warrant calendar. Has Broward County Sheriff's Office ever been notified, Corrections, and that Mr. Jimenez was ready for pickup?
Calendar, we're gonna leave this, give me Thursday's date, what week from today?
Thursday's the 3rd.
April 3rd, and I will pass it until the end of the calendar. We can readdress this, but I'm not gonna hold up this calendar for this argument. So April 3rd, And then we can even give, I'd like to see all the other paperwork on this case. Who?
The last one on the calendar.
Of where?
Oh, corrections needs.
Oh, corrections
Yes,
needs,
no,
it?
we draw.
Okay. Well, I don't have the calendar. Is that the calendar? All right, I'm being told that a case needs to be called out of turn on the main calendar, and that is Dahari, per the request of corrections. Dahari Duhaney? Okay, last one on the calendar, page 20. And these are added charges. Do we have Duhaney? Is this Mr. Duhaney?
This is Mr. Delaney.
All right, but what's happening is, there's an added charge on this case of battery by a detainee. Is he represented by the public defender's office?
Judge, are you appointing our office at this time?
Well, this is an added charge to an existing case. So does he have an attorney on the existing case?
Yeah.
Who was your attorney?
Miss Colleen something.
Is that private lawyer?
No, it's a public defender.
So the public defender, can anybody verify this?
Judge, I have no problem with the public defender being appointed. He's in custody.
Yeah, I was already in custody. I just had court yesterday.
Yes, Judge, our office represents him on a violation of probation.
Right. Okay, so the added charge, it is claimed that he committed the offense of battery by a detainee on visitor or other detainee on March 26th at TGK. Okay.
Requesting a $2,500 bond, and Miss Corey, the victim's name is Liban Guerra Prado.
All right. Finding probable cause. PD appointed, $2,500 bond. All right. Good luck to you, sir. All right. Back on the in-state warrants. The second case is Oscar Contreras Perez.
He has a hold for immigration and a hold for the U.S. Marshal.
Spanish interpreter, please.
All right. Is this Mr. Contreras? Yes?
Yes.
Okay. Contreras, I've appointed the public defender's office. It looks like, actually, this is an in-state. No appointment. Okay, I just want to let you know, sir, that you have a warrant out of Broward County. And the allegations are grand theft. Doesn't really tell me much, and no bond. Okay. Reset this date is what? April 11th? Silence. Okay. I guess it's April 11th.
If we can have the interpreter translate, please.
I thought
Do we have an interpreter?
we should. We had one before. Madam Interpreter? Where's the interpreter? I
don't see her anymore.
I don't see the interpreter here. We had one. Nope.
Just can we pass him for a few moments until the Spanish interpreter arrives?
Sure.
Thank you.
Moving right along. Anton Pinder. Where's Mr. Pinder?
Mr. Pinder is present.
Okay, Mr. Pinder, good morning, sir. My understanding is you have a warrant out of Broward County. Allegations are that you committed offenses of aggravated battery with a deadly weapon, domestic battery by strangulation, no bond. Okay, so. That's April 11th. To make sure that you've been transported to Broward County. Good luck, sir. Elisier Bencomo. Bencomo? Mr. Bencomo, do you speak English?
Spanish.
Spanish, all right, we don't have an interpreter, so this one will have to pass as well. Okay, next one is, Elvis Ferreira. Mr. Ferreira, do you speak English? He's right on the monitor. You speak English? Okay, good morning, sir. You have an in-state warrant from.
Good morning, Your Honor. He's gonna need the assist of the interpreter.
Who? He just told me he spoke English. Mr. Ferreira, you don't speak English? I can't hear you.
Are you saying Ferreira or Bencomo?
No, we passed the other one. We passed,
Okay. I apologize, Your Honor.
Mr. Jimenez.
You should be in pretrial.
Yeah.
Which one?
Mr. Ferreira.
Okay, Mr. Ferreira, can you hear us?
Yes, I hear you.
Okay, good morning, sir. You have a fugitive warrant from Palm Beach County, and it says it's for the, let me see here. It's a VOP, violation of probation regarding a battery. And it says no bond, okay? I don't know. You said something was query about pretrial?
He's in
That's where he's
Juvenile
located.
Detention Center. That's where he's located. So he's on Zoom, Judge.
Oh, no, I see him. I see him. Okay. So I'm gonna reset this for April 11th, so he can be moved on to Palm Beach. Good luck to you, sir.
Thank you.
That-
Can I waive extradition?
No, you don't need to. You're going to Palm Beach. It's an in-state. Okay. We just want to monitor to make sure you move on as quickly as possible. Okay?
All right, thank you.
Good luck. David Tavar Ortiz. I think
He
it's-
has a hold for immigration.
Okay. And where is Mr. Ortiz? Is he on? Oh, here he is. Is that him? Okay.
Metro was 6. Do you need an interpreter?
Yes,
Okay. You don't speak English.
I speak in English. I speak Spanish.
Okay. All right. We have to pass on the interpreter on that one as well. Okay. Let's see. I think that's it. So we have 3 holding interpreters.
Interpreter present, Your Honor.
Interpreters present. Okay. I think the first one is Oscar Contreras Perez.
En el caso de Oscar Contreras Pérez,
I think we reset this. We did this already. Yeah. Okay. The other one is,
He's present.
Como-
Speak Spanish.
yes, this is one. Okay. This is Mr. Contreras.
¿es usted, señor Contreras?
Okay. All right, Mr.
Yes.
Contreras, you have a warrant out of Broward County, sir. Where,
Señor
go ahead.
Contreras, usted tiene una orden de aprehensión del condado de Broward.
Okay, and the allegations are it's for the offenses of grand theft, and there's no bond on that, sir.
Se alega, delegadamente se le acusa a usted de un robo mayor y no tenemos fianza para usted, señor.
So I'm going to set this for April 11th, which is within 15 days, to make sure that you've been moved on.
Voy a agendar esto entonces para el 11 de abril, de aquí a 15 días, para asegurarnos que usted entonces ha seguido adelante.
Okay, in other words, transport to Broward to take care of this.
En otras palabras, transportado hacia Broward y encargado ya de este caso.
And you also has a hold for the U.S. Marshals and a hold for immigration.
Just have to put that on here. So there's an immigration one.
También tiene una retención por los alguaciles de Estados Unidos y también de retención de inmigración.
All right, good luck to you, sir.
Buena suerte para usted, señor.
Next case, an interpreter is
¿Puedo hacer
Eli.
una pregunta?
Question,
Yes.
díganos.
Bueno, vendrán a recogerme de Broward en 15 días o no entendí eso.
So they'll come to pick me up from Broward in 15 days or I didn't understand it.
It should be 15 days. It could be quicker.
Hasta 15 días, señor, puede ser antes.
All right.
Ok.
Okay. Elisier. This gentleman he has on the screen. All right, Mr. Bencomo, he also needs an interpreter. You have a warrant out of Flagler.
Señor, tiene usted señor Bencomo, usted tiene una orden de aprehensión de Flagler,
Flagler County.
del
Okay.
condado de Flagler.
And it says that it's for violation of probation, grand theft over $100,000, and it has no bond.
Dice que es por quebrantar su libertad condicional, robo mayor de más de $1,000 y no tiene una fianza fijada.
So this is gonna be reset again. I don't think there's anything pending except this, so this will be reset for April 11th to make
No creo,
sure has been transported.
no creo que tengamos nada pendiente en este caso, así que va a ser reagendado esto para el 11 de abril para asegurarnos de que sea transportado.
Okay, good luck to you.
Buena suerte para usted.
And then I think the last one is David Tabor Ortiz, is that? Yes, okay. Mr.
David.
Ortiz, you have a warrant out of Sarasota County. And it is for, let's see here, your bond is, it looks like failure to appear on a petty theft, something transit, not really certain, but the bond is $5,000 on this.
Your Honor, I have, he also has a hold for immigration.
It has a nice hold, yeah, okay. All right,
Señor Taba Ortiz, usted tiene una orden de retención del condado de Sarasota, fallar en comparecer y por hurto menor. No tenemos una fianza o $1,000 de fianza es en tránsito y también tiene usted una retención de inmigración.
all right, so the bond on the face of the warrant is $5,000, okay? I'm gonna go ahead and reset this and put it for April 11th for the Sarasota County Transport, but it does have a nice hold, okay?
Le ponemos entonces que tenemos aquí que la fianza, pero usted está fijada ya en $5,000 y vamos a reagendar entonces esto para el 11 de abril para asegurarnos del condado de Sarasota lo recoja. También usted tiene una retención de inmigración.
Mr.
Ajá, ya va. Una preguntita. ¿Puedo preguntar?
Can I ask you a question?
Mr. Tovar Ortiz, it is not recommended that you post your bond at this time due to the immigration hold. If you post your bond, then immigration will be notified to come pick you up. You may be sitting in immigration detention and miss your future court date in Sarasota.
Señor, no se recomienda que ponga la fianza usted ahora mismo. Si usted pone la fianza, paga esa fianza, entonces lo sacaría para inmigración, lo retendría, lo cogería, le daría la luz verde a inmigración para que lo recoja y usted estaría sentado esperando en inmigración y tal vez pierda usted su fecha de vistas en Sarasota.
Pero escúchame algo. ¿Puedo preguntar algo?
But listen, can I ask something?
Sure, sir, go ahead.
Sí, señor, díganos.
Yo tuve una corte en estos días y a mí me dieron provecho, me dijeron que ya estaba libre, que nada más estaba esperando migración. No entiendo qué está pasando entonces.
I had a court, this past few days. They told me that everything was set, that I was only waiting for immigration. So I don't know what's going on.
Does anybody know what he's talking about? Because it sounds to me like he.
You know, they added this warrant yesterday, so he probably doesn't know anything about it.
Okay. All right.
Esta retención o esta orden de aprehensión fue añadida ayer, así que posiblemente usted no sepa de esta todavía.
All right. So again, my ruling stands, $5,000 bond set, reset for April 11th, and he does have a nice hold. Good luck to you. All right. The only other thing that, for purposes of this calendar, if you wish to print out Mr. Jimenez, I think that's the one with the issue of the holdover, for future or further argument, you can do that, in this afternoon's calendar. Okay, I'm moving on to the main calendar.
Thank you.
If I might tell Mr. Tabortiz, Your Honor, what you mentioned at the end. Señor Tabortiz, entonces la juez dice que se mantiene el fallo
It's
que
a
dio.
different case, don't worry about
That's a
it.
different one.
Okay.
No, it was Tabortiz. She mentioned something at the end that I wasn't interpreted for him.
That was meant for a different defendant.
For Mr. Jimenez. Okay. All right, Ingrid Albagames.
Spanish interpreter, please.
All right, good morning, Miss Albagames.
Señora Alba Gámez, buenos días. Señora Alba Gámez.
It is alleged, ma'am, that on March 26th, you committed the following offenses in TJ Maxx located at 20505 South Dixie Highway in Cutler Bay.
Señora, se dice, se presume que usted el 26 de marzo en TJ Maxx hizo localizado en el 20505 South Dixie Highway en Cutler Bay.
for attempting to unlawfully use an it looks like anti-theft device and petty theft.
Por presuntamente tratar de usar un dispositivo antirrobo y por hurto menor.
All right, I'm appointing the public defender's office to represent her. I'm going to now be addressing her bond status.
Le voy a asignar a los abogados de oficio para que la represente y voy a entonces a ver su estatus ahora mismo
So
de
Judge,
liberación.
in terms of the charge, she's charged with an enhancement for being an unauthorized alien, but I don't think there's anything in the narrative. So it would just be the F3 rather than the F2.
Right, alien component. Does she have any other holds?
No, Your Honor.
Doesn't have any priors. So I'm not certain what this unauthorized alien provision is. If she doesn't have any other holds.
¿Tiene ella alguna otra retención? No, ella no tiene ninguna retención. Parece que tampoco tiene ningún tipo de historial penal previo. Entonces no sabemos de dónde viene esto de inmigrante no autorizado o esta provisión de esto si no tiene ninguna otra retención.
Judge, I would ask for pretrial services for Ms. Alva Gomez.
The enhancement doesn't coincide with other aspects. So having said that, I'm gonna make a finding of probable cause, okay? With regards to the I guess, misuse of an anti-theft device. I don't see where the enhancement is.
No enhancement, Judge.
Okay, so that,
Without any further information.
so it's 20, so I'm gonna give her pretrial services, alternate bond, 2,500. Okay?
Señora, en el caso usted se encuentra que hay motivos fundados en relación a esto que es el uso inapropiado de un dispositivo antirrobo, suponemos. Le damos entonces liberación bajo servicios previos a juicio y una fianza alternativa de $2,500.
Conditions of her release is that she has to stay away from this TJ Maxx, okay?
Count two.
Y condiciones de su liberación, usted tiene que mantenerse alejada del TJ Maxx.
$1.
$1 en la acusación 2.
Hold on a second. The next case is Yaremis Terrace. And Terrace has 2 cases.
Yes.
Okay.
Ms. Terrace is present. She speaks English.
Good morning, Your Honor.
Good morning. Do you speak English?
Yes, ma'am.
Okay. All right. You have 2 cases before the court. Case number F25-6199. It's alleged that you committed the offense of aggravated assault with a deadly weapon on March 26 in the vicinity of 14468 Southwest 158th Court. Okay. In case number F25-6198, it's alleged that on the same date, March 26, in the vicinity, same address, you committed the offense of possession of a controlled substance, cocaine, suspect cocaine, possession of a controlled substance, blue circle pill, suspect Xanax, okay, and 1 count of possession with intent to use drug paraphernalia, which is a misdemeanor. I've appointed the public defender's office in both of your cases.
Judge, I think it should be an aggravated battery rather than an aggravated assault.
Okay, it's charged. What you're saying is that you think that the court should finding a probable cause as to aggravated battery is what you're saying.
Correct. The allegations are that she stabbed the victim with scissors.
Okay, I haven't read that yet, but the charges on the A form are aggravated assault. Okay. All right, let me just take a look at her priors. And the alleged victim is Richard Torres. Okay. Is she pending trial?
There are 2 open misdemeanors.
Batteries.
One is a battery.
Yep. Except for April 25th. One's a battery. So wait a minute. So these are misdemeanors that she's pending trial on. And while out on what kind of release was she on that she came back with these 2 cases?
I don't know the release on the misdemeanors.
Well, I think that's important. Is she on probation?
I do not believe she's on probation. Her probation was revoked.
Because I see some modifications back in 2022, so it was revoked.
It appears so.
Well, what about, okay. All right. Okay, let's take a look at these A forms.
Judge, on 6199, I'd ask you to find public cause for battery. There's an indication that there's some sort of scissors. Does not indicate a deadly weapon. Doesn't indicate if they're round or sharp edged. The alleged victim refused fire rescue, so there's not appeared to be much of an injury.
I think there's enough for the ag bat.
Can't hear you, Ms. Hess. What did you say?
I believe there's enough for an ag bat. She stabbed the victim with a pair of scissors.
I haven't heard you. Oh, thank you. Okay, on the F-25-6199, again, I haven't heard anything about what her status was on the pending cases. She's got 2 cases that are set for trial. Batteries, one and the other one is possession is drug related, both misdemeanors appears. And then these 2 cases, but not sure the timing. Assuming there's no holds on that in the 6199, I do find probable cause for an aggravated battery. And I'm setting bond at $7,500 with a stay away order. And stay away order as it relates to Richard Torres. And if you're able to post bond or get released, you cannot have any direct or indirect contact either by phone, pager, fax, or third persons, and you must stay at least 500 feet away from the alleged victim, Richard Torres. You understand that? Yes.
Yes.
Which is, and the one ending in 6198, okay. Count 1, 2,500. Count 2, 2,500. Count 3, $500. So total bond is 5,500.
Judge, would you consider any reduction for counts 1 and 2? Miss Terrace is gonna have a hard time being respond.
3, 4 cases in the system.
Yes, Judge, I'm just asking for a reduction.
Respectfully denied. All right, good luck to you, ma'am. Okay, next case is Leticia Lady. Didn't we do that this morning? You did, right? Yes, okay. Esteem Wilson. Wait a minute. We missed Eugenia Muniz.
This Muniz is a bond out?
Stuff. Next case is Esteem Wilson.
Yes, ma'am.
She has an AC no bond.
Okay. All right, in F, there's a no bond hold. In case number F-25-3369. Okay. In this case, Ms. Wilson, it is alleged that on March 26th, in the vicinity of 1264 Southwest 61st Street, you committed the offenses of possession of cocaine, Possession, with intent to use, sell, manufacture cocaine. Possession, it says here, with intent to sell, manufacture, deliver MDMA, controlled substance. One count of renting for purposes of trafficking MDMA. And I think that's it. I'm appointing the public defender's office to represent you. And I'm now going to be taking a look at the arrest affidavit.
So her statement is that she's squatting, she's a squatter at the location. So she's living at a location where they're selling drugs.
Judge, the arrest form indicates.
Not renting is what you're saying. I'm sorry, you were saying, Ms. Corey?
The arrest form indicates there's a vacant room and a northeast bedroom. There's no indication in the arrest form what room or what location Miss Wilson was sleeping. There's also no indication of her personal belongings being found on the premises. I would ask that you find no probable cause for all charges.
But I think it's like a trap house, a house where they sell drugs. She's squatting there. I think there she would be in constructive possession.
Mhm. There's a bunch of people there.
Maybe reduce the bond. I understand it's a constructive possession case.
It's all it says it based on narcotic surveillance. It says here detectives are aware that the occupants, plural, stay within the room and northeast corner responsible for conducting narcotic sales. This is very vague. I'm not comfortable making a finding probable cause. If you want to set it for PC hearing, you can do that.
Okay,
When do you want to set this for?
I can try for this afternoon or tomorrow.
Set for PC hearing tomorrow. And it's 3:20 in the AM. And she does have a hold on the other case. Okay.
Question 10, Leaks in Vega,
What page?
17.
All right, I'm told corrections wishes to call a case out of turn, which is on page 17. And that is Matthew Vega.
Which file that was?
Corrections asked for this to be called out of turn?
Right.
Okay,
It's a direct file.
yes. And I have some, what appears to be some individuals, perhaps family members here. Matthew Vega. Okay, good afternoon. Does Mr. Vega speak English?
Yes, Your Honor. Good morning. Tara Connie, Assistant Public Defender on his behalf. Judge, he's also a child. He's 17 years old and his parent and family members should be in front of Your Honor in courtroom 1-5.
There, I have several individuals, so I'm going to ask one by one who they are. And all right, so let's start to the left and work to the right. Your name, ma'am?
I'm his aunt.
His aunt. Okay. Tiffany, do you have a last name?
Jones.
Jones, thank you. Middle?
Good morning, Your Honor. Oscar Vega, I'm his father.
You're the dad, and you, sir?
Your Honor, good morning. Eddie Vega.
And you are?
I'm his uncle.
Uncle. Okay. All right, so we have, I forgot what your relationship was? Aunt, dad, and uncle.
Yes.
Okay, got it. Okay. All right. Matthew is Mr. Vega. Matthew Vega is before the court because it looks like this is a direct file. There's a couple of things going on here. Okay, so the state of Florida has the option based on charges and age and a couple of other factors to decide to try a minor as an adult. Okay. In this case, there's a lot of documents, so bear with me because I'm going to try and give you the most informed information. There's an arrest affidavit that alleges that Matthew on February 28th of 2025 in the Treasure Isle Care Center, which is located at 1735 North Treasure Drive in North Bay Village, committed the following offenses. It says here 3 counts of arson in the second degree, 3 counts of burglary of an unoccupied conveyance, 1 count of arson in the first degree, and 1 count of burglary of an occupied dwelling. Okay, now, in addition to which, and normally what the court does in these situations, whether they be direct file or just any cases that fall at first appearance, is the court looks at, first of all, appoints. He has the public defender already on the case. I will look at the arrest affidavit, read it to see if there's probable cause for all of the offenses that are charged, and then address the bond status. Okay. In this case, the state of Florida has filed a motion for pretrial detention under Florida statute section 907041. And that would be with regards to, and they can do that if the defendant is charged with either a capital felony, a life felony, or a felony of the first degree, which in this case there is. And they're asking for him to be held no bond on that. So the court has to review the motion, review the affidavit, and then make a decision whether that motion will be granted. If it is granted, that he will be held no bond on that particular. But there's other matters that I'm sure if that is the case, the attorney will explain to you. So having said that, do you wish to make a statement? Is there
Your Honor, only if Ms. Connie
okay. And then
says it's okay for me to.
and that's prudent because everything here is being recorded and it can be used against him. Okay, so anything that the court is governed by, we have guidelines for purposes of bond, and there's arguments that I'm going to hear from both sides and address how this should be handled in accordance with the statutes and factors such as safety to community, et cetera, et cetera. Okay. All right. Okay. So, and this is what he has pending in the adult system. First time. Yeah. I don't know about,
Yes, Judge.
I don't know about the juvenile record, but let me just take a look at this. Okay. All right. So let's move on to the arrest affidavit.
So the allegations are that he set 3 cars on fire as well as somebody's home.
And I have Mr. Lurby. Are you on this case, Mr. Lurby? No. Okay. Because I see an attorney that just showed up.
No, ma'am.
So-
I'm on another one. Thank you.
Okay. You were saying, state.
The allegations are he set 3 cars on fire as well as a home.
Is this a nursing home? This facility?
I believe so. I think I wrote the stay away order wrong. If Your Honor could cross out car.
Okay. Okay, let me hear argument from both sides, please. State.
So Judge, arson is considered a dangerous crime, which is a first-degree felony. Therefore, the state filed a motion for pretrial detention, requesting that the defendant be held without bond pending the pretrial detention hearing in division.
And Judge, may I be heard if the state is finished?
Yes.
And also, just one more thing, the only thing in looking at the A form I didn't see is that interrupting the educational facility. But if you look at the information, it says, I guess, that the fires disrupted Treasure Island Elementary School. But other than that, I think there's PC on everything and the state has filed an information. Counsel, I'm done.
Yes, Judge. So first, as to the burglary of an occupied dwelling, it's not an occupied dwelling. It's in fact unoccupied at the time of the incident. So that's the first probable cause dispute that I'm making. The second is more focused on who Matthew is as a child and as a person. Of course, Your Honor, at this moment is meeting Matthew for the first time. However, he's already been held in the children's jail facility for 22 days, or today will be the 23rd day he's been in custody. He has no prior criminal history. Even in the juvenile division, he hasn't even been arrested before. He's a senior in high school, and he is on track to graduate. I have provided the state, not this particular assistant state attorney, but the state, the supervising division chief in front of Judge Cabarga's division, an entire mitigation packet that's about 90 pages that discusses Matthew's life and the underlying circumstances regarding this incident. I also had Dr. Haji do a risk assessment on Matthew. That was also provided to the division chief yesterday. And unfortunately, the division chief just hasn't had enough time to review to see if they would agree to release or, file this pretrial detention motion. I think it was filed just as a matter of form or as a matter of requirement under the statute. But the doctor did evaluate him and found that he is low risk on all factors, which is imperative to who Matthew is as a 17-year-old child. He has an incredible support system, not just in his family, but also at the school, on his baseball team. He's been playing baseball since he was about 3 years old. His mother and his sister are also on the webinar platform here in support of Matthew. He's able to either be staying with his family, which would be at his house with his mom, his dad, and his sister, or in the alternative, he would be able to reside with Miss Jones and his uncle, who are before Your Honor right now. The other thing is that the underlying circumstances that I've made the state aware of are very mitigating, in my opinion, because he has never been expelled from school, suspended, sent to any sort of expulsion. There have been numerous letters of support that have been provided to the state attorney's office indicating and reflecting Matthew's character as a child. Most importantly, the dean of discipline wrote a letter of support from his school. The assistant principal wrote a letter of support and attesting to his good character and how he's never had any history of any behavioral issues in or outside of the school. And so, Judge, even though you are getting a snapshot of who Matthew is, I think it is very important to note the amount of support that he has. And I do wish his father to speak on his behalf as well, because even though the state filed the motion, the rule does allow the court to release Matthew pending the hearing in front of the division. The subsection A does state that if the court does find probable cause, the person may be detained in custody pending the final hearing on pretrial detention. And so I would ask the court to consider all of this mitigation, given the fact that this is a child who, number one, has never been in jail before, number two, hasn't been in jail in juvenile detention or in adult jail, and has already spent almost a month in custody. And this is someone who has zero signs, according to the expert that I hired, of future risk, future harm, future violence. And I'm asking that the court please consider releasing him to house arrest, total lockdown, until the final pretrial detention hearing.
Okay, do you wish to add anything? It's up to you, sir.
Your Honor, the only thing I want to say is that I have no, can't excuse anything that he's being accused of. My only fear is for his safety where he's at right now. And I truly believe that he's in big danger with.
Well, they segregate them in corrections. They're not with adult inmates.
I understand, Your Honor. The only
Right.
thing I would ask you to consider is what Ms. Connie just mentioned
Mm.
about his prior history. And that he is, this is significantly out of character. And there are reasons. And I just think it's something that would be very important for you to take a look, if possible. I'm really sorry. I'm not,
No.
never been in this circumstance.
No, it's a difficult, the court understands. Okay, so I have a couple of things for the state because I have in front of me an information that appears.
Correct. The case is set for arraignment on Monday.
Filed.
Yes.
Information has been filed, and this information is for the count 1, arson in the first degree, which is a first degree felony, and then counts 2, 3, and 4, arson in the second degree. Then you have 1 count of burglary of an unoccupied dwelling, also a secondary felony. Count 6, burglary of an unoccupied conveyance, which then there's 3 of those counts, which are the vehicles, third degree felonies, and then 1 count of criminal mischief. I believe, it keeps going. Count 10. So there's 1, 2, 3, 4 counts of criminal mischief over $1,000 each, which is each a third degree felony. And then the final one is 1 count of unlawful to interfere or disrupt school campus, school function, etc. And before the state files these, you have a pre-filed conference. You meet with police officers, you meet with witnesses. Am I correct? Because I mean, this is how it normally happens. So we don't have just, an A form, but you now have it in formal information filed.
Correct.
Okay, so the court is being asked to make probable cause as to the counts that are set forth in the, because I'm missing page 2, by the way, of this, and that accounts for several other counts. That's why when you mentioned the count about unlawful interference or disruption with school, I don't see it here because I don't have that page.
So that may have been added during the pre-file. I don't think it's mentioned in the A form. On that 1 count, I'll agree to an ROR or $1. That's.
So what is the court being asked to do, to make findings? Because there's already an information file. And it's just.
Right. So I think the Your Honor needs to. I mean, a PC has already been found in juvenile court and information has been filed. I think that there is probable cause. So if Your Honor would just affirm the PC finding that's been previously made.
Because what I'm getting at is defense counsel has articulated, possible defects in reaching, and with regards to probable cause as to the second degree felony of an.
Correct, Judge. The only thing that counsel. Right. The only thing that counsel raised, Judge, is in the A form, it says it was an occupied dwelling, but it looks like at the pre-file, we corrected it and we filed the information on unoccupied.
Okay, so at this juncture, originally, but for had there not been an information filed, we would be started, but it is already beyond that point, and there's been additional charges filed. All I can go by is what is set forth in the A form, but the document, speaks for itself. This is not easy. It's a difficult situation. However, the state of Florida has the ability to treat a minor as an adult based upon not necessarily previous contacts with the system, but the type of offense that he's alleged to have committed. The A form sets forth a statement that was given to him. Again, that's separate, but it's part of what I'm seeing. So having said that, these are very serious charges, and the court needs to consider among one of the aspects of it, the likelihood of the person, coming back to court, fleeing, et cetera, and I'm paraphrasing, and also the danger to the community. This is extremely, extremely grave in terms of what it's setting forth. So based upon that, I will tell you that, he will have hearings forthcoming, and the information that is mitigating in nature, the defense counsel has artfully explained to the court it's better suited when they go before the division judge. And that doesn't mean that it's going to say, but based upon what I'm seeing, based upon what I'm reading, okay, this case qualifies for the court entering an order granting pretrial detention as to the first-degree felony. So he will be held no bond. Okay, that doesn't mean he cannot go in front of another judge, and you will have that opportunity to readdress this, but I'm granting that. So as far as count one,
that would only apply as to count number one.
that's what I said. So as far as count one, he's being held no bond. Okay.
And Judge, so I just wanted to clarify one thing. The state has to file an information in order to bring a child into adult court. So yes, pre-files may have been done when the case was in juvenile, but I just wanted to clarify that for the court, because I think that's significant that in order to have him tried as an adult, they must file the information. So we could not be here just on the A form.
They can't just abracadabra get an A form. Okay, I mean, that information, they have to go through the procedure of bringing in witnesses, albeit detectives, eyewitnesses. They have to go through a pre-filing conference so that they have the substantive information and testimony to be able to warrant the charging of these kinds of charges against an individual, whether that be a 17-year-old or a 62-year-old. I mean, that is the protocol. So to a certain level, I guess what I'm trying to say is these probable cause arguments have already had their day, okay? But for purposes of this hearing, I think most importantly is, and I can only go by what I have in the A form, okay? So I'm finding the probable cause is accurate as to all charges, and with respect to, counts 2, 3, and 4, these are arson in the second degree. Those are 75. This is like the low end of what I'm going by, but for the non-bondable offenses, $7,500 each. Okay, then you have burglary of an unoccupied conveyance. Okay, which those are third-degree felonies, and those are typically, without force. I'm even going on the without force, even though this is technically, it's $2,500 each. Then you have, again, this changes when you go to the information. Do you want me to make findings as to the charges in the information or charges in the A form? Because again, this is
corrections. It has to be consistent with the jail card. What's on the jail card?
I don't have anything as far as bond on the jail card.
No. So on the jail card, count 1 is first-degree arson.
I have 4 first degree, right, for the first one. Then I have second degree. I have 3 counts. Then I have 4 burglary of an occupied. I'm sorry, 1 burglary on an occupied dwelling and 3 burglary on an occupied conveyance. And I have 4 criminal mischiefs, 1,000 plus, and then the interference with education
information.
So it tracks the information.
Okay, which is what I have been trying to get at, because it's different than a regular first appearance. They've already filed that information. Okay, so we're going to go down through the information. Just to be clear for corrections, count 1 is no bond, count 2, 3, and 4, 7,500. Count 5 is going to be 7,500. Okay, count 6, 7, and 8 are going to be 2,500. Count 9, they're all 9, 10, 11, 12 are third-degree felonies, 2,500 each. Count 13 is $100. Okay, so I've addressed them at the lower end of the scale to the extent that I can. And there's a stay away order. So if he's able to post bond, if the division judge has a hearing and finds otherwise, okay, then any term of his release will require him, okay, to stay away from the following address, which is this Treasure Island Care Center located at 1735 North Treasure Drive, North Miami Village. And I would recommend that any other types of releases would include a GPS monitoring, total lockdown.
And Judge, one thing I did want to clarify as to count one, it's no bond pending the final hearing for pretrial detention.
Absolutely, which is what I tried to explain to the family, okay, that may change. But irrespective, I'm recommending, and again, that may change, that whatever methodology is reached, if it's different from this, to allow him a release, it will include a GPS monitor, total lockdown, okay? Got it?
Thank you.
Okay, I hope I've assisted in you understanding the process. It's good luck.
And Judge, one final request, if we could reset the case for tomorrow in front of the division judge for the actual hearing.
I think it's set to schedule the hearing tomorrow.
I'm told it's automatically there, okay?
Right, Judge. And I mean, the state did file the motion this morning. The division ASAs are already looking at the mitigation. So I would like to have it addressed before the weekend because I do anticipate they would agree with his views.
Being told it's going to print out tomorrow, okay? Okay, good luck to everyone.
Thank you, Your Honor.
I have to sign out. All of these, so leave this because this is, I have to do this, so let's leave it separate, okay? All right, moving on to the calendar. Where were we? Okay, on page 2, Nayelis Perez. Do you speak English?
¿Habla inglés?
Yes.
Yes.
All right, Ms. Perez, you are accused of committing the offense of an aggravated battery on a law enforcement officer and resisting an officer with violence to his person. And this supposedly took place on March 26th in the vicinity of 1805 West 56th Street in Hialeah. Okay, I'm appointing the public defender's office to represent you. Let's take a look at the affirm. Is this the only thing she's got? It looks
Right,
like.
so Judge, no priors. The state has no objection if Your Honor decides to order her to pretrial. It should just be bat, Leo, and resisting without.
Is the victim approved pretrial release on this?
I'll defer to the court. So it looks like they were arresting somebody else and she was grabbing the officer's hand to stop him from arresting the co-defendant.
Judge, I see no prior arrest history for Ms. Perez. She's working and she attends college, Judge.
I'm not doing pretrial.
Judge, they're talking, they're indicating that she touched the officer, Judge.
And unlawful touching, the last time I checked, is a battery. And the alleged victim happens to be a law enforcement officer, which is a battery on a law enforcement officer. I am not going to offer pretrial services. I will.
Then can we see if the officer's okay with it? I don't know if the state could reach out to the officer to see, Judge?
Absolutely. If that's what I asked, is the victim okay with that? They may be, but without that, I'm not going to do that. So a battery on a Leo, I'm making finding PC on that. Setting bond at $5,000 and count 2 is 2,500. So I
I think it should be without.
Pardon me?
There's no indication that she resisted arrest. I'd actually ask you to find no probable cause and release her outright for count 2, Judge.
I think there's enough for resisting without.
When they went to go arrest her, then it doesn't indicate that she resisted. It says she was placed into handcuffs and arrested.
Count 1, 5,000, count 2, RR. Okay. And print it out in the afternoon if you have the information. If you're going to reach out to the law enforcement officer they approved, then pretrial will be okay with alternate bond. Next case is Marilyn Etienne.
You know, we need to take one out of turn. He's on Zoom from Pretrial Detention Center. He's on page 18. His name is Travion Colley.
Page 18.
There are 2 cases.
Marlene, they're going to be here for a while. Okay. Here we go. Thank you. Okay. Well,
These
okay.
are added charges.
Okay, this is Travian McCauley at the bottom of page 18, number 54. Okay. Is this you, Mr. Crowley?
Yes, ma'am.
Okay. All right, let's see here. Added charges. Where is that? He has two cases, from what I understand. Let's see here. Case number F256202. Added charge is armed robbery with a firearm or a deadly weapon. First degree felony punishable by life, and one count of possession of a firearm or weapon or ammunition by a convicted felony, second degree felony. In the other case, F256201, you have also added charge of armed robbery with a firearm or deadly weapon, first degree felony punishable by life, and the same thing, one count of possession of a firearm or weapon or ammunition by a convicted felon, second degree felony. There's also,
I'm getting charged twice.
you have two different cases, sir. Yeah, in different locations. The first one, the 6202, supposedly occurred on March 20th of 2025 in the vicinity of Northwest First Avenue and Northwest 23rd Street. And the alleged victim in that case is a person by the name of Genesis De Soto. In case number ending in 6201, the offense allegedly took place on March 20th of 2025 in the vicinity of Northwest 6th Avenue and 8th Street in Homestead. And the alleged victim in that case is DeMonica Rolled On. So they're two separate instances. The state of Florida, in case number F256201, has filed a motion for pretrial detention, asking you to be held no bond on the first degree felony pursuant to Florida statute 907.041. And I believe that there's the same motion in the 6202 case with respect to the armed robbery. Okay, so let me just take a look at this.
So I have a robbery in Homestead.
You're represented by the public defender's office, is my understanding. My recommendation is, sir, that you not make any comments. Any comments that you make, unless your counsel agrees, is being recorded and can be used against you. Okay?
Mr. Crowley, please don't make any statements or comments. We'll get you a copy of the arrest form so you can review them, okay?
Anything from anyone? Because I'm ready to,
The state filed a motion.
that's all I'm looking for. All right. Actually, there's two victims on one and one on the other. All right. In case number 6201, the court makes a finding of probable cause. As to count one, he's going to be held no bond. The court is entering an order granting the motion for pretrial detention pursuant to Florida statute 907.041. And there's a stay away order that if he's able to postpone at any point in time, his conditions.
He walked out of the room.
Any contact, direct or indirect, with the alleged victim.
Judge, he walked out of the room.
Okay, well, he walked out of the room. I'm going to continue. Is he anywhere near?
I don't know where he is, Judge. I don't know where the officer is. I have no idea. I just see a blank screen.
Okay.
So if Your Honor would just have the state orders make a note to have them read in division.
Make a note, read to be read in division. Both counts, probable cause. Count 1, no bond. Count 2, 7,500 with stay away orders that'll be read into the in division. Okay, granting the motion in both cases. All right, back on the calendar.
Did we have on Zoom?
I'm sorry, Your Honor, for the case number ending in 6202. The first one is no bond, but what about 2 and 3?
Let me see the paperwork again. I thought it was only one count on each. And I read $7,500 on the second count. Let me see. So counts, all right. I misspoke. On 6202, there's 2 counts because there were 2 victims. In that case, there is counts 1 and 2 is no bond. Count 2 is $7,500. Okay. Stay away orders to be read in division. The other A form. I said 7,500. And then in the case number 6201, count 1 is no bond. Count 2 is 7,500.
Okay, Your Honor, so 6202 is no bond, count 1 and 2, and count 3, 7,500, correct? Thank you.
You're welcome. Okay, now you said somebody's being called out of turn. We need to really move this calendar.
Should we have Mr. Valencia? He's on page 17. He's on Zoom.
Good morning, Your Honor. Dan Larrabee on his behalf, standing in this morning for Judd Rosen. Andres was not brought to court yesterday, so it was reset for today, is my understanding.
Well, yesterday, I have a note here that he refused to come to court.
Okay.
That's a different.
Reason couldn't bond out before seeing a judge is they charged him with a 2nd-degree felony. Should be a 3rd. Standard bond is 2,500. Nothing else pending.
Okay, I mean, it says here, hold on. Yeah. Okay, all right, so any reason why you might qualify for pre-trial service, involved in alternate bonds standard.
Counsel, are you okay with just 2,500?
Yes, I think that's probably would be in the best interest of Mr. Valencia.
All right, so I'm gonna set bond at 2,500 with a state.
Okay. Thank you, Mr. Valencia. You'll be getting out later today, okay?
All right, good luck.
Thank you, Judge. Thank you, State.
He's not gonna, you're welcome, sir. Okay, all right. Back on the calendar. I think we are at Johnson, Tyler Johnson on page 4, is that correct? Or do we miss?
No, Judge, we're back
Maryland.
on page 3, Marlene and Tien, the last female.
Okay, here we go. All right, good morning. My understanding is she is out on bond in case number F253161, which is possession of cocaine. And so she will be held no bond on that case until she goes before the judge in that division. In this case, public defenders appointed. Ma'am, you said alleged that you committed the offense of strong arm robbery on February 28th of this year in the vicinity of 40 Northeast 75th Street in Miami, the alleged victim being a LaShawn McPhee. All right, I'm going to take a look at your arrest affidavit, and there's a co-defendant in this case as well, to see if there's probable cause and to address your bond status. Okay. All right, I find probable cause. Bond is set at $7,500 in this case with a GPS. If she's able to post the bond on the other one, total lockdown and stay away order. Ma'am, if you're able to post the bond and be released, you have to stay away from LaShawn McPhee. It's part of the conditions of your release. No contact, direct or indirect, and stay at least 500 feet. Do you understand that?
Yeah, but I don't even know who the person is. Judge, would you grant a work exception? She does work.
She's out on bond. No. No. Good luck, ma'am.
Judge, if she's out on bond, she'll have to go see the judge tomorrow, but on this particular case, Judge, I'm just asking that she have a work exception. I do have a job.
All right, next case is Tyler Johnson. Tyler Johnson.
Judge, who did you call next?
Tyler Johnson.
Okay, thank you. Mr. Johnson is present.
Good afternoon, sir. You for the court because it's alleged that on March 26th at an Exxon station located in North Miami Beach, a gas station, you committed the offense of criminal mischief, $1,000 or more, petty theft, and resisting an officer without violence to his person. I've appointed the public defender's office to represent you, and let's see here. I'm going to take a look at the form to determine your bond status. Does he has a null process. He has nothing else, right?
Correct.
Yeah. What's your address, Mr. Tyler?
He's currently homeless, Judge.
Oh, he's homeless. Oh, okay. Got it. Okay.
Judge, would we be able to reset Mr. Johnson for the afternoon? I'd like to see if I can get him into Southern Winds Hospital for some treatment. He's willing to go, and he believes he has active benefits.
All right, I'm gonna set the bond. If you're able to have something like that, you can.
Well, Judge, once you set the bond, then it'll be off the calendar, so.
What is the, why I wouldn't set the bond?
Why? Well, the box indicates PMHD, which is a possible mental health disorder. He indicates he does have benefits and is willing to receive treatment, Judge. So if we can get him over to the hospital for some treatment, we could do that hopefully by the end of the day, Judge.
And this is at what facility?
Southern Winds Hospital. It's a freestanding mental health facility. It's next to Citrus Health Network on the Palmetto.
Reset PM.
Thank you. All right.
Gonna be in the afternoon. Jose Ramirez. Jose Ramirez.
Coming up, yeah.
He's coming in.
Mr. Ramirez, do you speak English?
Habla inglés, señor Ramirez.
English.
English is fine. English is fine.
All right, Mr. Ramirez, good morning. You are charged with having committed the offense of aggravated battery with a deadly weapon or attempted, it says here, a machete. The alleged victim being George Bastard. and criminal mischief, more than $200 but less than $1,000 in the vicinity of 1651 West Okeechobee Road in Hialeah. I've appointed the public defender's office to represent you, so I'm going to take a look at the A form and make a finding if there's probable cause or not, and address your bond status, sir. Why is this an attempt, Madam State?
So it should be, I think it actually is an attempt because the victim was hit, but I don't think the victim was hit by the machete.
So it looks like an aggravated assault at best, Judge. And it appears that Mr. Ramirez is one that was injured. He's quite bandaged.
He's got nothing. 1 minute. Got another bet. No, it was an all frost. Another battery. No. Okay. I'm setting bond at $1,000, count one. Where do you live, Mr. Ramirez?
Where do you live?
I live in 1651 West Okeechobee Road, apartment 10, ma'am.
Same place where this supposedly happened.
Yes, ma'am. I'm the
Don't talk about the case. I just want to make sure because there's going to be a stay away order, but do they live in the same place? That's the concern that I have. This is renting a room is this a motel? Where you live
Yeah.
at?
Yes.
So this could be a problem with his staying 500 feet from this person. If this other person, the alleged victim, lives in the same place.
The alleged victim does not live there, Judge.
Does not live there? Okay, all right, okay. And then this criminal mischief state.
That's for slashing the tires.
There's no value, Judge.
No value. $100. Okay, so count 1,000, count $200 with a stay away order. Mr. Ramirez, if you're able to post this bond, you need to, okay, hold on. You need to stay away from Jorge Bistar, at least 500 feet away from him. No contact, direct or indirect. Do you understand that?
Yes, ma'am.
Good luck to you, sir. Next case, Kevin Kinsman.
Judge, there's a private attorney who needs to go to a sentencing in Broward. He wants to address the court. Let me know if I can promote.
Go right ahead.
Mr. Lewis.
Who's this for the court? Who's this?
For the court is Mr. Kinsman.
Okay, which is the one I was going to call, no?
Yes. Corrections, if we could do Quintanilla next, if possible.
Okay, Mr. Lewis, may I help you, sir?
Judge, I'm here. I'm here on Carlos Canetella, and I'm about to start a sentencing on a vehicular homicide. So if you could take me out of turn, I'd really appreciate it.
Is this Quintella?
Yes, Carlos Cantella.
Is this, that's why I'm asking, who's this gentleman?
For the court is Mr. Kinsman.
So Judge, we have Mr. Quintella. English or Spanish? He speaks English and Spanish.
English is fine, Judge.
Hey, Mr. Quintella.
Yes, good morning.
Out on felony bond in case number F25 5010 in Division 1. So it looks like you will be held no bond on that case. In case number And the new one is F-256245, where it's alleged that you committed one count of burglary of an occupied dwelling, which is a secondary felony, and one count of stalking, aggravated stalking, harassing or cyber stalking. Alleged victim being Sarah Liriano. Okay. And counsel, you represent him on these cases?
Judge, I do and will. If I could just speak as to the probable cause for the new case, it's my understanding this is his ex-girlfriend who came to Smith and Walensky's where he was having lunch with his new girlfriend, and she created a scene and is alleging now that somehow he took her phone. I'd ask for a very reasonable bond under these circumstances, Judge.
But he's out on felony bond on robbery charges. It looks like strong arm robbery, burglary, stalking, another stalking or not. No, this is this one, I'm sorry. It's only on the strong arm robbery.
Yeah, I understand, Judge, we're going to have to go in front of the division judge on that case, but I just would ask for a reasonable bond on this case, and I guess we'll deal with the division judge on the case that he's already out on bond.
For another case, F-255010, that is pending arraignment on April 9th for another aggravated assault with a firearm, corrections or state?
So I see the open case pending arraignment, yes.
Okay.
He's a longtime resident, Judge, has good employment. And all of these are pretty much a resulting of a ex-girlfriend who's continues to stalk him.
Okay. Okay, the allegations are that on March 25th of 2025, in the vicinity of 910 West Avenue, apartment 1032 in Miami Beach, that he unlawfully entered the victim's apartment. Let me just see. After picking the front door lock. Okay. All right, I'm making a finding of probable cause. Just see here, and is this an occupied
Yes,
of a dwelling?
yes,
It's not a second degree felony.
it is.
Occupied?
Yes.
But there's no battery or weapon. All right. Okay, so the bond on that, count one is 7,500. Count two is $5,000 with a stay away order. One of the conditions of his release is he not engage in any criminal activity, cannot use or possess any illegal drugs, cannot use or possess any firearm, ammunition, or weapon, and if he has one, he has to surrender them to the local police department. He is prohibited from having any direct or indirect contact with the victim, Sarah Liriano, either in person, in writing, by telephone, through social media, or through third persons. He has to stay at least 500 feet away from her. Do you understand that, sir?
Yes, ma'am.
That's on that case. And then he has a strong arm robbery on case number F-256204, and that's the one that took place at 9. Actually, that goes back to January 25th in the vicinity of 910 West Avenue, Miami Beach. So, $7,500 with a stay away order.
I'm sorry, Your Honor, you said 25?
$7,500
Thank
with a stay away order.
Judge, thank you for taking me out of turn. Do we know when he's going to be sent to division on the no bond case?
Tomorrow, Judge Block.
Thank you so much. Thank you again, Judge.
Bye.
Okay, come on.
All right, Mr. Kinsman.
Mr. Kinsman is present.
Kinsman, good afternoon. Do you speak English? Yes?
Yes, I do.
All right, sir. It's alleged that on March 19th, in the vicinity of 6261 Southwest 8th Street, you committed the offense of aggravated battery with a deadly weapon, and the alleged victim in the case has initials, I think that says KN. Not really certain. I have appointed the public defender's office to represent you. Let me take a look at the A form so we can determine your bond status. And he doesn't have.
No priors that I'm aware of.
Okay. Vehicle being the deadly weapon being the vehicle, correct?
Yes.
Finding probable cause, setting bond at $7,500 with a stay away order. Sir, if you're able to post the bond, you cannot have any contact, direct or indirect, with the alleged victim in the case with initials KN. You have to stay at least 500 feet away from her. No direct or indirect contact. You also cannot engage in any criminal activity, cannot use or possess any illegal drugs, and you cannot use or possess any firearms, guns, weapons, or ammunition. And if you have any, you have to turn them into the local police station and file a receipt with the court. Do you understand that? Yes?
Yes, ma'am.
Thank you. Juan Torres?
Spanish interpreter for Mr. Torres.
Interpreter present.
All right, good afternoon. Actually, good morning still, Mr.
Buenos
Torres.
días todavía, señor.
All right, my understanding is it's alleged that on March 21st of this year, in the vicinity of 1695 Northwest 20th Street.
Excuse me, Your Honor. I'm sorry, I didn't hear the address in the vicinity of
1695 Northwest 20th Street.
695 Northwest 28th Street.
20th Street. Sorry.
I'm sorry. I apologize to the court. There's some background noise, Your Honor. I apologize. Entonces, señor, se alega que el día 21 de marzo, en la vecindad del 1695, la calle 20 del Northwest,
You committed the offense of petty theft, 2 or more convictions, which make it a felony.
usted ya cometió el delito de hurto en menor cuantía, ya teniendo 2 o más condenas de la misma naturaleza, del mismo delito,
which makes it a felony with 3rd degree.
que eso lo conduce a hacer esto un delito mayor de 3er grado.
All right, the court's going to review the arrest affidavit to determine your bond status.
Entonces, si la sala ha revisado el informe de arresto, determina que existe motivo fundado para el arresto.
All right. Alleged victim of brings at 1695, again, Northwest 20th Street.
Usted vive entonces en el 1695, calle 20 del Northwest.
All right. I'm setting standard bond at $2,500 with a stay.
Entonces se fija la fianza que es normal para casos como este, que está en $2,500, señor.
Judge, with regard to probable cause, it indicates
Entonces se
prior
determina el
conviction
motivo
for
fundado,
petty
pregunta.
theft. However, the arrest form just indicates that he has prior
Hurto en
convictions.
menor
Does not
cuantía.
indicate
Ahí
what they
está
are.
también el informe de arresto que ponen en la pantalla para que se vea.
So here's a conviction for petty theft with a prior conviction.
Ya ha tenido ya condenas anteriores de delitos como estos, hurto en menor cuantía.
I found probable cause.
Judge, would
Ya
you,
yo determiné que sí existe motivo fundado para el delito que se le imputa al
And
señor.
they were from Walgreens. Okay.
would you consider the TAP program for Mr. Torres? He's currently.
La defensoría pregunta que si consideraría liberación con las condiciones del programa TAP.
Got an extensive history. All right, denied. Next case, Emil.
Denegado.
Bless you.
Judge, Mr. Acosta has a private attorney, Mr. Takachel. Let me see if he's here.
You can't stand right there. You want him to stand to go from this query?
I don't see his lawyer here. If we can pass. You
Who was his attorney? What's the name?
Arturo Takachel. Is he in the room by any chance?
I don't see. It's what,
So if we can just pass it.
pass. Next is Eric Podio. Is this Mr. Podio? Do you speak English?
Yes, Your Honor.
Okay, good morning, sir. All right, you are before the court because it's alleged that you committed the offense of strong arm robbery on March 2nd of 2023. Okay, in the vicinity of 9020 Northwest 8th Avenue in Miami. The alleged victim being a person with initials CV. Okay, I've appointed the public defender's office to represent you. Let me take a look at the A form and see if we can determine your bond status. Okay. All right. I find probable cause. Set bond at $7,500 with a stay away order.
Judge, would you be willing to lower the bond a little bit for Mr. Codio? He's not sure if he can afford the 7,500. Would you do 3,500 to 5,000?
Please.
Robbery. Why am I mean, he's got contacts with the system. It's not a first time. And albeit the last one goes back to 2022, but respectfully denied.
It looks more like a robbery by sudden snatching, which is a third-degree felony with a $2,500 bond, Judge. That's why I'm asking if you would consider
Appreciate the argument. I found probable cause for strong arm robbery and setting 7,500 with a stay away order. Mr. Codio, I'm sorry, I need you to understand that if you're able to post the bond, you cannot have any contact, direct or indirect, with the victim whose initials are CV. You have to stay at least 500 feet away from the victim's home, place of employment or school at all times. No texting, emailing, Facebook messaging, or Twitter. You understand that, sir? Yep.
Do you understand the order?
Yeah. Come on.
Angel Acosta. Is this Angel Acosta?
Yes.
Okay.
English.
All right. It's alleged that on March 26th of 2025, committed the offense of grand theft in the third degree in the Trump National Hotel located at 4400 Northwest 87 Avenue and Doral. My understanding is that this defendant has a probation hold in the following cases in Division 21, F23-8227 and F23-19978. Is that correct? Corrections?
Yes.
Okay, all right, so there will be no bond on those cases until defendant goes before that judge. 19978. Okay, public defender's office is appointed in this case. Let me just take a look. This is for hotel charges not paid. Correct. Yep. Standard bond 2,500 with a stay away order. You're able to post bond on this one. You can't go anywhere near Trump National Hotel located at 4400 Northwest 87th Avenue. You understand that? Yes?
Yes, ma'am.
Okay.
Judge, we have a private attorney for Jose Paniagua Charles. Do you want to take them out of turn?
I'm not going to take any private attorneys out of turn. This calendar is huge and we need to move it along. Ray Reichel on the bottom of page 5. So Mr. Reichel, do you speak English? Or Mr. Ray rather?
Yeah.
Speak English? Yes? Okay. Right. Good morning, sir. You have 2 cases before the court. First one in order that I'm being handed down is F256209. And in that case, it's alleged that you committed the offense of burglary of an unoccupied dwelling, 2nd-degree felony, and 1 count of grand theft in the 3rd-degree felony. And this is in the vicinity, this supposedly took place March 11th of this year at 4265 Southwest 5th Terrace. Alleged victim in that case is person with initials EL, okay? In case number F256210, it's alleged that on March 17th of this year, in the vicinity of 78 Northwest 44th Avenue, Miami, you committed the offense of burglary of an unoccupied conveyance, 3rd-degree felony, unlawful possession of a stolen credit card or debit card, 3rd-degree felony, and 1 count of fraudulent use of a credit card for less than $100. It says $100. All right. I've appointed the public defender's office to represent you. I'm going to take a look at the arrest affidavit to determine your bond status. Is he serving a sentence in, or was it closed out in F24185?
He was sentenced to 270 last year.
Last year.
The sentence is complete.
Okay, because I have a close date. Oh, I see. You're
He may
correct.
have had some CTS. I don't know exactly when he was released.
Okay, all right. But he's not on probation.
Correct.
On case ending in 6209, that's a curtilage. It appears.
Yeah.
And value. This is a package. It says here.
$80, so it'd be an M2.
All right. In case number F256209, I'm making a finding of probable cause as to a third-degree felony, and that is $2,500 of bond, and in the second count, only misdemeanor first degree, so 200 actually of the
second degree misdemeanor.
so that's $100. Yes, so total is $2,600 with a stay away order. Okay, and let me see, this one is 6209. Yes, the victim is initials EL, is a stay away from 4265 Southwest Fifth Terrace in Miami, and have no contact, director, and direct with the victim whose initials is EL. That's that one. In case number F56210, I find probable causes to all counts. So count one is 2,500, count two, 2,500, count three, $500 with a stay away order. I don't have a stay order for that one.
No, Judge.
Okay, so no stay order. Next case is Selwyn Goodlow on page 6.
Judge, Mr. Goodlow should be in division.
So let's take it off calendar.
Yes, I do have a note here.
Or are you sure, or is it a refile?
It says, let me see, it says here, I have a note here, 3 cases, and it's warrants have been, but it says cases already have been sent to division.
So we can take it off calendar.
They should be on for tomorrow corrections? Do we know?
I don't know. I don't have a date.
So what do you want me to do with this?
Have them scheduled for tomorrow, Judge, before the division judge.
Okay. So, on all of these. William Quick.
The bond out?
Thank you. Raul Hernandez.
Mr. Hernandez is present. He speaks English.
Hernandez. I'm missing right, they must be there, the April, the priors and Hernandez. There we go, thank you. All right, Mr. Hernandez, good morning, sir. You are before the court. It's alleged that on February 27th of this year, in the vicinity of 641 Brickell Key Drive, you committed the following offenses: 1 count of burglary of an occupied conveyance, 1 count of aggravated assault with a deadly weapon, 1 count of criminal mischief more than $200 but less than $1,000, 1 count of battery. I've appointed the public defender's office to represent you, and I'm going to be looking at the A forms now to determine probable cause. He's not on any supervision. No.
He did come in on 2 bench warrants, and I think that there is probable cause for burglary with an assault or battery.
Take a look at this. And the victim, the alleged victim's name is Jean Pierre Lewis. Okay, any argument?
Yes, Judge, there's nothing indicate that Mr. Hernandez did not have permission to be in the vehicle. There's nothing indicating who the owner of the vehicle was, Judge.
Judge, I think there's still probable cause. Burglary for the purpose of a criminal statute is different than property law.
So, Judge, if he's the owner of the car, then there's nothing indicating he wouldn't have permission to go into his own car if somebody's in the car without his permission. So at best, it would be an aggravated assault.
I'm sorry, I didn't hear. At best,
At best, it would be an aggravated assault for count 2.
What about count 1, Madam Ms. Corey? Because that's
There's nothing indicating who the owner is of the vehicle.
I mean, it's pretty clear he didn't have permission to be inside of the car in that they locked the door and he was trying to drill through the victim's face.
Isn't this the same victim that you have in this stay away order, the Jean Lewis? I mean, there's a victim. I'm confused
I
here.
think Mrs. Corey is trying to claim that the defendant owns the car, but that's not in the A form.
Well,
So I'm not contesting count 2, Judge.
no, we're talking about count 1.
Right, I'd ask if I know probable cause for count 1 or have a probable cause hearing, Judge.
It says the victim was sitting in the front passenger seat of the witness's black Tesla. So
it's the romantic,
it's his ex's car.
right? So I'm confused here as to where Ms. Corey is making the assumption that this vehicle belongs to the defendant. I don't read it as such unless I'm missing something.
Probably based on what our client told her. But there's PC from the 4 corners of the affidavit.
Actually, been occupied.
Right.
The battery.
With an assault or battery.
Right. So then even aggravates it more to no bond status. Okay. I don't think there's any, I didn't see the amount of the criminal mischief.
No.
Judge, one moment, I think she might be here. One moment, I'm gonna promote.
Yes.
Who is this?
Yes, I'm the witness. It's my car. It was his car. He had permission. He had the keys. It's his car. We shared the car together.
Okay.
There was burglary.
Hold on. Okay. Who are you, first of all? Because I have no idea. What's your name?
The owner of the black
Ariel
Tesla.
Montañez.
What's your name? Your name.
Ariel Montañez.
Ariel who?
Montañez.
Okay. The alleged victim in this case is a person by the name, according to the documentation that I received by the state, Jean Lewis.
Yes, I'm the witness. It was my car. It says the witness owns the black Tesla, not the victim. It was my car, and me and Raul shared it. I knew he had possession of the car. He had the keys, everything. He was not locked out. It's his car.
Okay.
Nothing was burglarized. He had possession of the car. It was known. We were speaking. This was.
And this because this is an investigation that, you know what, I want the detective here because I want to have this set for a probable cause hearing because this was not something that happened yesterday. This alleged event took place on February 27th of 2025, okay? And there were detectives that pursuant to an investigation ended up in a lineup identifying the defendant. And if the court reads this correctly, you're looking at the probability of probable cause for a first-degree felony punishable by life, which has no bond. So I'd like to have a full-blown hearing on this. Want to set this, I don't know if you can get the detective in this afternoon. If not, we can do it tomorrow.
I can
Get him in this afternoon. Can we get him in this afternoon?
Let me go right now.
I want to go right now. If I can do this as fast as possible and clear up this issue. It
Is somebody speaking to her?
No one is speaking to me.
I'm hearing third parties. She needs to present identification, ma'am. The state of Florida is going to make a determination as to how quickly they can get the detectives in. And if you want to appear at that hearing, then certainly you'll be advised and you can appear. Okay. When can you bring the detective in?
I can call him for this afternoon, Judge.
You want to try and set this afternoon?
Sure, I can try and call him this afternoon, but it looks like this happened back in February and maybe things, her opinion about what happened has changed.
It's up to
you. The one thing on the form I requested, I made sure there was no burglary at all.
Ma'am, you're talking out of turn. Let me I'm trying to ask a question of the state of Florida.
I'm so sorry.
I know you're frustrated, we're trying to get to this, but we're trying to make sure that there's sufficient time to get the law enforcement officers here, which have also a right to be able to talk to you, all right? So that work it out in some kind of an methodology. Okay, you can try for this afternoon, and if not, then it can be rolled over tomorrow. Okay, so reset for this afternoon, PM.
Thank you, Judge. And Judge, we have Mr. Takachel here on Mr. Acosta.
We passed that one, hold on. So let's reset. What page was that one on? Let me see here.
5.
Did I do bad?
Okay. I don't see the attorney. Let's do from.
He's on the screen now. There he is.
There we go.
Good morning, Judge. Good to see you again.
Likewise, counsel. Okay, so you represent Mr. Emil Acosta?
Emil Acosta, yes, Judge.
Okay, all right. So it is alleged that on March 25th of this year in the vicinity of 936 Northwest 44th Avenue,
Okay.
Miami, your client committed the offense of burglary with assault and battery therein, being a first-degree felony punishable by life, and 1 count of strong-arm robbery.
Oof.
Alleged victim in this case is Julio Merejos. Okay, in addition to which, the state of Florida has filed a motion for pretrial detention as to count 1, pursuant to Florida statute 907.041, asking that this court make the appropriate findings and hold him no bond. Okay?
Got it.
In terms of, let me just see here because there's a bunch of paperwork here. 6-2. It looks like this is he has another case.
He has another case?
Hold on, let me just make sure.
Yes, Judge.
Second count.
Wait a minute, I gotta make sure. Yeah, this is Acosta 6195. Yeah, he's got, but there are misdemeanors. It looks like he has another case which has no future hearing. It's an M24. How could that be? That's on battery, cannabis, and some other stuff, and then another.
He may have been in Mr. Takashi. Did you represent him? He may be in the program.
I was not aware of those cases.
Okay, but that doesn't have a future hearing. It's a 24 case, so that is in the system. All right. So having said that, I'm going to take a look at the arrest affidavit to see if there's probable cause and then address his bond status. But these are pretty serious charges.
Yes, they are, Judge. Thank you.
We spoke with Hernandez, by the way. The one for this afternoon, yeah. So this is a DV injunction related case.
Oh, okay.
Okay, so that you see, it says there's a relationship between him and the defendant.
So there's a domestic violence angle to this. Got it.
That's what's alleged. So he was served with an injunction. But it's a witness, the witness. So it's not the alleged victim, it's the witness that has a prior relationship.
Oh, okay. Not the defendant.
Do you have a copy of the A form, counsel?
No, I do not, Judge. His mother called me 30, 40 minutes ago.
Okay. All right, state.
So Judge, there is probable cause. The state did file a motion for pretrial detention, requesting the defendant be held.
Okay. Your Honor, is it possible to have this case print tomorrow before his division judge?
They usually do, is my understanding. Okay. I don't know who the division judge is, but
Should be there on the,
It's Cabarga.
oh, okay.
so I've reviewed the A form. I'm gonna make a finding of probable cause. I'm gonna grant the state's motion as to count one. So in count one, he'll be held no bond.
Okay.
Hold on a second.
Sorry. Good afternoon. Good morning.
And then as it relates to count two. This is about a phone. I think there may be a domestic spin on all of this, by the way. You have to read the A form. Okay.
Okay.
$7,500 with a stay away order. If he's able to post the bond, he will have to have no contact, direct or indirect, with his alleged victim, Julio Merejos, and cannot go anywhere near the following address, which is 936 Northwest 44th Avenue in Miami. Okay. And this will print out tomorrow with Cabargas' division. Yes.
We don't set it here.
Who does it? Who does it? Because council wants to see it.
Yes, I'd like to address it in the division.
Can you call and see if it'll print out tomorrow in front of?
It should automatically print. There's a motion for pretrial detention.
Oh, okay, yeah, yeah, that'll put it there for sure.
Okay.
Thank you.
Good to see you. Bye.
Thank you. Good to see you, Judge. Thank you very much.
Back on page 7, Jorge Castro Govea.
Spanish, please.
Okay, good morning, sir. All right, this is a warrant. Let me just see here. And it looks like it's staged insurance fraud and false report of a crime to a law enforcement officer. Who's coming from? Okay. Having to do with automobiles and staged accidents. Okay. What's the amount of the fraud, the result having to do with this State, do you have any idea of the insurance fraud that's alleged?
I would have to look at the warrant.
But I need to know a little bit more information.
Nothing indicating that anything was filed that I see.
So he's not charged with theft.
Only with staged insurance fraud by way of accident. It says it's a second-degree felony, but I see one count only, and false report of a crime to law enforcement officers. Only one count as well.
Judge, I would ask if you would consider pretrial services for Mr. Castro Gouveia. I see no prior history for him.
Dave, what's your position regarding pretrial?
I'll defer to the court.
I'm going to assess standard bond. Count 1, $7,500. Count 2, $500. Moving on to Lennon Purcell. Lennon Purcell. Is that you? Good morning.
Good morning, ma'am.
Sir, it's alleged that on March 26th of this year, in the vicinity of Northwest 38th Street and Northwest 32nd Avenue, you committed the offense of possession of a controlled substance, methamphetamine. Okay. I've appointed the public defender's office to represent you. He doesn't have any open cases.
I would ask for the TAP program, Judge, for Mr. Purcell.
Where do you live, Mr. Purcell?
I live at 1035 9th Street, Miami Beach, Florida.
And how long have you lived there?
About 5-6 months.
Is that a home or an apartment?
It's apartment 3.
All right, TAP?
Yes, please.
Okay, so TAP referral. Alternate bond is $2,500. What is the return date on this?
Judge, they can send it to him in the mail since he has an address.
But in terms of here, do we have a reset date?
We only do a reset date if they're homeless to tell them when to come back to court.
We do not need to do that.
Right. The only thing is, I think we need the address, apartment number for that to be, Ms. Court, because he filled out the affidavit, it'll go to his apartment number.
Yes.
Okay, we're good.
And does the clerk have, because this A form doesn't have an apartment number. It just says 956 Washington Avenue.
So what Ms. Corey said is before is that they send notice based upon where the defendants write their address in their affidavit for indigency. So if he writes his correct address, then they should send it to the correct place.
They should. Okay.
Thank you.
You're welcome. Okay. Mario Rodriguez.
Bond it up.
Thank you. Christian Marshall on page 8. Is it Marshall?
Yes, Cal Tristan.
Morning. Okay, good morning. It looks like you're out on bond in case number F24 23314 in Division 3. So there's going to be a hold on that case until you appear before that judge. Okay, today, you arrested on March 26th in the vicinity of Northwest 3rd Avenue and 16th Terrace in Miami for possession of a controlled substance, suspected MDMA. What is the other case for? Possession of controlled substance. Okay. All right, I'm going to appoint the public defender's office. Let me just take a look at this for your bond. $2,500 bond. Next case is for Sean Williams. Mr. Williams, good afternoon, good morning, still good morning. It's alleged that on March 26th of this year in the vicinity of Northwest 3rd Avenue and 16th Terrace, you committed the offense of possession with intent to sell or manufacture suspect crack cocaine and possession of suspect crack cocaine. I've appointed the public defender's office to represent you. Let me take a look at the arrest affidavit to determine your bond status here. Does he have anything open? Doesn't look like it. So.
He's got prior convictions for drug sales. State's requesting a bond. Maybe split the bond between the 2 counts.
$2,500 both counts on each of them. Count 125, count 225. 2,500. So total bond is $5,000. Carlos Toombs. The co-defendant.
Right, he's the buyer.
Is this Mr. Toombs? Yes?
Yes.
I was looking down. All right. Good morning, sir. All right. It's alleged that on March 26th of this year in the vicinity of Northwest 3rd Avenue and 16th Terrace, you committed the offense of possession with intent to purchase suspect crack cocaine and possession of cocaine. Is he on any kind of supervision? I see the record here, no question about it.
I don't believe he's on supervision.
Same thing as the other one, 2,500.
Since he's the buyer, he's not selling. I don't know.
Would you
If
be okay with pretrial services?
But he's got a lot of priors, so up to you, Judge.
Or tap?
Yeah, wow. This is consistent since 1980. Wait a minute, it even goes further.
Most of them are pretty old though, Judge.
Yeah, but no, not really. I mean, yeah.
10 years old.
Oh, you're right. Wait, no, 2014. Yeah, but he's got. I mean, the last contact was in 2016, but it's consistent. It's 4 pages of priors. Tap. Where do you live? Where do you live?
What's your address, sir?
Oh, I live at the community's house.
Oh, and does that work with tap?
Yes.
Yes.
So now you got. Okay, so we have to give him a date on this one.
Yes.
Tap referral. Okay. And when's the return date?
30 days.
March what?
April?
Oh, okay, because I was like, that's not 30 days. Okay, April. No, that's okay. We're getting tired. April what? I'm sorry. April. I'm sorry. Thank you. April 28th, and where does he have to go to?
Judge Altfield's courtroom, which I believe is 6-2.
6-2, and at 9 a.m.?
Yes.
All right, Mr. Toombs, listen carefully, sir. I'm going to refer you to the top program. You need to go back to court. Okay, I'm giving you oral notice on April 28th of 2025 in courtroom 6-2 in the morning, okay? 9 a.m. Got it? And they'll write it down for you.
And the alternate bond?
Alternate bond is 2,500 count 1, 2,500 count 2, okay? Jeremy Bryan. Mr. Bryan, good morning, sir. It's alleged that on March 26th of this year in the vicinity of Southwest 2nd Avenue and Southwest 1st Street of Miami, you committed the following offenses. First count is possession with intent to sell crack cocaine rocks. Then you have 12 counts of possession of crack cocaine rocks, which are each third-degree felonies. And then you have 1 count of possession without a prescription of certain drugs, which is a first-degree, it looks like second-degree misdemeanor. Okay. All right, I've appointed the public defender's office. Let me take a look at the A form here and see
Your
how
Honor, could
these
split-
12 counts. Yes, go ahead.
Yeah, Your Honor could split the bond on 1 and 2, or set the bond on 1, and ROR 2 through 13.
The same rocks, and I haven't looked at the A form.
Right, so what it is, they're charging him for every single rock.
Okay.
So I'm okay if you're on our RORs 2 through 13.
And the medication, what is it without the prescription? What we have now?
It just says a prescription bottle containing pills prescribed to someone else.
Pills to someone else. Okay. Got it. Okay. Counts 12. All right, so count 1 will be $7,500. Counts 2 through 13 will be ROR. Count 3
is 14.
Oh, that's right, 14. This is number 14. Is gonna be $100. 100. Okay. Robert McKenzie.
He's a refusal.
Can you please reset it?
Okay, reset what, tomorrow?
It's gotta stay on the calendar, so it'll be on this afternoon.
Okay, so refusing, and it'll just print when it prints?
Yep.
Okay, then who's this gentleman?
This is Mr. Peterson. He's the next one on the calendar.
Okay. Demetrius Peterson?
Yes, ma'am.
All right. My understanding is this gentleman is out on bond in case number F25 3587 for possession of cocaine and division 12. So there should be a hold in that case until he goes before the division judge. In this case, Mr. Peterson, it's alleged that you committed the offense of possession with intent to sell cocaine in the vicinity of 107 Northwest 11th Street, or I'm sorry, 11th Avenue in Miami on March 26th. I've appointed the public defender's office to represent you. I'm going to take a look at the A form to address your bond status. $7,500 bond. Next case. Jorge Izalbe.
Judge, can we reset this one for the afternoon? I should have filed a motion for pretrial detention.
Okay, so corrections reset, we're gonna print them out, Mr. Izalbe, in the afternoon today. Okay.
Yes, sure.
Next case is Malcolm Bowe. Mr. Bowe, good morning, sir.
Morning.
For the court, it's alleged that March 26th, in the vicinity of 1264 Northwest 61st Street in Miami, you committed the offense of possession of cocaine, 1 count. Possession with intent to sell, manufacture, deliver cocaine, second-degree felony, 1 count. 1 count of possession with intent to sell, manufacture MDMA, 1 count. And let's see here, 1 count of owning, renting for purposes of trafficking in cocaine, MDMA. I've appointed the public defender's office to represent you.
So it's a search warrant. He had some money. He said he was previously in the northeast bedroom. In the northeast bedroom, they found some cocaine as well as his cell phones. But the majority of the drugs were found in the vacant room. He made a statement that he's aware they sell narcotics at the location.
Yeah,
I think there's enough for probable cause. He's present at this location where he's aware they sell drugs. His phone is, and drugs are found in the room. He said he was just in and they found money.
These are
Judge, at best, it looks like possession of cocaine.
Yeah.
2 baggies.
I'm bringing the officer anyways. You want to reset this one too, Judge?
What do we do with the other ones?
The other one is set for PCH tomorrow.
This the same thing, because I can't, that's a stretch there. All right, reset PC hearing.
For tomorrow, Your Honor, or this afternoon?
No, this one's set with the co-defendant for tomorrow. It's the one with the car, the Tesla, that's set for this afternoon. All right, next case is Juan Diaz Ramos. Bottom page 10. This, for all intents and purposes, is the first time for this gentleman, because I see everything else was dismissed.
Right, so you should qualify for a program.
Spanish interpreter for Mr. Diaz Ramos, please.
Okay. All right, Mr.
Yes, the interpreter is present, and I apologize for the background noise, as I said before. Señor Diaz Ramos.
All right. You're accused of having committed the offense of possession of cocaine in the vicinity of Northwest 41st Street and 23rd Avenue.
Señora, usted se le acusa de haber cometido el delito de tenencia de cocaína en la vecindad de la calle 41 del Northwest y 37 Avenida.
Where do you live, sir? What's your
¿Dónde
address?
vive usted? La dirección suya, por favor,
8991 Southwest 36 calle.
Is that a house or an
89. 80. Okay, what's the
89
address? ¿Es una casa o un apartamento?
es una casa.
It's a house. 89?
Go ahead.
8991 Southwest
Okay.
36th Street.
Okay, 86. ¿Cuánto tiempo lleva usted viviendo ahí, señor?
Año y medio, voy para año y 8 meses.
A year and a half. It's going to be 1 year and 8 months.
Okay. I'm going to refer to pretrial services.
Yo entonces lo voy a hacer la referencia a usted para los servicios de antejuicio.
All right. Alternate bond is going to be $2,500. Okay.
Y en la alternativa usted saldría pagando una fianza de $2,500.
Hopefully they'll take you. They're going to interview you. Okay. Good luck to you.
Okay, muchas gracias, señor. Buena suerte.
Page 11, I have Danis Ortiz.
Spanish for Mr. Ortiz, please.
All right, Mr. Ortiz, good morning, sir.
Señor Ortiz, buenos días.
Okay, you're charged of having committed possession of crack cocaine and 1 count of possession of cannabis in the vicinity.
Okay. Okay. A usted se le acusa de la tenencia de cocaína en forma crack y también la tenencia de cannabis en la vecindad de la siguiente dirección.
Northwest 43rd Street and 23rd Court in Miami.
Southwest 23rd Street and 23rd Court. Okay. En la vecindad del
Northwest
la
40
calle 23 del Southwest y el 23 Court en Miami.
Right. Okay, I've appointed the public defender's office to represent him. He doesn't have anything. This is it, right? For that.
Voy a entonces nombrar la oficina de la Defensoría Pública para que lo represente a usted, señor.
Okay, pretrial services, possibility. Where do you live, sir?
Okay, servicio de antejuicio. ¿Dónde vive usted, señor?
En realidad no me sé mucho la dirección, pero a una cuadra donde me detuvieron.
I really do not know the address very well. It's a block away from where I was arrested, though.
Judge,
I don't know if he's been in South Florida long enough for pretrial.
Okay.
Okay, parece ser que sí, que ha vivido en el suroeste de la Florida lo suficiente como para ser elegible para los servicios de antejuicio.
You have to. What do they do? Interview him, Ms. Corey? If he doesn't remember his address, because he says he's been living here.
If he has any phone number of someone that can confirm an address for him, perhaps. that would know
Señor,
that.
le están pidiendo el número de teléfono de alguien que pudiera confirmar la dirección suya.
De verdad de verdad no me conozco a nadie, enseño porque estoy yo solo y de verdad que los números que tengo es en mi teléfono que.
Okay, the truth of the matter is I do not know anybody. I live all alone by myself and the numbers they're in my telephone.
Judge, he
My
also
cell phone.
has, it looks like some kind of traffic offense out of state where there's a warrant.
He has a warrant?
Pareciera,
I don't have any
la
of that.
fiscalía está leyendo y dice, parece ser que sí hay una orden como fugitivo de otro estado.
Well, if he's got a warrant, then it could be complicated, but.
Would you
look,
do tap?
I will do tap. This is not bond consultant. So tap referral, just give him a date when it.
Entonces va a ser una referencia para TAP y entonces lo que van a hacer es darle una fecha.
Okay, so give me the date again, Madam Clerk, that we gave the other gentleman, April something. April 28th at 9 a.m.
28 de abril.
And what forum was that?
Richard Hirsch, I've got 4-8.
4-8. Okay, so listen to me carefully, Mr. Ortiz. You're going to be referred and released to the CAP program. And
Préstame atención, señor Ortiz. Usted le van a referir al programa TAP.
you need to come back to courtroom 4-8 on April 28th, 2025 at 9 a.m. Understood?
Y usted necesita regresar al tribunal el día 28 de abril 2025 a las 9 de la mañana. Debe reportarse a la sala 4-8, señor.
Got it?
Alternate bond?
¿Lo tiene?
Please, just pass it down. Where is it? This one? Hold on. I believe count 1 is 2,500 and count 2, 500. Okay?
Judge, I see no probable cause for
Entonces, en el
cannabis.
primero sería $2,500 como alternativa y en el segundo cargo, que es cannabis, serían $500 como alternativa para salir.
What did you say?
If you would do an ROR for count or release outright for count 2, there's no mention of cannabis.
ROR. So corrections, 2,500 first count, ROR second. You are correct.
Entonces, corrección, la primera cargo son $2,500, la segunda sería liberación bajo palabra.
All right, the next case is Jose Paniagua. Charles?
He has a private attorney, Melissa Ramos, I'm going to promote.
Where's your attorney, sir?
I'm promoting her now. She's on Zoom, Judge. One moment. She's joining now.
Good morning, Your Honor. Melissa Ramos on his behalf, and he does need the services of a Spanish interpreter.
Yes.
Good morning.
The interpreter is present.
All right.
I apologize.
Your client is present before the court. It's alleged that he committed the offense of leaving the scene of a crash with serious bodily injury.
Entonces, si su cliente está aquí ante esta sala hoy por haber sido, se le alega el siguiente delito, huir de la escena de un choque donde ocurrieron daños corporales graves.
On March 26th of this year in the vicinity of Northwest 51st Street and 22nd Avenue.
Y eso ocurrió el 26 de marzo de este año en la vecindad, en los alrededores de la calle 51 del noroeste de la ciudad con la 22 avenida.
Okay, I'm going to read the arrest affidavit to determine its file status in just a moment, all right?
Yes, Judge, and I do have a PC argument.
Hold on.
Ok, yo sí tengo entonces, para motivo fundado, tengo ya un argumento.
What do you want, the F3 counsel? No SBI.
All right, go ahead, counsel.
Yes, Judge, I would just ask that you find probable cause for not for serious bodily injury.
Ok, entonces sí voy a determinar motivo fundado para lo que serían los daños corporales graves. Excuse me, the interpreter apologizes to the court for a second. I am going to disconnect and my colleague, Sheila Ortiz, is going to replace me at this moment. Thank you.
Couldn't finish out the case. Oh, there we go. Got the interpreter here.
Good morning.
There we go. Good morning.
Good morning, Judge.
Have you been sworn in this
I
morning?
have Xochitl Ortiz.
Terrific, thank you. All right, so the argument is no serious bodily injury. There's reference made in the A form that the victim, the alleged victim, was transported on the scene to Hialeah Hospital, reference neck and pain and back pain.
Yes, Judge, I would just argue that like neck and back pain can be deliberating, but it's not it doesn't qualify to the serious bodily injury.
Okay, okay.
Sí, estamos alegando de si hay gran daño corporal. El formulario de arresto indica que la víctima la transportaron al hospital de Hialeah porque estaba quejando de dolor en el cuello y en la espalda. La abogada defensora dice, sí, juez, yo alego que un dolor de espalda y de cuello lo puede debilitar a una persona, pero no califica como gran daño corporal.
Yeah. State, what's your position on that? Because I think that's a huge assumption.
¿Qué dice la fiscalía? Porque creo que es una gran presunción.
So I think we would need more information to establish that it's going to result in serious bodily injury.
Okay.
Creo que necesitamos más información para determinar si va a resultar en gran daño corporal.
That being said, I believe the defendant is a flight risk in that he texted the owner of the car to report the car stolen and left the scene of the crash.
Did you say he texted?
Yes.
Pero aparte de eso, sí creo que él presenta un riesgo de huida porque le mandó un mensaje de texto al dueño del carro para reportarla y se fue del sitio del accidente, huyó.
He needed to be convinced to come back to the scene.
Requirió que lo convencieran para que regresara al sitio del accidente.
And I counted 8 prior bench warrants for traffic, the most recent being from late December.
Y yo conté que en 8 ocasiones se emitieron órdenes de arresto por no presentarse por casos de tránsito. La más reciente fue en diciembre.
So he's got a history of not coming to court.
Así que tiene un historial de no presentarse a corte.
So what is this?
State's requesting an increased bond plus house arrest as well as a no drive order.
¿Qué pide la fiscalía? Que aumente la fianza, orden de arresto domiciliar y una orden de no manejar.
All right, I differ, and I think there's sufficient probable cause here to make a prima facie, in other words, probable cause finding with regards to the leaving the scene with serious bodily injury. This person was transported to Hialeah Hospital. I am going to find that there's probable cause for that. With regards to the other factors that the court has to consider with regards, and by the way, I don't have that information. The only thing I had on this gentleman was that he had a prior grand theft. There was no action. So I'm not privy to the information that you now are sharing with the court. But clearly that is of concern, because one of the concerns or factors that the court has to consider is whether he's a flight risk, what probability of him returning to court when so noted or so noticed, and other aspects of this of the safety of the community. And I did read the form in terms of how what occurred prior to and up until the time of the arrest. So I'm going to increase his bond. I think there's sufficient there to elevate it to $15,000. Okay. And I will institute and put in place a no drive order. That means he cannot drive a vehicle, motor vehicle, any kind of other device that is allowed to be driven on roads. Okay. He will be on a GPS monitoring device. What does he work? Do you work, sir?
1 second. Entonces yo sí discrepo, yo hallo que sí hay suficientes pruebas a primera vista que él huyó del sitio del accidente, hay motivo fundado. Yo sí veo que hay factores que él presenta un riesgo de huida, ya que no se ha presentado a otras fechas del tribunal, existe la probabilidad que no se presente en un futuro. Bueno, voy a aumentar su fianza en $15,000 más una orden de no manejar. No puede manejar ni un carro ni ningún otro tipo de aparato que se permita en las carreteras del estado. Señor, usted, un monitor grillete, ¿usted trabaja, señor?
Not at the moment.
Do you speak English?
Yes.
Oh.
Why are we using an interpreter?
¿Por qué estamos usando un intérprete?
Because my mama doesn't speak English, and my mama was the one who got me the lawyer.
Is your mother here? I'm sorry. Is she part of the chat? Is she here for these proceedings?
No, he's not present. His mom indicated to me that he would need the services of the interpreter, so I apologize.
Interpreter will stand by.
I don't think that was done deliberately. I just think it might have been miscommunication. All right. Okay, so do you go to school?
No.
Well, I don't think so. Total lockdown. Okay. Good luck.
Thank you, Judge.
Rodney Thompson.
Bond out?
Bond out? Okay, thank you. Antonio Lazard.
Yes, ma'am.
Good afternoon. All right, Mr. Lazard, it's alleged that you committed the following offenses on March 26th in the vicinity of Northwest 5th Place and 21st Terrace. First being possession with intent to sell suspect cocaine, possession of cocaine, or possession of suspect cocaine and no valid driver's, which is a traffic related offense. So let's see here. I've appointed the public defender's office to represent you. Let me take a look at this A form. Does he have anything else pending?
Nothing pending.
Everything else in the last.
I mean, he was also arrested for NVTL, but
That's all he has.
Okay, that's what he has. Right. Where do you live, sir?
What's your address?
Address.
It's 1301 Northwest 2nd Avenue.
Second Avenue Court.
I'm in second court, I think it is.
What apartment number?
206.
And not 305?
Nah, that's the previous address, ma'am.
Okay, so now it's to what?
It's 206.
And how long have you lived there?
3 weeks.
3 weeks. How long did you live at the 305?
Probably about 9 to 10 months.
Okay. Oh, that's all right. He doesn't have anything openly taken?
Judge, it's a possession with intent case.
Nothing indicating any intent to sell. It looks like it's a traffic stop, Judge. 6 baggies. They're saying he's.
I agree.
Driving.
Anybody also had money, $545.
What?
He also had money.
Right, $540 in denominations consistent. All right.
Well, Judge, any money they're gonna say is consistent with drugs. I mean, it's also consistent with a lot of other things like a rent payment, just getting paid on their job, things of that nature. So it's consistent with pretty much anything that cash is used for, Judge.
This is a pat down pursuant to a,
Well, he was getting arrested for the NVDL, I think.
that's what it was. All right. Okay, pretrial services, alternate bond. Count one. $2,500. Count two. $2,500. Okay. Good luck, sir. Next case is Sebastian Hernandez Garcia. What-
Spanish, please.
Have an interpreter?
Yes, Judge, I stayed connected. Yo se les intérprete, señor.
All right, Mr. Hernandez Garcia, you're here before the court. It's alleged that on July 8th of 2024, you committed 2 counts of aggravated battery with great bodily harm.
Señor, usted está ante el tribunal porque está enfrentando 2 cargos de agresión física con agravantes. Alegan que esto ocurrió el 8 de julio del 2024, agresión física que causó gran daño corporal.
Okay, I've appointed the public defender's office to represent you,
He nombrado a los abogados de oficio que lo representen.
and we're going to take a look at the arrest affidavits and all the documents to determine your bond status.
Vamos a repasar los affidavits de arresto y todos los documentos para determinar una fianza.
The alleged victims in both of these cases, or in this case rather, is one is Mateo Gonzalez Rubio, and then the other one is Maria Amaya Ocampo.
Las presuntas víctimas en este caso, uno es María Amaya Ocampo y el otro Mateo González Rubio.
What's the background on this gentleman, State?
¿Cuál es el historial de este joven?
I don't have anything except this.
It looks like he entered the country in December of 22.
Parece que entró al país en diciembre del 22.
I don't think I've got any other information.
Does have anything pending?
No, nothing pending.
No tengo más información. No tiene nada pendiente, no nada pendiente.
Sir, where do you live?
Señor, ¿usted dónde vive?
1261 Northwest 59 TH Street, number 15.
Okay, how long have you lived there?
Muy bien, ¿y cuánto tiempo lleva viviendo ahí?
5 months.
Okay. Do you work?
¿Trabaja usted?
Yes, sir.
Where do you work?
¿Y dónde trabaja? ¿Qué hace?
Irrigation, aires acondicionados, pintura, construcción.
Irrigation, air conditioning, painting, construction.
Okay. All right, I'm going to find probable cause as charged. There's I'm gonna set standard bond at $7,500.
Haya motivo fundado tal como lo han acusado, voy a fijar la fianza estándar en 7,500.
All right.
This is 2 counts.
Hay 2 cargos.
State you want.
I was saying, and Ms. Corey was saying the same thing, 2 counts, 2 victims.
Sí, 2 cargos, 2 víctimas.
What do you mean?
So is it 7,500 each, Judge?
75 each count.
Got it.
7,500 por cada cargo.
Spence, you were gonna say something?
Would you consider splitting one bond among 2 counts or any reduction? It's from July 2024, Judge.
It's pretty egregious. It just took a while to get in. So,
Pues consideraría dividir las fianzas o fianza solo por uno y el otro no. No dice dice la abogada defensora, fue desde el 22, no dice la juez, bastante atroz lo que ocurrió.
pretty serious injuries. I'm going to enter a stay away order, Mr. Hernandez Garcia. One of the conditions of your release, if you're able to post the bond, is you have to stay at least 500 feet away from both of these victims.
Voy a emitir una orden de alejamiento, señor. Una de las condiciones que si usted sale de aquí, tiene que obedecer orden de alejamiento, permanecer por lo menos 500 pies alejado de estas 2 víctimas.
No direct or indirect contact, which means no contact in person and writing by pager, through fax, email, any kind of social media, or through third persons. Do you understand that?
No contacto directo ni contacto indirecto. Significa no contacto ni en persona, por escrito, por localizador, por fax, por correo electrónico, mensajes de texto, mensajes por las redes sociales ni terceros. ¿Usted entiende, señor?
Yes.
Okay, good luck to you.
Buena suerte.
Diego Torres?
Mr. Torres is present. He speaks English.
Okay, Mr. Torres, good afternoon, sir. You have 2 cases before this court. The first one is F25-6238, which is alleged that you committed the offense of possession of a controlled substance, a THC wax pen. That being a 3rd-degree felony in the vicinity of 10901 Southwest 24th Street, okay? And the other case is pursuant to a warrant. Let me just see here. The bond on that one was set at $12,500, and that is a possession of a firearm by a convicted felon. Did this come from a juvenile court? I think so. Because it talks about Judge Prescott entering this warrant on January 25th. Is this a direct file? Or did
No,
he?
Judge, they're indicating that he's a delinquent based upon a prior history.
But what is he doing here in front of me?
So that's, so it's a felony to have a gun before you're a certain age if you've been adjudicated delinquent.
Okay, but these are not dealt with in juvenile court, but rather in the adult court is the question.
Yes, in the adult court.
Got it. Okay. Okay. All right. With regards to case number F25-6238, this apparently was a search incident to arrest. Let me just see here. This is missing a whole lot of information. Controlled substance, possession of a THC wax pen.
Right, so they arrested him on the warrant and they found a THC, a vape in his pocket.
But it doesn't say. It just says search incident to arrest revealed a multicolored suspect THC vape. This is most respectfully very deficient.
Let's do a $1 bond, Judge.
I have no objection to that.
Dollar? I can't
Yeah,
hear.
that's fine.
$1's
It's
fine,
always
Judge.
good.
Dollar on that one. And then on the other one, which is the arrest warrant. I'm gonna keep the bond the way that Judge Prescott suggested it, so it's 12,500.
Judge, would you consider setting standard bond form?
Not after I read the affidavit, 12,500. Good luck, sir. Wilson Munoz Suarez. This is no, same gentleman. Okay.
Spanish, please.
Yo seré su
No.
intérprete.
Mr. Munoz Suarez.
Muñoz Suárez, ¿es usted?
Yes.
Okay, sir, you have, good afternoon. You have, first of all, let me just inquire. Do you work?
A ver, un par de preguntas. Primero, ¿usted trabaja, señor?
That could be incriminating. I don't know if you want to ask that.
Sí, trabajo.
Eso podría ser incriminante. I do work.
The court needs to inquire as to whether he's entitled to the services of a public defender.
El tribunal necesita investigar y preguntar si él tiene derecho a los servicios del abogado de oficio.
One of the charges is that practicing medicine without a license.
Uno de los cargos es que está practicando medicina sin una licencia.
Without telling me what you do for a living, sir, are you employed?
Sin decirme a lo que se dedica, señor. ¿Está empleado?
No.
Do you?
¿Cómo dijo?
No.
No.
Okay. Do you own any property of value, such as a home, a car?
¿Usted es dueño de alguna propiedad de valor? Por ejemplo, una casa, un vehículo.
Sí.
Yes. Which one, the home?
¿Qué? ¿Una casa o un carro?
Una casa.
A home.
Y un carro.
And a car.
Okay. And that home, your home, it's titled in your name?
¿Y esa casa, su casa, el título está bajo su nombre, señor?
Sí, señor.
Yes, ma'am.
What is the value of that home, approximately?
¿Y aproximadamente cuál es el valor de esa casa?
$450. 450,000.
$450, 450,000.
Okay. And do you have any monies in the bank, any bank accounts with money in them?
Okay, tiene dinero en cuentas de banco con dinero.
Sí.
Yes.
How much money approximately do you have in those bank accounts?
Aproximadamente cuánto dinero tienen esas cuentas de banco.
Sumándolas todas como 15,000.
Totaling them all around 15,000.
Okay. Do you pay a mortgage on that home?
Okay, ¿usted paga una mensualidad en su casa, una hipoteca?
Sí, pago una hipoteca.
Yes, I pay a mortgage.
Okay, so you said you weren't employed, and I don't want to know what you do for a living. You weren't employed, so you don't have any regular means of income?
Okay, usted dijo que no estaba empleado y no quiero entrar en detalles en lo que trabaja, pero dice que no tiene ninguna fuente de ingreso.
Tengo la fuente de ingresos de mi clínica en Venezuela y aquí cuando los doctores me llaman a que los asista como surgical assistant.
Cuando lo asiste como surgical assistant, dijo.
Sí.
I have got my clinic from Venezuela, and then here when doctors call me so that I can assist as a surgical assistant.
Did you file a tax return last year?
El año pasado presentó una declaración de impuestos.
Sí, sí.
Yes.
How much were your earnings last year?
Y el año pasado, ¿cuánto fueron sus ingresos?
¿Cuánto pagué o cuántos fueron mis ingresos?
How much did I pay or how much my income was?
Your income, just
Su
income.
ingreso, solo su ingreso.
Como 60,000.
Around 60,000.
He's not going to qualify for the services of public.
No va a calificar para los servicios del abogado de oficio.
Paying a private attorney to represent you, sir, or thought about that?
¿Puede contratar a un abogado privado que lo represente o
Sí.
piensa contratar a uno? ¿Ya lo ha pensado?
Sí, voy a contratar a un abogado de oficio.
Yes, I'm going to hire a public defender.
You don't
Oh,
hire-
privado.
Private.
Okay, have you spoken to anybody?
¿Ya ha hablado con alguien?
Sí, creo que sí, mi familia me está...
And when are they going to be?
Yes, I think so. My family is. ¿Y cuándo van a presentarse?
Hoy debería presentarse.
They should be here
Zoom.
today by Zoom.
What's the name of the lawyer?
¿Cómo se llama el abogado?
No sé porque no he podido hablar con mi familia, no me
I
dijeron el nombre.
don't know because I haven't been able to speak to my family. They didn't tell me.
Well, twofold. He obviously doesn't qualify based on preliminary inquiry by this court for the services of public defender. He says the family has been speaking about hiring an attorney, but he doesn't know because he hasn't had that conversation as of yet, but they have been speaking to. So what is the preference of the state in this position to, you know, he needs a lawyer entitled to have one.
We can reset it. So you can bring in an attorney. Also, it's a little problematic because there's a domestic violence case and it looks like his mom lives at the same location. So we should see whether or not she wants a stay away order.
Obviamente no va a calificar para los abogados de oficio. La familia ha estado hablando de que contratarán un abogado, pero él no sabe, pero sí lo han estado hablando. Pero, ¿qué vamos a hacer? Necesita un abogado, tiene derecho a un abogado. La fiscal dice, bueno, podemos programarlo para otra fecha, pero también hay un poco problemático aquí porque hay caso de violencia familiar. Su mamá vive en la misma residencia que él.
Okay. You were going to say, Ms. Corey, something? I'm sorry.
No, Judge, I was just looking to see if his mother was here. I don't see her logged in.
Buscaban a ver si la mamá se encuentra aquí, no la veo.
Sir, do you think you'd be able to contact your family to your attorney can be here tomorrow morning?
Señor, ¿cree que se pueda comunicar con su familia para que su abogado se presente aquí mañana?
Una amiga, sí.
He has a friend here, Judge. If I can promote, perhaps she'll have information.
Okay.
Ms. Valle, if you can accept, please.
Valle, por favor, acepte.
She's rejoining.
Buenos días.
Good morning.
You speak English?
¿Usted
No.
habla inglés?
No.
No.
And who are you, ma'am? What is
¿Y
your name?
usted quién es? ¿Cuál es su nombre?
Mi nombre es Rosanela Valle, yo soy la cuñada del señor Wilson Muñoz.
My name is Rosalena Vale, and I'm Mr. Muñoz's sister-in-law.
Okay. Have you or do you know if Mr. Munoz has a private lawyer to represent him in this case?
Usted o usted sabe, no necesita intérprete, pero espere para el señor interpretarle. ¿Usted o usted sabe si la familia del Muñoz ha contratado a un abogado privado que lo represente?
Sí, tenemos un abogado privado para él, estamos tratando de que se conecte a la reunión.
Yes, we have a private attorney for him. We're trying to get him to connect to the meeting.
What is the name of the attorney?
¿Cuál es el nombre del abogado?
El señor se llama, ya le digo, Miguel San Pedro.
His name is, let me tell you, Miguel San Pedro.
He's not on the, I'm being told he's not part of the Zoom.
Me indican que no es parte del Zoom, de la reunión de Zoom.
Okay.
Question.
Una pregunta.
Is there a possibility that, number one, Mr. San Pedro may appear this afternoon on the calendar or tomorrow morning?
Pregunta, ¿es posible que el abogado San Pedro podría presentarse en una audiencia esta tarde o mañana por la mañana?
Sí, podemos hacerlo esta tarde.
Yes, we could do it this afternoon.
All right. Then it's going to be reset. Make sure that he has all the information so he can appear by Zoom this afternoon. Okay?
Okay, se programará para otra fecha. Vamos a asegúrese que él tenga toda la información para que se presente por Zoom esta tarde, ¿ok?
Also, if your mother-in-law wants to have contact with him, she's got to log on to Zoom.
Y también si su suegra quiere tener contacto con él, ella tiene que conectarse a Zoom.
Sí, ella se puede conectar. Queríamos dejar claro que fue solo algo del momento, que estamos todos apoyando a Wilson y que tenemos la posibilidad de que él esté con nosotros en otro lugar si no puede estar en este momento.
Yes, it's just something that just happened at that moment, but we're all here supporting Wilson, and there is another place where he can stay if he's not able to stay here at this time.
We'll set this for the afternoon.
Programaremos esto para la tarde.
Right. Juan Oro Pesarosa.
Spanish interpreter, please.
Yo seré su intérprete, señor.
All right, good afternoon, sir. You are, it's alleged that you have committed the offenses of battery on a person 65 years of age or older.
Señor, buenas tardes. Se alega que usted cometió el delito de agresión física contra una persona mayor de 65 años de edad.
One count of simple assault, domestic in nature.
Un cargo de agresión física de índole familiar.
And one count of criminal mischief, less than $200, but more than 1,000. I'm sorry, I got it backwards. More than 200, but less than 1,000.
Y un cargo de daños a propiedad ajena con la cantidad de daños de más de 200, pero menos de $1,000.
Okay, the alleged victim is Roberto Proenza, which appears to be your stepfather.
La presunta víctima es Roberto Proenza, que parece ser su padrastro.
All right, the public defender's office has been appointed to represent you. I'm going to take a look at the A form and then we're going to determine your bond status.
Bueno, hemos nombrado a los abogados de oficio que lo representen. Voy a revisar el formulario de arresto y determinaremos la cantidad de fianza.
Okay. Any argument either side?
Yes, Judge, there's no age in count one.
¿Algún argumento? Sí, juez, dice la abogada defensora. No hay edad.
I agree.
And no value for count three.
Estoy de acuerdo y no hay valor por cargo número 3.
I don't think they live together currently.
No creo que actualmente vivan juntos.
So really you're left with a simple battery.
Entonces es una simple agresión física.
There's no value for the criminal mischief either.
Y tampoco hay valor por el daño a la propiedad ajena.
Meters. Okay. Simple battery, $1,000 count one.
Agresión física, $1,000, cargo número 1.
On count two, $250.
Cargo número 2, $250.
And count three, $100.
Y cargo 3, digo, $100.
All right, so this total bond is $1,350. Now,
Entonces el total de su fianza, $1,350.
part of the conditions of this release, if he's able to boast the bond, is that he not have any contact, direct or indirect, with Mr. Proenza, the alleged victim in the case.
Ahora, si parte de su libertad condicional es que no puede tener ningún contacto directo ni indirecto con el señor Provenza, que es la víctima en el caso.
You understand that, sir?
¿Entiende usted eso, señor?
Sí, lo entiendo.
Yes, I understand.
For indirect contact, you can't reach him through social media, through third persons. You have to stay at least 500 feet away from his home, place of employment, or school at all times. Do you understand that?
Entonces, no contacto significa no contacto, ni a través de redes sociales, ni a través de terceros. En todo momento tiene que permanecer por lo menos 500 pies alejado de él, su residencia, su lugar de empleo, su escuela. ¿Usted entiende eso?
The reason why the bond has been reduced from the statutory amount is because there's no indicia in the A form of the age of the alleged victim.
Y si la cantidad de fianza se ha reducido más bajo de lo que requiere el estatuto, es porque no hay indicios de de la edad de la presunta víctima.
Do you have any items of personality that are located at the victim's home that you need to retrieve?
¿Tiene alguna propiedad, pertenencias en la casa de la víctima que usted necesita retirar?
No, no, yo vivo separado.
No, no, I live separate from them.
Then stay away from them, okay?
Entonces manténgase alejado. ¿Está bien?
Está bien.
All right.
All right.
Next case is, Orvisios Bain. Is this Mr. Bain? Good afternoon, sir.
Good afternoon.
All right. You are accused of having committed the offense of possession with intent to sell crack cocaine, one count of possession of crack cocaine, and one count of possession of cannabis, 20 grams or less, in the vicinity of Northwest 29th Avenue and 43rd Terrace. I've appointed the Public Defender's Office to represent you. I'm going to be taking a look at the A form to determine your bond status. And he's not on probation, right?
Correct. It looks like he just did
Modified.
120 to close out, yeah, his probation. They let him keep the withhold. That's why it's a modification, not a revocation.
So this is pursuant to a traffic stop as well.
There's a lot of drugs.
75, yeah.
So if you're would split the bond or just set the bond on count one.
They're signing it as a third.
It shouldn't be, count one shouldn't be an attempt. It's a completed possession with intent.
All right, count one, 2,500, count two, 2,500, count three, 500. Jermaine Laurent.
There's an added charge. He also has a fugitive hold from Broward, no bond.
Hold on. Is it mad at charge? I have 3 cases for him. So fugitive warrant from Broward. Okay, so 3 cases that I have for this gentleman are the following. I have F 25-6196 for strong arm robbery that supposedly took place on March 24th in the vicinity of 3303 Northwest 167th Street in Miami Gardens. That's the 96, the alleged, hold on. 96. Who's the alleged victim on that? Because I have an address, but I don't have a victim.
And 96?
96, yes. You have a stay away order.
It's Northern Tool.
Uh-huh.
If I forgot to write it in.
I have more than two, that he's supposed to stay away from that area, but where it says the person, a victim, there is no name.
So the listed victim in that case is Mario. Last name LeBlanc. Leblanc.
Leblanc?
Yes.
Okay. All right, so that's so Mr. Laurent, the alleged victim is Mario LeBlanc, and supposedly this occurred at this Northern Tool located at 3303 Northwest 167th Street. That's one case, okay? The other case, which is F256197, you're alleged to have committed armed robbery with a weapon, first-degree felony. And this was also at this Northern Tool place, 3300, but this goes back to December 10th of 2024. Let me see if I have any paperwork on that. 6197. Oh, and this one you have, the state has filed a motion for pretrial detention on this first-degree felony punishable by life, asking the court to hold you no bond. I don't have the name of a victim on that one also, it just says Northern Tool, same thing. Who's the person on that one?
One second, let me see. That is gonna be, I don't have a name for the victim.
No? Okay. No. Okay, so that's that one. And the third case is F256221, which is retail theft. But this isn't a felony amount, and the alleged victim is Harbor Freight. And that's a third-degree felony. It says suffered a loss of $1,300 in merchandise. Okay. All right, I've appointed the public defender's office. And you said these were added charges, corrections?
Yes, Your Honor.
All right, well, then we'll start with the 6196. The strong arm robbery.
So Judge, in that case, I would ask you to find probable cause for grand theft.
It's okay. It talks about an aggressive posture as the force. It's a little vague.
Yeah, what?
Grand theft, a third-degree felony?
Yes. There's a value, $1,150.
Standard bond on that is
$2,500.
$500 with a stay away order.
You said 2,500?
2,500 with a stay away order. Okay, and that's Mario LeBlanc. Can't have any contact, direct or indirect, sir. And you have to stay at least 500 feet away from him and away from Northern Tool. Okay, that's that one. The next case, which is F256197, that's the one that the state of Florida has filed a motion for pretrial detention. The allegations are that he committed armed robbery.
So Judge, in that case, there's no indication of any weapon being seen or utilized. There's no weapon recovered. I would ask that Your Honor find probable cause for a strong arm robbery, which is a second-degree felony.
The only reference stated is that he claims to have stated that he had a gun.
Judge, based on, I'll agree with counsel's arguments.
You will what? I'm sorry.
It's an implied weapon, I agree. So it should be a strong arm.
Okay. So your motion?
I'll withdraw it.
You'll withdraw it, okay. Bond on that one is set at $7,500, and PC for a strong arm robbery. With a stay away order. So on that, I don't have the name of the victim, but he has to stay away from this northern tool located at 3303 Northwest 167th Street, and the state withdraws a motion for pretrial detention. And then the last one, which is the retail theft felony in nature. Okay, so here. This is from a Harbor Freight store. And they're saying that the, I think the loss was like at $1,300. $2,500 bond plus a stay away order. And he has a fugitive warrant from Broward with no bond. Okay. Next case is Don Trey Blackshear. Blackshear. Is this Mr. Blackshear?
Yes, ma'am.
Sir, I have an ink form here. This is it on January 19th of this year in the vicinity. Okay, all right. So Ms. Blackshear, sorry for the interruption. It's alleged that on January 19th of 2025 in the Marathon gas station located at 6650 Northwest 7th Avenue in Miami, you committed the offense of, it says here, possession with intent to sell cannabis within 1,000 feet of a church or school, I think is what it is, and which is a secondary felony, possession of, well, actually petty theft, previous conviction, first degree misdemeanor, and criminal mischief, $200 or less, or attempted criminal mischief, second degree misdemeanor. He has, does he have something else? Another?
A misdemeanor?
Yes, petty theft.
Okay, but it's the same case.
Separate.
Incident that occurred on, let's say.
Because it says
He was arrested for both at the same time. So it's probably the same exact case, Judge. Yes, I think. And Judge, on count one, it's one baggie of marijuana. I don't know why they say it's possession with intent. It just should be possession.
I agree, Miss Corey.
What did you say? No, what did he say? Huh. Okay. Sir, you need to conduct yourself accordingly. You're in court. Be respectful, please. Okay, so you were saying.
Wait, so just possession on count one.
And then the convictions on the petty theft. Let me just see.
It references it.
All right, count one. Simple possession, so that's 2,500.
Misdemeanor.
I can't hear you.
It's marijuana. It's a misdemeanor.
I thought you're correct. So that's M1. So that's.
Would you do $1 bond for the marijuana, Judge? It's one baggie. I don't even know if the state even prosecutes those anymore.
I'm sorry, I didn't hear what you said. Did you want the state what, or would I what? I didn't hear you.
So Ms. Corey's asking for $1 on the cannabis. That's fine. I'm not sure if we file these cases.
Well, instead of going through this, is this the only thing that this guy has? I mean.
There's PC for the petty theft and the criminal mischief too.
Cannabis, all right, hold on. I'm not gonna put it all, okay? It's gonna be $500 on first count. Number two, $500. Number three, $100. His total bond is $1,100.
Judge, Mr. Blackshear is homeless. Would Your Honor consider the TAP program for him?
No, ma'am. And he needs to stay away from this Marathon gas station.
Well, okay.
Next case is Luis Ruiz Nunez.
Spanish interpreter, please.
Yo seré su intérprete.
Good afternoon, sir. Mr. Ruiz Nunez, you're here before the court because it's alleged that on March 18th of this year, in the vicinity of, not sure which one, because it has two addresses here. They're both in Hialeah. You committed the following offenses: 3 counts of possession with intent to sell or manufacture a controlled substance, that being crystal meth; 1 count of possession with intent to sell butanol; and 1 count of possession of drug paraphernalia with intent to use it.
Entonces, señor, se alega que el 18 de marzo de este año, no sé en dónde exactamente, porque incluyen aquí 2 direcciones, pero usted se le acusa de lo siguiente: de tenencia de adminículos para el uso de drogas con la intención de utilizarlos, 1 cargo de tenencia de mutenenol y 3 cargos de tenencia con intención de vender o fabricar metanfetamina en cristal.
Argument on this, please.
¿Algún argumento?
One moment, Judge, I'm still reading.
Un momento, juez. Sigo leyendo.
So, Judge, and he's charged with 3 counts of possession with intent of the meth. I would ask it just find probable cause for on count 3 of that possession of meth.
That's okay. It's for what they found as a result of the search warrant.
And I'm not sure what Lieutenant is. One moment.
Pido que solo lo haya que motivo fundado para 3 cargos de tenencia de metanfetamina. La fiscal dice, está bien, creo que surgió por la orden de arresto, por la orden de saqueo, de búsqueda.
But the argument is possession or possession with intent to sell. Because that's how it counts.
So he sold to a CI twice. And then there was what was found at the house. If you want to find just possession for what was found at the house.
Entonces, 2 veces le vendió a un informante confidencial y luego hay lo que encontraron en la casa. Si usted haya que solo hay motivo fundado para lo que se halló en la casa.
And Judge, it looks like butandiol is an industrial chemical.
I have no idea what that is.
Juez, dice la abogada de oficio, buteniol es un químico para limpieza. No tengo idea de lo que es, dice la juez.
Do you know, Madam State?
It says it's used as a substitute for GHB, so I believe it does have, it is a narcotic.
¿Qué dice la fiscalía? Dice aquí que se usa para sustituir a GHB, así que sí, es un narcótico.
Do we know?
1 second.
Sabemos, un segundo, dice la fiscal.
So, let's see. Right, a recreational drug with euphoric sedative effects.
Sí, es una droga que se usa de manera recreacional con efectos eufóricos y como sedante.
possession of that, because this is charged with possession with intent to sell, manufacture, et cetera, et cetera.
No estoy segura, dice la juez, porque esto es lo acusan de tenencia con intención de vender, fabricar, etcétera.
Judge, I don't know if it's specifically listed as a controlled substance.
It is?
I don't think it is.
No sé si lo incluyen en la lista de sustancias reguladas, juez.
I'm okay with $1 on that charge.
Estoy de acuerdo si le quiere dar $1 de fianza en ese cargo.
Nothing.
All right, count 1, simple possession, $2,500. Counts 2 and 3, $1 each. Count 4, $1. Count 5, $500.
Entonces, cargo número 1, tenencia, simple tenencia, 2,500. Cargo 2, 3 y 4, $1 de fianza. Cargo 5, $500 de fianza.
So the total bond is $3,003.
3,003 es la fianza total.
Sorry, Judge, I missed the bond. Your Honor didn't set the standard for possession with intent for the sales to the CI.
No, I said simple possession.
When he
Wait.
sold to a confidential informant,
I thought you said that you agreed to 1 count of simple possession.
on that 1 count for what they found at the house.
Y que de los cargos cuando le vendió al informante confidencial, ¿no? Creí que dijo usted, fiscal, que solo que estaba de acuerdo que solo de un cargo. No.
So
Con lo
the
que... Go ahead.
That's what I said. Okay.
Es lo que dije,
Lower
¿ok?
state's objection.
Se opone la fiscalía.
Absolutely. Okay. Next case is, let me see here, Jonathan McKinley. This is Mr. McKinley. Good afternoon, sir.
Good afternoon, ma'am.
You are before the court, sir, because it's alleged that on March 26, 2025, in the vicinity of 29931 Southwest 149th Avenue, you committed the offense of burglary of an occupied dwelling and burglary of an unoccupied dwelling. I've appointed the Public Defender's Office to represent you. The alleged victims are Lorraine Tomlin. And again, the address is 29931 Southwest 149th Avenue in Miami. Okay. Let me read the A form so that we can determine your bond status. Argument, please.
No argument, Judge.
Counts 1 and 2 each, $7,500 bond with a stay away order. Mr. McKinney, and if you're able to post the bond, sir, one of the conditions is that you cannot have any contact, direct or indirect, with Lorraine Tomlin. Okay, that means you have to stay at least 500 feet away from her. No contact in person, through third parties, in writing, by telephone, pager, or through social media of any type. And stay away from the area described as 29931 Southwest 149th Avenue in Miami. Do you understand that?
Yes, ma'am.
Okay. Cannot, part of the conditions of your release also is that you cannot engage in any criminal activity. You cannot use or possess any illegal drugs. You cannot use or possess any firearms, guns, weapons, or ammunitions. And if you have any of these, you have to surrender them to the local police department, get a receipt, and file it with the court. Again, no contact with Lorraine Tomlin. And that's it. You understand that, sir?
Yes, ma'am.
Okay, back to you, sir. Carlos Quintela, I'm sorry.
We handled that.
We did?
Private attorney, yep.
Right. The next one is Karine Brinson.
Present.
Morning.
All right. Good afternoon, Mr. Brinson.
Good afternoon, Your Honor.
All right, you have, in this case, it's alleged that on March 19th of this year in the vicinity of 1007 Northwest 27th Avenue, you committed the offenses of possession of a firearm or weapon or ammunition by a convicted felon, aggravated assault with a deadly weapon, and improper exhibition of a weapon or firearm. Actually, 2 counts. There are 2 counts of possession of a firearm or weapon by a convicted felon and 2 counts of aggravated assault with a deadly weapon and 1 count of improper exhibition of a weapon or firearm. I've appointed the public defender's office to represent you. I'm going to take a look at this arrest affidavit and determine your bond status, sir. The victim, reported victim, at least 2 of them, of the aggravated assault have initials DT and BR. Any argument?
No, Judge.
Mr. Brinson, do you work, sir?
Yes, ma'am.
What do you do for a living?
I pick up scrap metal, ma'am.
Okay. All right, I reviewed the arrest affidavits. I'm going to find probable cause as charged as to count 1 and 2, $7,500 each count. Count 3, $5,000 each, 3 and 4. Count 5, $500. So that's count 1, $7,500, count 2, $7,500, count 3, $5,000, count 4, $5,000, count 5, $500. There's a stay away order on each of these alleged victims, BR and DT. Sir, I need you to understand that if you're able to post the bond, you cannot have any contact. You have to stay at least 500 feet away from each of these victims and their respective property. That means no contact, direct or indirect, with the persons by pager, fax, or social media. Do you understand that? And I'm gonna put him on a GPS monitoring device. With which category is the one that allows him to go to work?
2 or 3.
Which is the difference between 2 and 3?
3 is roaming, 2 would allow him to go to work.
Okay, then it's number 2.
So Judge, since they're neighbors, can Mr. Brinson go back with the police to go get his belongings?
Yes, you can. Which one is it? This is on the, I don't have any, there's no provision in this particular stay away order that I got, but if he has any property, personal that needs to take, he can go there with law enforcement officer. One time. All right, next one is
Okay, so he's able to go one time with the police.
with the enforcement officer. Daniel Pay. I have your prior refusal on Mr. Pay. Mr. Pay, good afternoon.
Good afternoon.
All right, you're before the court because it's alleged that on March 25th of this year, in the vicinity of 601 Northwest 2nd Avenue, in Miami, you committed the following offenses, sir. 1 count of attempted strong arm robbery, 1 count of aggravated battery over a person on a person 65 years of age or older, and 1 count of resisting an officer without violence to his person. I've appointed the public defender's office to represent you. I'm going to be taking a look at the arrest affidavit to determine your bond status. And the alleged victim's name is Ismael Peralta. All right, there's no age as to, did I miss this, as to the alleged victim?
Right, no age, that's correct.
Right, and it's not aggravated battery.
Right. All right. Count 1. It's going to be $5,000. Count 2 is going to be a simple battery. So that's M1. Count 1, 5,000, count 2, 500, count 3, 500, and stay away with it.
Okay, so your bond is 6,000. It's gonna cost 600 to a bondsman to get out. All right, call a bondsman, get on out. This is the number for your lawyer. Stay out of trouble and come back to court in 1 month, okay?
Yeah. What do you mean? I call a bondman
And tell them you got a $6,000 bond. They're gonna ask for 600 bucks. Okay, I'll get you out with
Where do I
600.
get the money?
Call a family or friend and see if they can post it for you, okay?
And when do I get out?
After you post your bond.
Wait, will I ever get out even though I don't pay for it?
You eventually get out, but it's probably gonna be, if you don't have money, you have to talk to your lawyer, okay?
Is this Mr. Rio? Do you speak English? Okay. All right, Mr. Rio, you're before the court. It's alleged that on March 26, you committed the following offenses in the vicinity of 2434 Northwest 66th Street. 1 count of aggravated stalking, 1 count of domestic violation of a domestic violence injunction, 1 count of a threatening phone call, 1 count of misuse of an emergency communications, a 911. Okay, the alleged victim in this case is Ashanta Ryu. I've appointed the public defender's office to represent you. Let me take a look at this arrest affidavit so we can determine your bond status. Sir.
He also has a domestic violence warrant, no bond.
Okay. Do you have a case number on that or not?
It's DVW 23-288.
Here in Dade County? Is it here, a Dade County case?
Yes, Your Honor.
Thank you. Argument, please.
Judge, it doesn't appear to rise to level of an aggravated stalking.
So he keeps on calling 911, but I think he only called the victim once.
This is a sibling type of thing, domestic. I just don't see how. This simple stalking is what, a first degree misdemeanor?
Yes.
This A form, it could be a lot more specific. Count 2, violation of a domestic violence injunction. I only have, I have missing, these A forms are missing certain pages, so I only have page 1 and then it goes to page 3. What is the restraining order, case number 2023-10568?
Yes.
Okay. And then count 3, which is the threatening phone call.
I think those are the phone calls to 911.
Then you have the other misuse of a 911 communication.
Yes.
All right. On count 1, I make finding as to just regular stalking, that's $1,000. Count 2, violation of domestic violence injunction, $1,000. Count 3, $100. Count 4, no PC. RR him in that one.
No PC release outright.
Outright on that count. Okay. If he's able to post the bond, he's going to be on a GPS monitoring device. Do you work, sir?
No, I don't. I pick up job gigs off of bacon and instant work.
You do what?
I pick up job gigs off of bacon and instant work.
Okay. All right. So you're not working. Okay.
Not technically, but
There's a stay away order if you're able to post the bond, sir, and resolve the other hold that you have on the domestic violence injunction. You cannot go anywhere near the alleged victim in the case, your sister, Ashanta Reed. Do you understand that, sir?
Yes, ma'am.
That means no direct or indirect contact, no calling her, no sending somebody else to talk to her, no electronic or social media, not in writing, no contact. You have to stay at least 500 feet away from her. Do you understand that? Yes?
Yes, ma'am.
Okay. You cannot use or engage in any criminal activity. You cannot use or possess any illegal drugs. You can't have any guns or ammunition. If you have any, you have to turn them into the police department and get a receipt and file it with the court. Do you understand that?
Yes, ma'am.
It's the level for work only. Okay, so that's number 2.
And it's plus house arrest on everything, correct?
Yes, level 2. Good luck to you, sir. Next case is Gene Hitchens. Is this Mr. Hitchens?
Yes, Judge.
Good afternoon, Mr. Hitchens. It is alleged that on February the 3rd of this year, in the vicinity of 14025 Northwest 27th Avenue in Opelika, you committed the offense of strong arm robbery, 1 count burglary of an unoccupied conveyance, and 1 count of petty theft. The alleged victim, I have 2, is initials RC and ST. Okay, I'm gonna take a look at the arrest affidavit to determine your bond status. Okay, state, address the burglary of an unoccupied conveyance.
It looks like he took the items from the truck.
The who?
He took the items from the truck.
Who? Which in the first instance, the turkey wings?
Yeah.
Okay. But he's charged with strong arm robbery.
So, because the victim tried to stop him from leaving and the defendant punched the victim.
Right.
There's PC for both.
But he's not charged with battery. He's charged with strong arm robbery, burglary of an unoccupied conveyance, and petty theft.
Strong arm robbery encompasses violence, which is the punch.
Yes. I'm just trying to discern where the conveyance is as opposed to taking the wings. Burglary of an unoccupied conveyance. Okay.
So, I mean, I think he took it out of the truck. If it's unclear.
It doesn't state that, Judge. I'm okay if you split a bond for the strong arm robbery among the counts, Judge.
Count one, $4,500, count two, $3,000, count three, $250 with a stay away order. Next case is Osvaldo Garcia.
Mr. Garcia is present. He speaks English.
Okay, Mr. Garcia, good afternoon, sir. My understanding is he is on probation, out on probation in case number F209490 out of Division 1, so he'll have a hold on that case. In this case, Mr. Garcia, it's alleged that you committed the offense of 2 or more convictions of petty theft, which is a third-degree felony in the vicinity of 7535 North Kendall Drive, which is known as Macy's. Okay, I've appointed the public defender's office to represent you. Let me take a look at the A form.
See any allegations of prior convictions?
What's his prior convictions? I
Right,
don't-
so, and it said exactly 100, so an M2 is fine.
So that is $250. No, actually, $100. And a stay away order. Sir, if you're able to post bond, you have to stay away from Macy's. You understand that?
Can't stay away from Macy's.
Can't go back.
Yeah, you said the bundle was $100?
Next case is Will. Did we miss something here? I have here Will Feliciano. Did we skip it? Bond out? Okay. Delbert Finley,
Wordy,
still worthy.
yes.
So reset the when. They just reset.
Reset it from calendar to calendar, Your Honor. PM.
There's something missing here. Is this colleague? No, what I have here in front of me is Irving Johnson. Irving Johnson on bar page 19.
Number 55 corrections.
And this year.
Not before court. This is not a charge. Let me see what it is. Burglary with assault and battery PBL. There's a. So he's not before the court. What do you want to do on this?
I'm okay waiving his presence.
Johnny would make a note to
stated.
get the stay away order in division.
Okay, all right. So the added charges it appears are burglary with assault and battery therein, punishable by life, and written threats to kill or do bodily harm. And this goes back to October 29th of 2022, according to this A form. Victim is brother. Victim 1 is brother and victim 2 is uncle. What are the underlying charges on this, if these are added charges? Petty theft? No.
So he's in on, it looks like an ad, petty thefts as well.
Petty theft and aggravated battery.
Well, there's a motion that you filed on this for pretrial detention on the first count.
Yes.
I can't, okay, so the stay away order stand, he's gonna have no bond on count one. And count two was that $7,500? With, and then stay away in division. Did we leave anything out on this calendar? I think we've, and I need to know from corrections what time you want to be back.
2:30, Your Honor.
30 it is. Okay.
Thank you, Judge.
Thank you. Oh, I need to sign something for you. There was a batch.
No, it's just. Yeah.
What's your number?
All right, good afternoon, everyone. Can you hear me? Can
Good
they hear
afternoon,
me?
Judge.
Oh, there it is. Okay. I'm Judge Maria Espinosa Dennis. I'll be presiding over the afternoon felony bond hearings. I need everyone to please stand up, raise your right hands to be sworn.
Please raise your right hand. Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? Say I do.
All right, have a seat, please. All right, your appearances for the record.
Nessa Ath on behalf of the state.
Do we have defense here? I thought I saw, there we go. It's Corey. I think her mic might be off.
The interpreter would like to be promoted.
Okay.
Rebecca Corey, Assistant Public Defender. Good afternoon.
Afternoon. Okay. All right. Do we have an interpreter that's going to be assisting us this afternoon?
They need to be promoted.
Okay, we also need to promote the interpreter. Got him?
Good
Okay, terrific.
afternoon, interpreter present.
Good afternoon, Madam Interpreter. Have you been sworn today?
No,
Okay, Madam Clerk, would you please swear in the interpreter?
Do you swear that you will well and faithfully interpret from English to Spanish, Spanish to English, the questions asked and the answers given to the best of your ability, and that you have such ability? Say I do.
I do, Maria Pozueta, court interpreter.
Thank you very much. Okay, I think we're ready to start. The first person on the calendar is Amanda Martinez.
Judge, corrections is asking to take one out of turn on page 2. It's Fernando Herrera.
Okay, let's see here.
Yes, please.
Herrera, yes, number 7. Okay.
I also have an officer present for PCH corrections whenever you have a chance, Wilson Munoz Suarez.
And we have a lot of private attorneys, Judge. We have 1, 2, 3, 4, 5 private attorneys.
If not, these calendars. Okay, so I have Fernando Herrera, the form. Okay, I have the paperwork.
Mr. Herrera is present.
Mr. Herrera?
Yes, Your Honor.
Sir. All right, I have here an affidavit warrant that basically says that on March 26th of 2025, in the vicinity of 12513 Southwest 147th Terrace, you committed the offense of battery on a person over the age of 65 years, okay? Which is a third-degree felony. I've appointed the public defender's office.
I'm not sure if he's going to qualify for a PD based upon his occupation. I see no criminal history. I think there's probable cause. I don't know if he'll waive an attorney and Your Honor will just set the bond and issue the stay away order.
Okay. And your occupation is, sir?
I'm sorry, could you repeat that, Your Honor?
For a living.
What do you do for a living?
I'm a firefighter.
And how much did you make last year?
I made 72,000.
So, you're not going to qualify for the service of public defender, it looks like. I haven't even inquired about assets, but based on income alone. Have you retained or are you in the process of retaining a private lawyer?
I'm in the process now. I'm going to be searching for.
Okay, all right. So for purposes of, would you, Ms. Corey, would you assist as a friend of the court in the process so that we can just address the bond status?
Yes, Judge.
Okay. So, like I said, charges are battery on a person over the age of 65. I'm going to take a look at the arrest affidavit and review it to determine probable cause and address your bond status. All right, Mr. Ojeda? Hold on a second. Okay. All right, the alleged victim's name is Fernando Cardenas, okay? All right, Mr. Herrera, what I'm gonna do is I make a finding that there is probable cause, sir. So what I'm gonna do is I'm going to set bond at $5,000, okay? And I'm gonna enter a stay away order. That means no contact. Out of the conditions of your release are you to have no contact with the alleged victim in the case, who is Fernando Cardenas, which means no direct or indirect contact, whether in person, in writing, through third parties, by telephone, pager, or social media. You have to stay at least 500 feet away from this gentleman. You understand that? I can't hear you. I guess that's a yes. I think the mic is off.
Completely understood, Your Honor.
So then that's your bond. Good luck to you, sir. And next time you need to bring your attorney, okay?
Okay, thank you.
What was the other one that needed to be called out of turn?
We could please call Wilson Munoz Suarez.
What page, Nessa?
Who are we calling?
Page 6, Wilson Munoz Suarez. He has private counsel Miguel San Pedro. I will promote.
So this is page 6. Thank you.
And you know, Judge, that wasn't the case that I needed, but it's fine. We can take the case that I needed and fix this for you. Hold on.
But is the one we're gonna do the Munoz?
I need Raul Hernandez on 10. So if we can do that one after. Ms. Corey, you a co-host?
¿Cómo se llama la familia que está en la línea?
So this is Mr. Munoz Suarez, and yes, I'm a co-host.
Okay, so if you can help out.
Good afternoon, sir.
Good morning, Your Honor. Miguel San Pedro, good afternoon on his behalf.
That's wishful
I was
thinking.
here earlier, and they asked me to, the family has retained me for the hearing today.
Correct.
I believe there's family members also on Zoom and another computer elsewhere. And I think that the court inquired as to whether his mother was available, and she is available if the court wants to inquire of her.
Separate cases. He has case number 256178, where it's alleged that he committed the offense of practicing medicine without a license, that being a third-degree felony, on December 12th.
He'll need the Spanish interpreter, Judge.
Oh, okay. Doesn't speak English. I'm sorry, I didn't know. I recall if we used an interpreter. Madam Interpreter?
Interpreter present.
Okay, what I'm advising counsel is that he has, this gentleman, the defendant, Mr. Munoz Suarez, has 2 cases.
Señor, usted tiene 2 casos. Your Honor, you sound choppy. Just letting you know.
Okay, I can hear you. I don't know.
I can't hear you very well. That's
Okay, well, is anybody else having a problem hearing me?
That's better.
Okay. So he has 2 cases. The first case is 25-6178, which alleges he has committed the offense of practicing medicine without a license, which is a third-degree felony.
Okay. El primer caso, que termina en 7-8, se le imputa practicar la medicina sin tener una licencia. Es un delito mayor en tercer grado.
Okay. The other case, which ends in 6179, it is alleged that he has committed the offense of 1 count of battery on a person 65 years of age and older, 1 count of simple domestic violence, battery, and 1 count of resisting an officer without violence to his person.
Okay. El segundo cargo se le imputa, número 1, agresión física, que termina, perdón, en 6179, se le imputa en primer lugar agresión física a una persona de 65 años o mayor. El segundo cargo es violencia doméstica simple con agresión física también. Y el en tercer lugar, tiene un cargo de resistirse a un policía sin violencia.
And the alleged victim on this, for this battery, is Margarita Suarez, who is a relative, I believe, the mother of the defendant.
Y la presunta víctima en este caso es Margarita Suárez, que creo que es la madre del acusado.
And this is the victim that the state of Florida had discussed about potentially having her appear and advise what her position was with regards to the stay away order.
Y es la víctima que potencialmente, bueno, la Fiscalía del Estado de la Florida se había planteado traerla aquí para ver cuál era su postura respecto a la orden de alejamiento.
Right. Is she available, Mr. San Pedro?
I understand she's available. They have asked to appear. They raised her hand.
Can they write in the chat so we know who to promote?
Okay.
In Spanish.
Bueno, se le
We're
está,
texting them now to write into the chat something.
okay, se está localizando a esta persona.
Okay, so well,
El nombre de María Suárez, por favor. Leal.
María Suárez, no es Margarita, es María.
Margarita María. Margarita, you're correct. It's Margarita Suárez Leal.
All right, so while we wait for Ms. Suarez.
Ms. Corey, can you promote her? She's under iPhone.
Bueno, parece que está en su...
Just accept the, let me try one more time. She needs to accept the promotion. She's rejoining.
Ay, vieron.
Apareció.
Okay. Ma'am, I think, what is your name?
Señora, ¿cómo se llama?
Margarita Suárez Leal.
Margarita Suárez Leal.
Okay, and how are you related to Mr. Wilson Muñoz Suarez?
¿Cuál es el parentesco con el señor Wilson Muñoz Suárez?
No, él es mi hijo.
He's my son.
All right, Madam State, you conduct the inquiry, you have the concerns.
Sure. So, ma'am, do you live with your son?
Señora, ¿vive con su hijo?
Si vives con Wilson.
Sí, vivo con él.
Yes, I live with him.
Vivimos los dos solos aquí en la casa.
It's just the two of us here in this house.
Are you afraid of him?
¿Tiene miedo de él?
Que si tienes miedo de él.
No, no, él es muy bueno. Él me acarició cuando se fue, me puso la mano en el hombro. No, él es el mejor.
No, he's very good. He's very good. He petted me before he left. He put his hand on my shoulder. He's really good.
Do you want him to come back home?
¿Quiere que vuelva a la casa?
Que si quieres que vuelva a la casa.
Claro, lo estoy esperando. Ay, Dios mío, yo no he dormido ni nada esperándolo.
Of course, I'm waiting for him. Oh my God, I haven't been able to sleep waiting for him.
Does he take care of you?
¿Le cuida? ¿La cuida
De que
usted?
si él la cuida a usted.
Sí, él es el que me cuida y me hace el almuercito y todo.
He's the one that takes care of me, makes my lunch and everything.
And ma'am, how old are you?
Y señora, ¿cuántos años tiene usted?
¿Cuántos años tienes tú?
Tengo 89.
89.
Okay. And has he ever put his hands on you before?
¿Alguna vez le ha puesto la mano encima, señora?
¿Alguna vez te ha puesto la mano encima?
No, ni me ha hablado duro ni nada.
No, he hasn't speak badly to me or anything like that.
I don't have any more questions. I don't know if the court does or counsel.
No tengo más preguntas.
Your Honor, what I know from the family is that apparently at the moment of him being walked out by the police, he grabbed her arm kind of like to say goodbye, and I don't know, maybe there was a misunderstanding what was going on, but I don't.
Bueno, yo lo que tengo entendido por la familia es que cuando le arrestó la policía, él puso su mano sobre ella para decirle adiós y a lo mejor hubo un malentendido ahí.
I mean, the officers characterized it differently.
Excuse me, counsel, can you repeat your sentence,
The
please?
officers characterized it differently. They didn't see
Sí,
it.
oh, thank you. Sí, la policía lo caracteriza de manera diferente, esto.
All right. Okay, with regards to the probable cause on those counts in that case, any argument, Mr. San Pedro, in that regard?
No, ma'am, no further argument.
En cuanto a los motivos fundados de ambos casos, ¿hay algún argumento por parte del señor San Pedro? El señor San Pedro dice que no.
Anything state?
¿Fiscalía?
No further argument.
No, no hay más argumentos.
He's done everything. Up to you, Honor, whether or not you feel comfortable to modify the stay away order.
No, I don't know what the alleged victim's mental capacity is. All I can do is observe. Clearly, she stated that she does not fear for him, that he is affectionate and caring of her, and they reside in the same place. You know, the court finds probable cause as to all of the counts that have been raised. I'm going to set bond on count 1 at $5,000, count 2 and 3 each $1,000. So his total bond is $7,000. Given, you know,
Excuse me, Your Honor, may interpreter. Go ahead.
Yes, ma'am.
There's 4 counts on
Okay.
that case.
No sé cuál es realmente no sé cuál es la capacidad mental de esta persona. Dice que no le tiene miedo, que él la cuida, que viven juntos. Bueno, hallo que hay motivos fundados para todos los cargos. En el cargo número 1 pongo una fianza de $5,000. En el cargo número 3, $1,000 para cada uno, por lo tanto es un total de $7,000.
Actually, it's $8,000. I left out count 4, corrections pointed out.
Sí, sí, realmente son $8,000 porque se me dejé fuera el cargo número 4.
Now, what I'm going to do is based on the victim's testimony, I'm going to enter what is called a modified stay away order. And,
Basándome en el testimonio de la víctima, voy a emitir lo que se llama una orden de alejamiento modificada.
okay, and I want to explain what the conditions are of his release to Mr. Wilson and also, I'm sorry, to Mr. Munoz and also to the victim in this case.
Le quiero explicar las condiciones de su puesta en libertad con la señora Muñoz.
Okay. First and foremost, as it relates to Mr. Munoz, the conditions of your release are going to be as follows.
En cuanto al señor Muñoz, las condiciones de su puesta en libertad son las siguientes.
Number one, that you cannot engage in any criminal activity.
No puede involucrarse en ninguna actividad delictiva.
Number two, that you cannot use or possess any illegal drugs.
No puede estar en posesión o consumir ninguna droga ilegal.
Okay, that you cannot use or possess any firearms, guns, weapons, or ammunition.
No puede poseer ningún arma de fuego, munición o permiso de armas ocultas.
You must surrender any firearms, ammunition, or concealed weapons permits to the nearest police department and file a receipt with the court.
Debe entregar inmediatamente cualquier arma de fuego, munición o permiso de arma oculta a la comisaría de policía más cercana y presentar un recibo ante el tribunal.
Okay. The defendant will be allowed to have contact with the victim, Margarita Suarez.
Al acusado se le permite tener contacto con la víctima Margarita Suárez,
Okay. But he is prohibited from being physically threatening or violent towards her in any manner whatsoever.
pero se le prohíbe ser físicamente amenazante o violento en contra de ella de ninguna manera posible.
And this is being modified based on the alleged victim's testimony this afternoon, stating that she is not afraid of the defendant.
Y esto se basa en el testimonio de la víctima, de la presunta víctima, de esta tarde, en el que dice que no tiene miedo del acusado.
Any other requests from either side?
Did Your Honor set the bond for the medicine without a license?
Haven't gotten to that one. This is
Okay,
just,
then no.
all right.
La fiscalía pregunta si la jueza ha puesto la fianza por ejercer la medicina, por cargo de ejercer la medicina sin licencia.
Okay, all right, so that's this case. The second case, which is the
Este caso, el segundo caso,
256178, which is practicing medicine without a license. Okay, any arguments with regards to that?
en cuanto al segundo caso de practicar la medicina sin licencia, ¿hay algún argumento al respecto?
No, Your Honor, I would just ask the court to be considerate of the fact that he's already posting an $8,000 bond if the court would reduce the $2,500 bond existing now.
Sí, yo nada más le pediría a su señoría que tuviera en consideración que ella tiene que pagar $8,000 de fianza y que por lo tanto redujera los 2,500.
Okay, one moment. Let me just review this a little carefully. What's the state's position?
¿Cuál es la postura de la fiscalía?
Yeah.
1,500, so maybe a slight reduction, and the defendant shouldn't be performing procedures that you need a medical license for.
La fiscalía opina que el acusado no debería estar practicando procedimientos para los que se necesita una licencia médica.
All right, I'm not going to reduce the bond. I'm going to set bond at $5,000. Okay.
Voy a poner una fianza de $5,000.
There's really nothing else for me to tell him. I mean, these are the charges. He should refrain from conducting or practicing or incorporating himself for the time being on anything having to do with healthcare unless he has a license to do that. Okay.
Okay. Eso le pongo $5,000 de fianza, no hay nada más que pueda decirle, excepto que se tiene que abstener de practicar cualquier tipo de tema de salud, médico, a no ser que tenga una licencia.
Okay. Good luck to you, sir.
Suerte, señor.
What's that that you wanted to call out a term?
The other case, Judge, is. I'm so sorry.
Was it Raul Hernandez?
Yep, on page number 10.
Raul Hernandez. Okay.
He's a private attorney now. It's Dustin Tischler. I will promote him.
He also promotes a detective. Please.
And I'll promote Ariel also.
The detective is Sandoval.
Sandoval.
Good afternoon.
Okay. Good afternoon. I'm not. Okay. All right, Tischler, good afternoon, and we have, I believe this is the witness.
Yes, Your Honor.
All right, let's swear in this witness.
Oh, here, I found him.
Raise your right hand, ma'am. Do you swear that everything you're going to testify here today will be true and correct with penalties of perjury?
Yes, I swear.
Your full name.
Ariel Lobo Montaño.
Thank you. Okay. All right. This is Mr. Hernandez. He speaks English or not? I forgot.
Yes, Judge.
Yes. Okay. Mr. Tischler, you represent Mr. Hernandez, correct?
Yes, Your Honor.
So, Judge, at this point, I would ask that you discharge the public defender's office.
Public defender is discharged. Okay. Thank you. Yeah. Hold on 1 second, because I saw a detective that we lost him 2 seconds ago.
He's actually on mute.
I'm right here, Your Honor.
Okay. All right. Is this Detective Sandoval?
Yes, Your Honor.
All right. Let me just regroup here. So we reset a couple of things from this morning. So Mr. Hernandez is alleged to have committed on February 27th of 2025 in the vicinity of 641 Brickell Key Drive the following offenses. 1 count of burglary of an occupied conveyance, 1 count of aggravated assault with a deadly weapon, 1 count of criminal mischief, more than $200 but less than $1,000, and 1 count of simple battery. Okay. See here, this had to do, oh yes, with the Tesla. Okay. And there were some issues going back and forth with regards to the probable cause. State, did you file on this one? This does not have,
There's no motion, but the state is arguing that there is probable cause for a burglary with a battery.
Battery, there we go, which could rise to the level of an no bond, punishable by life. So then you have the second count, which, okay. And all right, okay, so there was an issue with regards to the victim and who owned the car and what had transpired. So State, do you want to take the lead on this?
Sure. So we could please swear in the detective.
Okay. Raise your right hand, sir. Do you swear and affirm that everything you're going to testify here today will be true and correct under penalties of perjury?
I swear.
And your name, sir?
Detective Edwin Sandoval.
And with what entity are you affiliated?
The City of Miami Police Department.
Okay, go ahead. Counsel?
All right, detective. So initially, the affidavit talks about one of the wheels to the Tesla being punctured. Do you know who punctured the wheel to the Tesla?
On scene, I was I was just told by the witness that the wheel was punctured.
Okay. All right. And when you got on scene, you met with the witness and the victim? Or officers met with the witness and the victim?
I'm sorry, the witness has her mic on, so it's kind of conflicting with your questions.
So maybe if you could just mute yourself for now. Thank you. Okay, so officers met with the witness and the victim.
Yes, ma'am.
Were the officers able to determine the relationship between the witness and the victim?
Yes, ma'am.
Okay, explain.
The witness and the victim were in an ongoing relationship at that point, and furthermore, they were getting ready to move in together at this point.
Wait, how do you know that? Who told you that?
The witness.
Okay. And 1 second. So in terms of the vehicle, do you know who owned the car?
The witness.
The witness. Okay. How do you know that she's the owner of the car?
She stated she was the owner of the vehicle.
Okay. And they were broken up at the time of this incident?
The witness and the defendant were no longer in a relationship, according to the witness. They had been split.
She was in the car with someone new?
Yes.
And did the defendant use a key to open the vehicle?
No.
How did he enter into the vehicle?
The defendant entered into the vehicle by driving an electric power drill through the front passenger side door of the window directly into the victim's face.
Okay. And was the car damaged?
Yes.
How much damage was caused to the car?
The vehicle suffered a shattered window to the front passenger side, approximately, well, that'd be listed in the report, the approximate value of the damage.
Okay. And when you spoke to the witness, did the witness tell you that the defendant had permission to use a drill and enter through the window of her vehicle to try and drill into the victim's head?
No.
Objection, Your Honor.
No.
Well, did the witness say that the defendant had permission to go into the car?
No.
Like, were the doors locked at the time?
The doors were locked, yes.
Okay. I mean, there's no further questions.
Mr. Teicher, do you?
Yes.
wish to- What?
Detective, you were in charge of investigating this case, correct?
Yes, sir.
And this incident happened in February 27th, correct?
Yes, sir.
So a month ago from today.
Approximately.
And you've been a detective for how long?
I've been a detective for 1 month.
1 month. So this was the first day that you ever became a detective, was the date that you got assigned this case?
No, but it's not my first day as a police officer. I've been investigating crimes such as this for several years now.
And how many A forms have you written in your life?
Hundreds.
Relevant.
I'm sorry?
Hundreds.
Relevance.
I'm going to get to the relevance. Thank you.
What his back, how long he served as a detective. Let's get to the issues here.
Okay. So detective, you've written hundreds of A forms and you're in charge of this investigation, and you charged the defendant with a burglary of an occupied conveyance, correct?
Yes, sir.
And you charged him with an aggravated assault with a deadly weapon, correct?
Yes, sir.
You felt that those were the appropriate charges based on the evidence that you know, correct?
Yes, sir.
Okay. You did not charge him with burglary with an assault or battery, correct?
Yes, sir.
Okay. And the vehicle, the Tesla, did it have things inside of it that belonged to the defendant?
I can't recall, sir.
The baseball bat that the alleged victim pulled out of the Tesla, was that the defendant's baseball bat?
Relevance?
You're not an attorney, sir. Was it his stuff or not?
I can't recall.
And the defendant, he had the keys to the Tesla in his possession, didn't he?
Actually, that question was not answered. Like the victim, the witness herself didn't know where the keys were.
Okay. So you don't know whether the defendant actually had the keys to the Tesla, correct?
Yes.
And even though the witness owned the Tesla, she gave permission to the defendant to use that Tesla, correct?
That permission was retracted a week before, where she had been trying to contact him to get her vehicle back, that she had sent a certified letter to get her vehicle back, that she had to override access for her to get her car back. She was pleading with him to get her car back. She retracted that permission. He had no permission to have that car.
The vehicle was at his residence, his apartment building, correct?
That's correct, but he didn't have permission to have it.
Again, just answer my questions, please. It was at his apartment complex. He had the keys to it, and the witness came with her new boyfriend to his residence, correct?
He doesn't live there, so no.
It's not the building where he was at?
That's not where he resides, no.
The vehicle was parked there, correct? And that's where he showed up, correct?
Correct.
And the witness who's here today, she is stating that he had full permission to have that vehicle, to enter that vehicle, to drive that vehicle. He had the keys to that vehicle at the time of this incident.
He is stating this now on scene to me and several detectives. She stated that he did not have permission to have that car.
Okay. And again, at the time when you arrested him and investigated for a month, you did not feel and you did not charge him with burglary with an assault or battery, correct?
No.
Thank you very much. No further questions.
All right. Final argument, Madam State?
Sure. So it doesn't make sense that she would allow him in the car if they were broken up. She's in the car with.
Judge, I don't want to interrupt the state,
Sergeant?
but sorry, I don't think we're completely done with, we're not ready for argument yet because we have a witness who wants to testify.
Oh, okay.
It's the state's burden to establish probable cause. I brought forth my detective. This is a non-adversarial hearing.
Isn't a trial, and she's correct.
Well, we have a witness who's on scene, who owns the vehicle, who wants to testify. To not let her testify.
The issue, this is not a trial counsel. The issue today was there was a deficiency in terms of the information in the affidavit that the court needed to find. She's already testified this morning that he had permission. Everybody had permission to use the car. So she vehemently opposes these charges, as I recall. So there's nothing different that she would say today, this afternoon. So having said that, do you have any argument? Let me hear from the state first and then defense.
So it doesn't make sense that she would allow him in the vehicle if they were broken up at the time and she was in the car with her new boyfriend who they said were moving in together. So you don't let your ex-boyfriend who you've broken up with into your car. And if you look at the manner in which he's trying to enter the car, he's got a drill. He breaks the window and he's trying to drill into the victim's head. It makes no sense that somebody would allow another person to do that to their vehicle. Additionally, the detective did testify that the witness was actively trying to get the car back from the defendant, that he didn't have permission to have that car anymore. They were broken up. She had a new boyfriend. And based upon what was told to the detective and the officers on the scene, there's probable cause. I understand maybe they're back together. Maybe she doesn't want to press charges, but that doesn't negate the fact that he entered the vehicle without her permission with the intent to commit a battery. Additionally, I would like to argue that it was the state that brought forward the issue that there is probable cause for a burglary with a battery, which is a higher charge than what the detective charged, which are also appropriate charges. But I think based upon the narrative, the more serious charges are appropriate.
Mr. Teichler?
Yes, thank you, Your Honor. So here's a problem when a detective who's in charge of investigation uses his experience, his knowledge, and charges what he feels is appropriate. And we have a defendant who, this case has been pending for over a month. He wasn't arrested. This is not a case where the state of Florida felt he needed to be taken off the street for the safety of the victim. It's a month later he gets arrested. The detective did his job and filed the charges that he thinks is inappropriate. Now, just on the basis, on a random state attorney looks at it and says, you know what, I think we need to charge him with a non-bondable offense. And it's really a travesty that the state uses this burglary with an assault or battery, which is really used for, you know, breaking into someone's house and committing a major crime. It's a life felony. It's almost the most serious charge that you can have, to pull in these DV cases where the state knows, we've all been around long enough. If Your Honor finds probable cause of this case and he gets held in jail without bond, he's going to eventually get released at an Arthur hearing. It's just a matter of, are we going to force this young man, probably with no priors, to lose his job, to sit in jail for a week because this state attorney thinks that there's probable cause that the detective determined that there was not. We have a victim, a witness who owns the vehicle, saying that the defendant had full authority to go into the vehicle. It's not a charge that's going to hold up, and just to throw him no bond because the state feels that maybe there's more information on there. They could be making this argument saying first-degree murder, and it's just not there. Just because they want to hold him no bond, I think it's inappropriate. I think the bond should be set at what the charges are, especially with the witness testifying. She owned the vehicle. He had permission for it. She went to his residence to try to retrieve it. And unfortunately, she went with her boyfriend and a domestic violence incident happened. But it's not the type of case where this young man should be sitting in jail without a bond.
Okay, thank you. All right, I've listened attentively. I've reviewed the arrest affidavit not once, not twice. And I want to remind everyone here that the court has not only the discretion, but the obligation that in reviewing an affidavit, if it finds within the four corners of the instrument that it's deficient, okay, in the elements required of an offense, can obviously find not only for a lower pled or alleged offense, but also if it finds that there's additional factors contained within the arrest affidavit that would increase the gravity of the offense, the court can do that also. And it is abundantly clear that, and I heard very attentively the witness testify. I also heard, when I say the witness, I'm speaking about Miss, I'm sorry, Miss, I don't want to mispronounce her name, but the owner of the vehicle, as she is stated this afternoon. And I've also listened attentively to the detective. And I find that there is probable cause. There is probable cause for a burglary of an occupied conveyance with a battery therein, which is a first-degree felony punishable by life. And I am finding such and holding him no bond on that count. On count,
Your Honor does have discretion to place him on house arrest or some form. If the state was worried about the victim's safety or anything like that, then they would have arrested him a month ago.
and did not interrupt you when you were arguing, and I would ask for the same professional courtesy. Okay, I have not finished my findings. As to count two, I find that there is probable cause to find that an aggravated assault with a deadly weapon was had, and that is a secondary felony. I'm assessing bond on that count at $5,000. As to count three, I'm also making a finding of probable cause and assessing bond at $1,000 in that count. And as to the fourth count, battery, I'm also making a finding and assessing $1,000 bond. In addition to which, if he's able to post bond, okay, there's going to be, well, I really, you gave me state with regards to a stay away order as it relates to Jean-Pierre Louis.
That's the victim, yes.
So that's being entered into. Cannot have any contact, direct or indirect, by pager, phone, any social media, third parties in writing, etc. And you have to stay at least 500 feet away from this victim, victim's home, place of employment, or school at all times. Now, that's it. Okay. Now, you were saying, Mr. Teichler, you can proceed now with your argument.
Thank you. I was just saying that there are modes that Your Honor could implement if Your Honor is worried about safety of the community or the victim, placing this young man on house arrest versus him sitting in jail until a bond, at least over the weekend, until we can get a bond hearing set.
Right. But the court also has to be mindful of other facts. There's not only the ones that you've quoted. Respectfully, I'm denying your request. My ruling stand. Okay. Thank you and good luck.
And is that with the PTD hearing, Judge?
No.
I'm sorry.
Motion?
I didn't hear you.
Set a hold for the motion.
There was no motion on this case. It's pending Arthur.
There's no motion pending. One was not filed. Okay. All right, we're going back on the regular calendar. Amanda Martinez, page 1.
She's a private attorney, Greg Iamino. I will promote.
Thank you. Iamino.
Good afternoon, Your Honor.
Okay, you're here on behalf of Amanda Martinez.
Yes, Your Honor.
Does she speak English?
I believe so.
Yes.
Yes, I do, my honor. Yes, I do.
The PD has been appointed, discharging as private counsel. All right, Ms. Martinez, you're here before the court because it is alleged that on March 24th of this year in the vicinity of 19100 Northwest 37th Avenue in Miami Gardens, you committed the offense of aggravated battery with a deadly weapon, 1 count of discharge of a firearm from a vehicle, and 1 count of shooting or throwing a deadly missile. Okay, I am going to review the arrest affidavit now to make a finding, to see if there's probable cause and address your bond status. The alleged victim in this case is a person by the name of Leonel Mesa Waterman with a date of birth of June 21st, 1994. Okay, let me just.
So Judge, a couple things. It looks like it should be an assault with a firearm rather than a battery with a deadly weapon. And it looks like all 3 charges relate back to the same set of facts. I did not see any criminal history.
I didn't see one. I was going to ask you about that. Okay, hold on a second. Let me just review the form. Do you have any argument? Let me just review it, and then I'll ask you, Mr. Imoto.
Okay, Judge.
All right, the allegations set forth is that it's alleged that the defendant fired a round at the victim's vehicle, striking the right rear lower bumper of a vehicle that the victim was in. Okay. All right. Did you wish to argue, Mr. Imoto?
Judge, no, I concur with the state attorney with respect to the aggravated assault with a firearm, and do not have any probable cause arguments.
Is there any accompanying injunction or domestic violence stay away orders?
The A-form says there's no history of domestic disturbance between the victim and the offender, so I'm assuming no.
Okay. All right. What is the state looking for here?
A bond, because it all relates back to the same facts, maybe split the bond a little bit.
All right, this is what I'm going to do. On count 1, I'm setting bond at $5,000. Count 2, $2,500. Count 3, $7,500. These are pretty serious charges. Very serious. Okay. There's going to be a stay away order entered into place. These are people end up dead. Okay, and I want Miss Martinez to listen very carefully. Okay. Part of the conditions of your release, if you're able to post bond, are the following. You cannot engage in any criminal activity, ma'am. You cannot use or possess any illegal drugs. Can you hear me? I want to make sure you hear me. Okay, you cannot use, purchase, possess, carry any firearm, gun, weapon, or ammunition. You must immediately surrender any firearms, ammunition, or any concealed weapons permits to the nearest police office, police department, and file the receipt with the court. Understood?
Yes, yes, sir.
You are prohibited from having any direct or indirect contact with the following persons hereinafter: the victim, Leonel Mesa Waterman, including any contact in person, in writing, by telephone, through social media, or through third persons. You must stay at least 500 feet away from this victim, the victim's home, place of employment, and or school at all times. Do you understand that?
Yes, Your Honor.
Do you work?
Yes, ma'am.
All right, so the full bond should be $15,000 with a stay away order. Good luck.
Thank you, Judge. Thanks.
Next case is Jessica Hammock.
Present.
Hammock, okay, you're here before the court, ma'am, because it is alleged that on March 13th of this year, in the area of 14721 Northeast 6th Avenue, apartment 33A in Miami, you committed the offense of burglary of an unoccupied dwelling. Okay, is this a warrant?
No, I think the officer checked the box because they want a nebia, so it would be up to the court.
Nebula.
Right, I'm not sure if it's appropriate. Allegations are that she stole a pressure washer valued at $350 from the victim's cartilage, the trailer park.
I'm not inclined to put an nebula requirement.
I also don't have the victim's name, so if Your Honor would just do a stay away order from the location.
Who is the, because I have the location at 147.
I don't have the victim's name.
Okay, all right.
Judge, Ms. Hammock does not have funds for a bond. Would Your Honor consider house arrest as an alternate for her?
No, ma'am, not on these charges. Setting bond at $7,500 with a stay away order. Okay, Ms. Hammock, one of the conditions of your release is that you cannot go anywhere near this property, 14721 Northeast 6th Avenue, apartment or lot 33A in Miami. You understand that?
Yes, ma'am.
Next case is Estine Wilson.
This is set for a PC hearing tomorrow. I'll agree to the ROR today.
I'm sorry?
It's set for a PC hearing tomorrow, but I spoke to the detective. I'll agree to the ROR today. It's a
On this case. He has a no bond hold in another case, F253366.
so she should still have that no bond hold, but on the new case, we can do an ROR, or if Ms. Corey prefers $1, since she's got the holds.
I'll do $1 each count.
And it's because you cannot bring in the detective?
Well, I can bring the detective, and I spoke to him, but it's a tough constructive possession case. So I think at this point, it'd be better just to agree to the ROR, and we'll see what we ultimately file.
Okay. And you may not file anything, is basically what you're saying.
I don't know. I mean, we've got a month to figure out the evidence.
So the state and defense agreed on R.
I think because she's got the AC no bond anyways, we're agreeing to $1 on every count.
Okay, so now it's $1. Okay.
But with no PC. So it's by stipulation.
It's 4 counts, correct? Yeah.
Yes.
Yes.
No PC found. Okay. And it's off tomorrow's calendar because it was set for tomorrow.
Correct. So she should go before a division judge tomorrow on the AC.
So corrections, just so you know, no PCs found. The state's not going forward on the PC hearing tomorrow, so it's $1 count 1, $1 count 2, $1 count 3, $1 count 4, and he still has a no bond hold in F253369. Okay. Next case is Tyler Johnson.
This court was trying to get him into the hospital. Any information?
I have not heard back yet from the hospital. Would you be okay if we passed it for a little while, Judge, to see if they respond?
And let's see at the end. At the end, please. Okay, the next case is Robert McKenzie.
Mr. McKenzie.
No, he refused.
He refused, Judge.
It was reset for tomorrow.
Reset. 328. Next case is Cleaver Vargas Rodriguez.
Reset NBC.
Hey, Ms. Court, if you want to look into benefits for him too.
I'm sorry, Nessa, what did you say?
It looks like it says that the officers were dispatched to a potential Baker Act, so he may have some mental health issues and need stabilization. So the PD may want to run for benefits. So if we can reset it for tomorrow on BC.
Okay, reset 320. We did Fernando Herrera. The next one is Willie Smith.
Reset disruptive.
Ms. Court, you want to waive his presence? He's out on felony bond.
Yeah,
Yes, we can do that.
Okay. PD works.
He's out on felony bond on 6 cases.
6 cases? Okay. So he has no hold on those corrections?
The state's requesting a hold for Judge Venzer.
Is this all these cases in front of Judge Venzer? Because I have here F253889, F25389092, 3904, 3963, and 4158. Those are the ones.
Yes.
Okay. All right. The added charges here are grand theft in the 3rd degree of the vehicle, possession of cocaine, suspect brought cocaine, introduction of possession of a controlled substance into a jail facility. And then the other one is driving while license suspended, which is.
Those are not before you, Judge.
The last.
The DWLSs is not before you. They reset him tomorrow.
I have those arguments.
Okay.
Ms. Court, you do or you don't have a PCR?
I do.
Is it count 3?
Count 1 and count 3. For count 1, there's nothing indicating that Mr. Smith was aware that the car was stolen. He indicates that he knew the rentee of the vehicle, was allowed to borrow the car for a few days. He actually had the keys with him. So there would be no knowledge for the theft charge. And in count 3, it looks like the police did not search him appropriately if they're claiming that once he got into corrections here at the jail, that in the bag that he had in his jacket pocket, there was an item inside the paper bag. So it looks like no one bothered to search him.
Want to stipulate to $1 on 3?
That's fine.
I think there's PC on 1 that's recently stolen.
He was driving. Yep. All right, a finding probable causes to 1 and 2. Each of those is a $2,500 bond, $1 on count 3, no PC on that one. So that's $5,000, and he has hold on the other 6 in front of Judge Venzer.
Count 3, you said no PC release outright?
$1 on that one. Actually, it's release outright on that one. If I didn't find PC, no, it's release outright.
So count 3 is a release outright, not a dollar.
I'm okay with $1. He's being held on other charges. Okay, thank you.
Procedurally, it's incorrect.
It's by stipulation, because if the state does ultimately file, he'll get CTS on it.
Get it. All right. Okay. So what do we leave it at? So corrections won't think they were not. It's $1 or release outright.
$1, please.
$1. Corrections. Okay, thank you. All right, the next one is Joseph Lawrence White.
Present.
Okay, Mr. White, good afternoon, sir. Okay, let's see what we got here.
I show he's a VFOX. He's on probation. He's in custody being held no bond, F201059.
Okay. All right, on this case. Take a look.
And just for the record, we'll be invoking Mr. White's right to counsel and his right to remain silent.
All right, Mr. White. You are out on probation in case number, it looks like F201059. You'll be held no bond on that one. In this case, it is alleged, this is case number F256251, that actually there's two cases. Okay, so let's start with the 6251. It is alleged that on March 26th of this year, in the vicinity of Northwest 63rd Street and 18th Avenue, you committed the following offenses: possession of a firearm by a convicted felon, tampering with physical evidence, possession of cannabis within 1,000 feet of a church or convenience store, resisting an officer without violence to his person, possession of cannabis, 20 grams or less, and one count of providing a false name after arrest. That's that case. In case number F256252, it's alleged that on February 10th of 2025, in the vicinity of 2185 Northeast 167th Street, apartment number 8 in North Miami Beach, you committed the offense of attempted felony murder, causing injury, assault, aggravated assault with intent to commit a felony, and battery with prejudice. Okay. I've appointed the public defender's office to represent you in these cases. And so let me take a look at the arrest affidavit to determine probable cause and also to determine your bond status on these cases. Okay, any argument with regards to the 6251 case?
Judge, I'm gonna admit that it's circumstantial. The defendant ran, the officers heard the thumping noise consistent with a heavy object, and then they found the gun a few yards from where he was initially standing, and they also found the marijuana. His excuse was that he was urinating, but there was no sign that he was urinating, and that it looked like the gun hadn't been there a long time because it wasn't, rusted or anything like that. So I think there is probable cause, but I will acknowledge that it is circumstantial. The cannabis I'll agree to, maybe, a reduced bond on. I don't know if this court has anything else.
So Judge, if they didn't see Mr. White with a gun, they find a gun yards away and then claim it's his without any other information, Judge, that's just not sufficient for possession of a firearm by a felon, Judge. It's just not. They never saw him in possession of it. They have nothing indicating that it belonged to him. In addition, nothing with regard to tampering with the physical evidence because they never saw him with a firearm. The cannabis is described as 4 baggies. They're saying that it was in the area where he was first seen. So just being in the area where he's seen is not sufficient, Judge. It's wishful thinking on the police department's behalf, but it's.
This area, the first paragraph described as a high crime area.
The only other thing I want to add, Ms. Corey, is that he admitted to the cannabis, but he said the gun wasn't his, but in his statement, he said the cannabis was his.
I'm sorry, Corey, I interrupted you to just make that observation. Go ahead, I'm sorry.
So Judge, at best, then it would just be possession. Simple possession of marijuana. And I don't see any allegations of a false name. Maybe I missed it, but it's a
I
lot.
looked at it, I didn't see it.
I didn't see it.
I didn't see right to counsel. I didn't see that either. Just read
No.
it.
Because he's being held anyways, $1. If Ms. Corey wants to know more, that's fine too.
Well, there's I'm not finding PC as to counts 1, 2.
Count 5 is possession of marijuana, Judge, so no public cause for count 3 then.
Or the resisting.
That's him taking off, running.
Count, the only count that there's PC here is count 5. Possession of marijuana. There's nothing else. So counts 1 correction.
I'll agree to $1 bond for the ones that you have no probable cause for, Judge.
Okay.
So it's being held on other things.
All right, okay, so, because I'm not finding PC on counts 1, 2, 3, and 4 as written on the safe form. So stipulated $1, and then as to what count 1, 2, 3, and 4, each $1, and then count 5, $500. Okay.
And count 6, $1? That's the
That-
false. Yeah.
$1. Wait a minute then. Yes, count 6, $1. Okay.
So only on count 5 is 500 and 1, 2, 3.
Everyone else, 1, 2, 3, 4, and 6, $1. Okay. That's that case. Now the other case, the one ending is 6252, the one that he's charged with 1 count of attempted felony murder, 1 count of aggravated assault with intent to commit a felony, and 1 count of battery with prejudice.
So I think a more appropriate charge would be an attempted second with a deadly weapon.
Well, the alleged injuries here are 4 to 5 inch wide and 2 inch deep slash across the chest.
I think it would be an attempted second-degree murder with a deadly weapon.
The restroom also indicates that the alleged victim picked up a skillet and tried to attack Mr. White.
That was after, I believe, the defendant approached the victim and punched him in the face. So the defendant was the initial aggressor.
What's this battery with prejudice?
So it's because the alleged victim, I believe, is transgender, and the defendant made a homophobic remark.
And this gentleman is
On probation.
on probation in 6 cases.
No, he's on probation in 1 case.
Okay, and this is the one, which is the one that you're moving to? This is the one that you filed a motion for pretrial detention.
The attempted murder, yes.
Got it. Okay. Any argument, Ms. Corey?
Judge, there's nothing indicating that Mr. White attempted to murder the alleged victim. The alleged victim was going at him with a skillet, Judge, from the kitchen.
All right. Court has reviewed the arrest affidavit, the motion filed by the state. And the court is going to make the following findings. I find probable cause as to count 1 for attempted second-degree murder. I am granting the state's order for pretrial detention on that count, so it's going to be out of no bond on count 1. With regards to count 2, it'll be $5,000. And count 3 is $5,000. There will be, he's able to post bond and be released despite all the other matters that he has. There's a stay away order against the, in favor of, he's prohibited from having any contact direct or indirect with the alleged victim, whose initials are TM. You understand that, Mr. White, which means no direct or indirect contact with this individual, either by person, pager, third parties, social media. You have to stay at least 500 feet away from victim's home, place of employment, or school at all times. Right, the conditions of be released. You cannot engage in any criminal activity. You cannot use or possess any illegal drugs. You cannot use or possess any firearms, guns, weapons, or ammunitions. And if you have any of those, you need to surrender them to the nearest police station and file the receipt with the court. And again, you're prohibited from having any contact, direct or indirect, with the alleged victim whose initials are T. Here it's a little bit more specific, VM. So that's 3 initials. You understand that? Okay. There's 2 victims here. I just realized there's Sean Harris Jr. Yeah, on the second one. Okay. Good luck to you, sir. Next case is Lorenzo Serrano.
Judge, I have him out on F24 35557 Alpha.
Yes. On F24 35578.
Yes.
Yes. Yeah, it's out on bond. So there should be a no hold, no bond hold on that one until he goes in front of that judge. Is this Mr. Serrano?
Yes, Judge.
Does he speak English?
Yes.
Okay. It looks like he's out on bond on more than 1 case. I have a note here that he's out on bond in front of Judge Altfield in cases numbered F24 35578, which we discussed, and F24 15618. Yes. So he'll be held on both those. Okay, on this case, Mr. Serrano, which is the F256254, it is alleged that on March 25th, of this year in the vicinity of 20781 Northwest 17th Avenue, Miami Gardens. You've committed the offense of attempted felony murder with a firearm, armed robbery with a firearm, aggravated battery with great bodily harm and or with a firearm, aggravated assault with a firearm. Actually, let me go back because there's 4 counts of armed robbery with a firearm or deadly weapon, and there are 4 counts with for aggravated assault with a firearm. Alleged victims in this case are Iverson Asensio, another one with the initials AR, another one with the initials GF, and another one with the initials SA. The state of Florida has filed a motion for pretrial detention pursuant to 907-4041, asking that it be held no bond in the either life or first degree felonies, which constitute counts 1, 2, 3, 4, 5, and 6. I believe, if I have those right. Okay, I'm going to review now the arrest affidavits, determine probable cause, and address the motions filed by the state.
For the record, we'll be invoking Mr. Serrano's right to counsel and his right to remain silent.
Thank you. All right, any argument, state?
Judge, I believe there's probable cause, requesting that the defendant be held no bond pending the determination on the pretrial detention hearing.
Defense, you wish to,
Judge, with regard to probable cause, it looks like they're duplicitous charge of the aggravated battery with the attempted murder. The allegation is that
one
gunshot wound was to the leg area, Judge. There's nothing indicating that he was attempting to kill anybody. The statement made to the police on the arrest form is that he felt threatened at the time.
all right. I've reviewed the arrest affidavits, reviewed the motions filed by the state. The court is going to grant the motion for pretrial detention in count 1, counts 2, 3, 4, and 5, and in count 6, he'll be held no bond in counts 1 through 6. With regards to count 7, he will be 7 through 10, $5,000 bond each. I will be entering stay away orders for the following, and I need Mr. Serrano to listen carefully. If he's able to post bond on it, on this case, okay, you cannot have, sir, any contact whatsoever with Everson Asensio. That means no direct or indirect. You have to stay at least 500 feet away from this individual, his home, place of employment, school at all times. The other victim with initials AR, same thing. The other victim, initials GF, same thing. And another victim with a name with initials SA, same thing. Additional requirements under this particular case, it'll be bond, if he's able to post bond, plus the GPS, total lockdown. Okay.
Judge,
Next.
I'm sorry. So on count 7 through 10, is it 5,000 plus house arrest?
Yes. And counts 1 through 5, no, 1 through 6, no bond.
Judge, the private attorneys are wanting to know if they can be taken out of turn. They've been here for about 2.5 hours waiting. Who would be willing to do that?
Here, we're on page, we're 5 out of, okay, how many do we have here? We're midway, I think, 5 through 11. Who's the first attorney? You have to
The first attorney would be,
Oh, wait, come on, get out.
Oh, sorry.
it would be Michael Meyer on Alejandro Pujol, number 15. And then right after that would be Jay White on Alfredo Paraguan Marine. Both cases are on page 6.
Alejandro.
Alejandro
They want?
Pujol, yes, number 15.
Yes,
Okay.
Alejandro Pujol, Spanish interpreter for Mr. Pujol.
Thank you. Good afternoon, Mr. Meyer.
Judge Espinoza, good afternoon to you.
Okay, are you having Mr. Alejandro Pujol?
I do, Judge. He needs the interpreter.
Interpreter, yes, ma'am.
Interpreter present.
All right. Your client is before the court. There's an affidavit here that I've received, a direct affidavit that states that on December 13th of 2024, in the vicinity of 1499 North Homestead Boulevard in Homestead, he committed the offense of felony battery.
Tengo aquí una declaración jurada del 13 de diciembre del 2024 en el que se dice que en las inmediaciones del 1499 Norte de Homestead Boulevard, usted cometió el delito de agresión física con agravantes.
Alleged victim has initials JT, and apparently it's occurred at the Walmart store at the address that I just read out. Okay.
Las iniciales de la víctima son GLT, GTL, y estaba en el Walmart, en la dirección que ha indicado.
All right, we're going to review the arrest affidavit momentarily and to address his bond status, and then I'll hear argument.
The state's just seeking standard bond with the stay away order.
La fiscalía busca una fianza estándar.
There's no enhancement here, so this is a $5,000 bond with stay away.
Judge, I don't oppose that.
$5,000 y una orden de alejamiento, dice el juez.
Let me let Mr. Buyon know what the contents of the stay away order is. He cannot have any contact, direct or indirect, with the alleged victim in the case.
Señor, no puede tener contacto directo o indirecto con la víctima en este caso.
Which means no contact in person, in writing, by telephone, pager, fax, or through persons.
Lo que significa que no puede tener contacto en persona, por escrito, por teléfono, a través de las redes sociales o otro medio electrónico, mensajes de texto o a través de terceros.
He has to stay at least 500 feet away from his home, his placement, or school at all times.
tiene que permanecer en todo momento al menos a 500 pies de la víctima, de su casa, lugar de trabajo y lugar de estudios.
You understand?
¿Comprende, señor?
All right, good luck,
Sí.
Buena
Thank you very
suerte.
much, Judge, for taking me out of turn. Have a great day.
everyone. Next case, that needs to be called out of turn.
Is Alfredo Paraguan Marin, the next one on the calendar right after Mr. Puyo.
6.
I'm promoting Mr. White.
Got it.
Judge, good morning. Good to see you.
Good afternoon.
Good afternoon. Sorry, my head's a little mushy.
Mr. White, this is your client, Mr. Paraguan Marin.
Yes, Judge. He needs a Spanish interpreter, please.
You have one?
Interpreter present.
Okay, your client, Mr. Paraguan, is, it's alleged that on June 13th of 2023, in the vicinity of 6020 Northwest 99th Avenue, number 203, he committed the following offenses.
I'm so sorry, Your Honor. Can interpreter have a repetition, please?
Yes, it is alleged that on June 13th of 2023, the defendant in the vicinity of 6020 Northwest 99th Avenue in Doral committed the following offenses.
Muy bien. Se alega que el acusado el 13 de junio del 2023 en las inmediaciones del 6020 Northwest 99 Avenida en Doral cometió el siguiente delito.
Count 1, organized fraud of $50,000 or more.
Cargo número 1, organized.
Fraud.
I'm sorry, I don't understand that word. Organized?
Fraud. F-R-A-U-D.
Fraude.
I'm sorry. Un fraude organizado de $50,000 o más.
Number 2, count 2, to defraud a financial institution.
Defraudar una institución financiera.
Number 3, grand theft of the second degree, which is from $20,000 to $100,000.
Okay. Esto es hurto mayor en segundo grado.
And count 4, actually there's more on the second page. Unlawful use of a communication device.
Uso ilícito de un dispositivo de comunicación.
Fraudulent use, the next count, of a personal identification or possession with intent to use fraudulent identification.
Posesión de una identificación fraudulenta con intención de utilizarla.
Obtaining a credit card by false statement.
Tarjeta de crédito con declaraciones falsas.
Okay. So what I'm going to do now is I'd like to take a look at this arrest affidavit, and then I'd like to hear argument from both sides and what the rest
Lo
of
que voy a hacer ahora es mirar voy a mirar la declaración jurada del arresto.
So he used the victim's personal identification to obtain a $60,000 loan and created a fraudulent, a fake email address and phone number.
Ok, entonces utilizó la identificación falsa de la víctima para obtener un préstamo de $60,000.
That he used in the loan application.
Excuse me?
That he used in the loan application. The fake email and
Sí,
phone.
que utilizó una aplicación para pedir el préstamo.
There's no indication that an actual loan was given. In fact, count 1 and count 3 contradict each other. Count 1, organized fraud, talks about 50,000 or more. Count 3, grand theft, is only 20,000 or more. So that's a conflict. And if you go to page 3,
Excuse me, counsel, can you allow me, please?
My apologies.
Yeah. Bueno, realmente el cargo número 1 y el cargo número 3 se contradicen. El número 1 son $50,000 o más y el cargo número 2 son $20,000 o más. Aparte de eso, no hay evidencias que recibiera ningún préstamo este señor.
The only evidence is on page 5, the last page. There's mention of a cash advance, but there's no amount.
La única prueba está en la página número 5 que se habla de un avance de dinero en efectivo, pero no se especifica la cantidad.
And the officer describes this as a financial institution. This is not a financial institution. If you Google the name,
Bien, esto que se califica como una institución financiera realmente no lo es. Si se mete en Google es el nombre,
you'll notice that Mont Technology on the second page of the A form is a fintech platform. They're a broker for loans. They're not a bank.
sale Mott Technology y que realmente no son, son unos brokers, unos corredores de préstamos, no son un banco.
And they're also located in Georgia.
Están ubicados en Georgia.
And there's no indication that the victim is in Dade County, Florida. The only information I can gather is a 561 area code that was allegedly used.
Y no hay tampoco pruebas de que él estaba en la Florida. La única numeración que tenemos es el 561 como código de área.
So, Your Honor, I have questions about jurisdiction and questions about whether or not this is properly charged, and also the conflicts in the charges with regards to probable cause.
Tengo entonces algunas cuestiones respecto a la jurisdicción, si esto ha sido debidamente, estos cargos han sido debidamente cursados y también si existen motivos fundados para ellos.
The only evidence of anything happening in Dade County is my client's address.
La única evidencia de que algo ha sucedido en Dade County, en el condado de Dade, es cuando mira su dirección.
And I would argue, lastly, Your Honor, that a lot of the counts are duplicitous. Organized fraud, grand theft, defrauding a financial institution, using false statements to obtain credit. These are all duplicitous and contained within organized fraud or grand theft.
También yo diría que, bueno, pues que estos cargos que se le imputan aparecen duplicados porque organización para defraudar, defraudar en gran cuantía, defraudar, todo eso cae dentro de un solo cargo que sería organización para defraudar.
So, Judge, I would suggest to the court that perhaps it impose a standard bond on count 3, which is grand theft, $20,000 to $100,000. I think that's what the facts represent at best.
Entonces yo diría que se podría poner, que la juez podría poner un solo cargo, que es el de hurto en mayor cuantía, sería el cargo número 3, que va de $20,000 a $100,000.
And the remaining counts be dollar bond, except for the communication device that asks for a standard bond.
Y que el resto de los cargos se le retire la fianza, excepto por el dispositivo de comunicación.
State.
So if the defendant's in Miami trying to obtain these loans, I believe that the jurisdiction would lie in Miami.
Como el acusado está en Miami intentando obtener estos préstamos, yo creo que la jurisdicción cae aquí en Miami.
I think there's PC on everything.
Yo creo que hay motivos fundados en todo.
All right. I've listened carefully. There's probable cause. Mr. White, what I think might end up is this might end up in federal court.
Veo que hay motivos fundados. Señor White, yo creo que esto va a terminar en un tribunal federal.
The court is going to, and it appears from my reading that the loan was not, the application was not concluded. At least not that I can read from here.
Por lo que leo aquí, yo me parece que la solicitud del préstamo no fue conclusa, no se concluyó.
It doesn't specifically state that that's something that obviously will have to be, but for purposes of initial probable cause, and I don't understand why there would be a nebia requirement either. So I'm going to find probable causes to all counts. On count
veo porque no tendría que haber una audiencia nebia, una nebia. Aquí yo hallo que hay motivos fundados en los cargos.
I'm setting bond on count one at $15,000.
El primer cargo fue fianza $50,000.
Count two at $5,000.
Cargo número 2, $5,000.
Count three at $500.
El cargo número 3, $500.
Count four.
Cargo 4. Excuse me.
Count four at $2,500. 250.
Ok. Sí. El 4 a $2,500.
Count five, on count five, that's $2,500.
El cargo número 5 son $2,500.
Count six, $500.
Y el 6, $500.
Judge, I didn't quite hear you on count one, organized fraud, because based on the amount of loss, there's different degrees of felonies. If it's over 50,000, it's a first. If it's 20 to 50, it's a second. 20,000 or less is the third. I didn't hear if you said 15 or 5050.
15,000.
Oh, sí, perdón. $15,000, no 50,000, como indica su abogado. Hay distintos grados de fraude organizado. Puede ser un delito mayor de primer grado, segundo grado, tercer grado. Son 15,000.
Judge, will the court consider a 10,000 for count one, given that there's argument as to whether it's a first or a second degree?
Nope.
Se consideraría $10,000 de fianza, dado que puede ser de primero un delito grave de primer grado, segundo grado. La juez responde que no.
There's a statement in regards to the victim, alleged victim with initials AV cannot have any contact if he's able to post direct or indirect, has to stay 500 feet away from victim with initials AV. Okay.
Bueno, tiene una orden de alejamiento de la víctima con las iniciales AB, tiene que no puede tener contacto directo o indirecto, por escrito, por terceros, tiene que permanecer al menos a 500 pies de la víctima, su casa, lugar de trabajo y de estudios.
Any other cases that need to be called out of turn for any lawyers? Okay.
I don't think there's any other private attorneys left.
Thank you.
Thank
All right. Left off, let me see here. On page 7. Did we skip Joseph Doyle on page 5?
He should be.
Clear. He's present, Judge.
Okay, all right. Is this Mr. Doyle?
Yes, ma'am.
Okay, good afternoon. All right, Mr. Doyle, you're here before the court. Today, it's alleged that on March 27th, in the vicinity of the 400 Kings Point Drive in Sunny Isles Boulevard, you committed the following offenses. 1 count of battery on a law enforcement officer or correctional officer. 1 count of resisting an officer without violence. 1 count of criminal mischief, $200 or less. 1 count of disorderly intoxication. I've appointed the public defender's office to represent you in this case. I don't see, is this his first offense?
So he's from, it looks like Indiana. I don't know if it's Indiana or Illinois. He's from out of state.
Okay.
I think it's Illinois. I do see prior arrests out of state.
Any argument?
Not with regard to probable cause, Judge, no.
All right, I'm setting bond as follows in count 1, which is the battery, $5,000. Count 2, 1,000. Counts 3 and 4, 100 each. So the total bond should be $6,200 with a stay away order.
Judge, would you consider the standard bond for count 2? Standard bond is 500.
I will. So So the corrections is 5,000 count 1, 500 count 2, 100 and 100 count 3 and 4 respectively. So the bond is 5,700. With a stay away order, Mr. Doyle, if you're able to post the bond, one of the conditions is you cannot have any contact, direct or indirect, the alleged victim in the case whose initials are KK. You have to stay at least 500 feet away from this person, his home, place of employment, or school. In addition to which, you also have to stay away from coastal towers. They don't want you anywhere near 400 Kings Point Drive and Sunny Isles Boulevard. Do you understand that?
Yes, yes, ma'am.
Okay. Next case is Camellon Fernandez.
An added charge, it happened at the jail.
And he has a hold for immigration.
Okay. Each is assigned. Here it is. Okay. Camellon Fernandez.
Is number 12 here corrections or is he in the hospital?
Oh, Andy.
And you said this was an added charge?
Embassy.
Ms. Cole, you want to waive it if he's got the ice holds?
He's got an ice hold too?
Yes. This is a battery on police officer, correction officer, firefighter in transit.
Right, apparently they're on lockdown and he wanted to use the bathroom before they locked down for the night and the officer sprayed him with mace. And then he may have broken nose and ribs. And they didn't bring him to court for some unknown reason.
So what do you want to do? You want to roll it over or it's up to you?
Yes, Judge, if we can come to court tomorrow.
Reset for tomorrow?
What was it, NBC?
Not before court, correct.
Okay.
Next case is Jorge Izalde. Thank you again.
He received a dollar bond on his traffic case.
Okay, is this Mr. Izalde?
Yes.
Okay, Mr. Izalde, good afternoon. I have an arrest affidavit here that says that on March 26th of this year, in the area of I-95 North and Northwest 79th Street, you committed the following offenses. 1 count of aggravated battery on a law enforcement officer. 1 count of fleeing and eluding a police officer with lights and siren. 1 count of, well, that's the traffic, the reckless driving. Okay, so it's count 1 and 2. The state of Florida has filed a motion for pretrial detention. On count 1, asking you be held no bond.
So Judge, on count 1, I would ask that you find probable cause for, at best, aggravated assault on law enforcement officer. Nothing indicating that the officer was directly hit by Mr. Izalde.
So I think for there to be probable cause for an aggravated battery rather than an aggravated assault, there needs to be some kind of injury, and it does say that the detective suffered from and was treated for a head injury based upon the defendant colliding with the officer's vehicle.
Looks like he was treated on the scene by fire rescue, so it doesn't look like it was a serious injury.
All right, I'm making finding a probable cause. I do find probable cause as charged on count 1. He's going to be held no bond. I'm granting the state's request for pretrial detention. And I'm setting also count 2 at $2,500. Next case is Vladimir Perez. Mr. Perez, it looks like he's out on bond in case number 25, F25-21223 in front of Judge Stuzen.
Mr. Perez is present. He speaks English.
Okay. Mr. Stuzen, did you hear that? I mean, Mr. Stuzen. Perez, you know it's getting late.
Long day.
Mr. Perez, I just advise corrections that it appears that you are out on felony bond in case number F25-21223, which appears to be some kind of burglary related offenses. So you'll be held no bond on this case until you appear in front of that judge. Today, you have before the court an affidavit that says that on March 24th of this year in the area of 1439 Alton Road, Miami Beach, you've alleged to have committed the following offenses. 1 count of unoccupied burglary of an unoccupied structure, which is a third-degree felony. 1 count of criminal mischief of $1,000 or more, which is a third-degree felony, and 1 count of grand theft in the third degree, another third-degree felony. I've appointed the public defender's office to represent you. I'm going to be taking a look at the arrest affidavit and determine if there's probable cause for these offenses, and if so, what the bond amount is going to be. Understood? Okay. How many AC units are involved here? Because there's a count of
$12,000.
Oh, those are the brackets I think.
I think just 1.
Okay. And 1 burger. Yeah. All right. $2,500 counts 1, $2,500 count 2, $2,500 count 3. He has, if he's able to post a bond, has to stay away from Classic Way, located 1439 Alton Road in Miami Beach. You understand that, sir?
Yes, ma'am.
Mayor,
Can you go back to number 16, just to verify count 3, because we have 500. The clerk said you wrote 7,500.
I don't have that paperwork. Is that Marlene?
Yes.
Okay, I don't know what the paperwork is.
The clerk has it.
Okay, let me take a look at it. Let me see. Hold on, let me take a look at that. Count 5 is 500. Is that the one you're asking about? It doesn't make sense. Count 6, sorry. Count 6.
Wait, can I verify the bonds that we have? You told us count 1, 15,000, count 2, 5,000, count 3, we have 500, count 4, 2,500, count 5, 2,500, and count 6, 500.
No, count 3 is 7,500, 7,500. That's the second degree felony. The only one for 500 is count 6. I'll read them to you again. Count 1 is 15000, 15,000. Count 2 is 5,000, 5000. Count 3 is 7,500, 7500. Counts 4 and 5 are $2,500 each, 2500, and count 6, 500. Got it? All right, Mr. Is it Sykes?
Yes, ma'am. Yes, Your Honor.
Okay, good afternoon, sir. All right, you are before the court. Looks like charged with one count of possession of cannabis with intent to sell within 1,000 feet of a school, or just school is what it says. It's a second-degree felony, and this supposedly took place on March 26th in the area of 100 block of 6th Street in Miami Beach. I've appointed the public defender's office to represent you. I don't see anything open on this gentleman except
No,
his.
well, he's from Atlanta.
Okay.
Local ties.
Got it. Okay. Let me take a look at the school is Lemus, or the park, Lemus Park, right?
Yeah. Yep.
Okay. $7,500 bond with a stay away order. Serve your post bond. You cannot go anywhere near Lemus Park, which is located on 5th to 15th Street, Washington Avenue, to the ocean, Miami Beach. That's the address that we have there. 100 block of 6th Street. You have it here. 5th to 15th Street.
That's, I think the area of Lemus Park is on the stay away order, the whole park.
Understood, sir?
Yes, Your Honor.
Okay. Jamie McKinney. Oh, wait a minute. This gentleman has another, does he have another case?
No, there's another defendant, Ismail.
I missed that one. Hold on. Amir Ismail. Is this Mr. Ismail?
Yes, Your Honor.
Whatever.
Yes, Your Honor.
All right, you're here before the court, sir, because it's alleged that on March 27th, in the vicinity of 150 Northwest 21st Street in Miami, you committed the offense of defrauding an innkeeper for $1,000 or more, which is a third-degree felony. I've appointed the public defender's office.
Judge, it looks like there might be a private attorney here. They haven't identified themselves.
Okay, let's
say they're a private attorney for this case.
You want to promote that person? They've been here.
I'm an attorney, Mr. Ismail.
I'm going to promote Judge.
Video. Can you hear me?
We can hear someone.
We can't see you.
Are you able to hear or see me?
We can hear you. We can't see you. Now we can see you.
I have been waiting since 1 o'clock. I have seen the judge sign off when she did, and I saw Your Honor sign on again at 2:20. I have put my name into the chat. I have put my name into Q's and A's, and for the life of me, with all respect to the system, why have I waited over 2.5 hours?
What is your name, sir?
Lion Greenblatt.
That's not what your text message says. It says lie 999-207 on Greenblatt. We don't have
my gosh.
Greenblatt on the calendar, sir.
I'm so sorry, Your Honor. I put my name in Lion Greenblatt on. Nonetheless, Your Honor, I'm here for Mr. Amir. Ismail. Judge, I'm not going to belabor the point. I understand the nature of the charge. He offered to take one of the personnel to a place where he had sufficient funds to pay the balance. They refused. It seemed to me they wanted his gold Rolex instead. Would Your Honor kindly set the bond at the $2,500 that was originally scheduled?
Yes, sir. Done.
Judge, if I may, I want to thank you for the courtesy and my peek because I'm not familiar with the webinar. I'm familiar in all the other jurisdictions where the Zoom seems to be functioning slightly differently. And I apologize for my lack of technical skills. I really,
Judge,
truly do.
You could even maybe reduce it more. Maybe, I know he's got some money he's got to pay off his bar tab with.
We're going to pay the bar tab as soon as he gets out.
I paid, Your Honor.
Or an ROR.
I paid, Your Honor.
Would the court consider an ROR and get him out and let him pay this bill lickety split?
I'm not gonna alarm him, but maybe he's entitled, maybe he'll qualify for pretrial services. Does he have any?
He's not going to qualify for a pretrial because he's not local.
Okay, in that case, we'll stick with the bond and I'll have his friend posted immediately. Thank you so much, Your Honor. And again, I apologize for my technical lack of skills. Truly, I am a Luddite, which is a good word to know, Madam State Attorney.
Bond, Judge.
2,500.
Thank you, Your Honor. May I seek permission to leave?
You want to stay any longer, sir?
You talking to me or Mr.?
I was kidding because you've been here all day.
Well, I'm glad you have a sense of humor. You've put me right back on track. Thank you, Madam Judge, and thank you, State.
Thank you.
Have a good afternoon all. Bye-bye.
Likewise. Jamie McKinney? Mr. McKinney? Good afternoon, sir. You're before the court. It's alleged that on today, March 27th, in the area SA Recycling, located at 1015 Northwest 72nd Street in Miami, you committed the offense of burglary of an unoccupied structure and petty theft. Appointed the Public Defender's Office to represent you.
I don't know how the court feels about TAP, if not a bond.
I would ask for TAP, Judge. Mr. McKinney's homeless.
He's stealing scrap metal.
That's what I thought. But here, no, we don't have anybody here for TAP. Okay, I'll make a TAP reply. Alternate bond. First count will be 2,500, second count, $1. Okay, what's the return date on this? April, what did we say?
I think we said the 28th.
28th, that's what the clerk just told me.
You said count 2 is $1?
Yes. Okay, and he's gonna be referred to TAP, that's the alternate bond. 2,500 first count, $1 the second count, and he needs to show up in the courtroom. I forgot the courtroom number.
6-4.
Thank you.
6-4 on April 15th at 9 p.m. Good luck to you, sir. Malcolm Bowe.
So in this one, if Your Honor would find PC just count 1, we don't need to set it for a PCH.
Is this Mr. Bowe?
No.
Oh, wait. So what happened to, where's Bowe?
It's set for PCH tomorrow, but I don't know if Ms. Corey wants to waive his presence.
So he's not here because set for PCH for tomorrow.
Tomorrow instead of for.
Is there any way to get him over here? Corrections?
It's set for tomorrow.
He's down the hall, Judge. If we can get him out today instead of sitting in overnight.
Michael Leva. Is this Mr. Leva?
Yes, ma'am.
All right. Good afternoon, sir. Mr. Leva, your report, it's alleged that yesterday you committed the following offenses in the vicinity of Northwest 12th Avenue and Flagler Street. 1 count of possession with intent to sell or manufacture marijuana. 1 count of resisting an officer without violence to his person, and 1 count of possession with intent to use drug paraphernalia. What does he have? Let's see here. Okay, this is a hand-to-hand. Is there anything open?
He's on probation, I believe.
Okay, this is a third. Okay, so count one, it's $2,500. Count two and three, $500 each. $3,500 total.
You say he's out on probation?
Am I wrong? If I'm wrong, I apologize. I see probation, but maybe it's the wrong defendant.
What's the case number?
I got F22-10601. I'll run it. Hold on.
Mike, yes. Is
Yeah.
that a whole judge?
What's the case number? He's on probation. There has to be a hold on that case, yes.
F22-10601 and F22-901A.
Okay. Bravo Leal.
Spanish interpreter, please.
He has a hold for immigration. You see the dollar bonds on each one of his traffic cases.
Okay. So he's got a nice hold. All right, Mr. Bravo Leal, you are before the court. It's alleged that you committed today the offense of criminal mischief, $1,000 or more, which is a third-degree felony, and domestic violence battery, first-degree misdemeanor.
Ok. Señor, se le imputa de haber cometido una
Criminal mischief.
criminal mischief, daños a la propiedad, excuse me, daños a la propiedad por más de $1,000 o más, lo cual es un delito grave en tercer grado, y también por una agresión de violencia doméstica, que es un delito menor en este caso.
I've appointed the public defender's office to represent you. The alleged victim is Auribel Estrada Garces.
He nombrado al abogado de oficio para que lo represente. La víctima supuesta es Auribel Estrada Garcel.
Count one, $2,500.
There's no value for count one. Looks like second-degree misdemeanor.
Well, maybe increase the bond because the defendant, because of the facts. He smashed out windows in the victim's car.
Hey, she's right. He didn't say how much.
It's true.
Smashing in the window, so that becomes a misdemeanor.
Yes.
Okay.
Bueno, se está debatiendo, la fiscal pide que la juez dice $2,500 por el primer cargo, la fiscal pide que le pongan más porque rompió las ventanillas del carro.
There's no value. Okay, so count one, $100, count two, $500. So that's total $600 with a stay away order. And
Cargo número 1, $100, cargo número 2, $200.
a stay away order. He cannot go anywhere near. He was able to post the bond, although he's got an immigration hold. Oh, he has a stay away from Auribel Estrada Garces.
Tiene una orden de alejamiento de Auribel Estrada Garcel, tiene una retención de inmigración.
Good luck to you, sir. Okay. Mackey, Andres Mackey.
Andrés Mackey.
He's a fugitive from Broward County being held no bond. And he has a misdemeanor battery domestic violence. He'll go tomorrow on.
Okay. Yeah, I have 2A forms here for him today. In case number F256270, he is alleged to have committed on November 11th of 2024 1 count of aggravated assault with a firearm, and 1 count of written threats to kill or do bodily harm, secondary felony. In case number 256269, he's alleged to have committed on December 30th of 2024 the offenses of aggravated battery on a pregnant woman and aggravated battery on a person 65 years of age or older. The victims in the 6269 case have initials of MP and JJ. And in the 6270 case, victim with initials JJ, date of birth January 12th, 2000. I've appointed the public defender's office to represent him, so let's take a look at the form to determine probable cause and bond.
I don't see any age
I
for
agree.
count 2, and I see no injuries. So it'd be probably cause for battery only.
The part of the 669, I was on the 6270. Okay.
On the 6-9.
Okay. Let me see. Okay. All right, so going back to the 6269, there's a battery on a pregnant woman that is set forth, and there's also another battery, but it doesn't say how old the second victim is. So are we clear that then the first one becomes an F3?
No. It's battery on a pregnant victim is an F2. So it's aggravated because of the victim's death.
Didn't need to be there. Okay. And then the other one is just a simple battery.
Correct.
So on count 1, the bond on that one is 7,500. Count 2,
Sorry, Judge, what case are you doing?
I am doing F25 6269. Battery on a pregnant woman. First count is $7,500 bond. The second count is $1,000. Total bond $8,500 with your stay away order. And he has a Broward County hold, right?
Yes.
In the other case, the F25 6270, that is alleged, that's an aggravated assault with a firearm and written threats to do bodily harm. And I think there's probable cause for both. Both counts. One count is $5,000, the first count, and the second count is $7,500 with a stay away order. Baker? Are you Mr. Baker?
Ma'am.
Yes?
Okay, yes, ma'am.
Good afternoon, sir. All right, you're before the court because it's alleged that March 26th in the area of Palmetto Bay collision located at 17880 South Dixie Highway, you committed the offense of robbery by sudden snatching, grand theft vehicle, and 1 count of aggravated assault with a deadly weapon. Alleged victim being a Young, which is spelled Weihua, Young, Zhang, and yeah, this is at the Palmetto Bay collision. I've appointed the public defender's office to represent you. Let me just take a look at the A form and then address your bond status, sir. Any argument on these?
They charge the grand theft of the motor vehicle as an F1, should be an F3.
Right, there's no value.
It's a really super expensive car. All right, this should be $2,500 each count. Count 1, 2, and 3 with a stay away order. You can't have any contact, direct or indirect, with this victim or go near Palmetto Bay collision. Good luck to you, sir. Chandra Finley.
Judge, Mr. Baker's requesting if you would consider pretrial services for him.
Unfortunately, no, he's got quite a record. This is pretty serious.
He is reset Ward D.
Reset working. Okay. So we normally set it for tomorrow?
Yes.
Okay. Aaron Williams.
Set NBC.
This is a petty theft on more convictions.
Yeah, Ms. Corey, you want to waive it? I'll agree to a lower bond.
It's an added charge for waiver's presence.
Yeah, it was $15.75 worth of stuff from Dollar Tree.
What do you want to do on this?
For $1,000 is fine.
Okay. Ms. Corey, you said you wanted to pass one. Hold on 1 second. I have them circled here.
Yes, Judge. So, Judge, did you set a bond on Mr. Williams? Would you consider $100, Judge?
Which is this one?
On Mr. Williams.
On this one? This is the one from Dollar Tree, $100 bond.
Okay. And then the one we had passed earlier, Judge, Tyler Johnson. He's number 4 on the calendar on page 2. I did hear back from the hospital. They are willing to accept him. So I would ask if we can custody release him to Southern Winds Hospital, set an alternate bond. And if it's okay with you, Judge, I will ask Judge De La O to sign the order for custody release.
That's a secure facility. I passed that down. But you asked us, you had to pass also BOWE on page 8.
That was the one, Judge, where we were supposed to have a PC hearing, but we can take care of it today.
All right, let me address first and foremost so the corrections knows on page 2, Johnson, Tyler Johnson. Okay, this is the one that I had said $2,500 count 1 and $1 count 2. So this is going to be a custody release. State have any objection to this?
No, no
Okay.
objection.
Southern Winds Hospital. And how do you want to word just the order is going to be signed by De La O?
Right. It's a form order, it's fine, but Your Honor needs to set an alternate.
Alternate is the $2,501. I've already.
Count 3?
I'm sorry?
Count 3?
We had a count 3? Oh, there was
Yeah.
no set on that one. $1. Makes it even. Okay, so that's taken care of. The other one is Bo. I have it here, BOWE.
Corrections, were you able to get them?
1 second, no.
Okay.
Page 8. Discussing on this.
So this was the PCH, I'm just agreeing to possession on it.
The first count,
Yep,
what are you gonna do? What do you want to do on the other ones?
ROR,
All right. And take off the calendar the PC hearing for tomorrow?
correct.
Yeah. Judge, you're just gonna set the bonds without the defendant here, correct?
If the defense waives his presence.
We'll waive his presence, Judge. Would you
Alright.
read a pretrial services form, Judge?
He's got a 364 from last year for selling. He's got pages of priors. I think he got enough of a break. State's requesting standard bond in count 1.
Okay, so count 1 is 2,500. Counts 2, 3, and 4 are no PC.
No PC release out, right?
And take it off the calendar for tomorrow. Okay. Got it. Okay, that's it. I hope.
That's it. Thank you, Judge.
Thank
Take
you.
care.
Great job.
Have a good night.
With us tomorrow, Judge?
Nope, I don't know who's gonna be here, but it's not me. Good luck. Bye, and have a good weekend.